breakout rooms. So DeKalb YDC, you're going to get an invitation in a moment to go to a breakout room. If you're able to go there, that will be a private space for Mr. Sharp and his client to talk. And then Mr. Sharp, you can just drop on out when you guys are done. You've got plenty of time.
All right, thank you.
You bet. And they're in. Fantastic. Yeah. I think you're in a safe space. Oh, who's that? Oh, hey, yeah, sorry about that. Oh, sure. I thought you wanted the house lights on. You can have that too. Well, we need to do that for the day. So, yes, we're all online right now. So you are free, consistent with the deputy's instructions, to move around in the courtroom. All right. Ms. Rivers, are you ready? Okay. Courtroom 3, you guys ready to go?
Ready to go, Your Honor.
Fantastic. Let's go on the record. Mr. Partridge, are you ready?
Yes, Judge.
All right. And is it going to be Ms. Grofsky or Ms. McCauley or Ms. Ocom, who seems to have just joined us, who'll be handling the bond hearing of Mr. Rodriguez?
Judge, it's going to be
Your Honor. It is mine.
Or yeah, it's one of the other two. But may I jump off, Judge? May I be excused?
Yes, ma'am. Appreciate you joining us.
Absolutely, sir. Thank you. Have a great one.
You too.
Also be excused.
Sure.
This is all Miss Ocom. She was exactly where we thought she was. She was in Judge Krause's courtroom, so totally fine.
All right. We'll blame Judge Krause. I'm glad she freed you up. Ms. Ocom, you ready to go?
Yes, Your Honor.
Great. Well, let's get on the record then. Mr. Rodriguez, before we get on the record, Mr. Partridge told me you do not need an interpreter. Is that correct?
Correct, sir.
Okay, super. This is 20 CP 196190, State versus Luis Manuel Rodriguez. Mr. Rodriguez, you are charged with murder and drug offense. You have not been indicted. You've been in jail for over 130 days, and you do not have a bond. Mr. Partridge has filed a motion to have a bond set for you. That's what we're going to consider this morning. I'll let you know, unless something strange comes up that I feel like I need more info on, I'll let you know when we're done with the hearing if I'm going to set bond for you or not. My role in your case is only bond. If and when your case is indicted, it will be randomly assigned to one of 15 different judges. That could be me, it may not, but I'm right now connected to your case only for this question of bond. Mr. Partridge, why don't you get us started, please?
Yes, sir. Thank you, Your Honor. Good morning. Judge, this is a matter, as the court just laid out, 2 counts where my client is charged with a drug offense as well as murder. This stems from a June 25th incident, Judge, where a young man was killed in the Venetian Hills neighborhood in Atlanta. Judge, this is a situation whereby the vehicle that was identified in that incident was a vehicle that was rented by my client and was loaned to a friend. Basically, my client was renting the car for a friend and allowed the friend to drive it. And the friend had the vehicle until about 4 a.m. on June 25th when he brought it back to my client. My client then returned it to Enterprise later in the morning. About 2 to 3 days later, Judge, Enterprise contacted my client about damage to the vehicle, alleged gunshots into the vehicle in the rear near the tail light, where my client was just made aware of it, had no knowledge of that at all, Judge, but nonetheless, the damage was outstanding. The client didn't think much about it after the fact. because him and his family were being evicted from their apartment in Cobb County. A little bit later, Judge, into July in the summer, my client moved to Miami. He picked his family up, moved to Miami. His family consists of his wife and his 2 children. They moved to Miami where my client was working at the tavern up until his arrest in December. My client, again, as the court has stated, has been in custody since December the 12th of 2020, where he's not had a bond. My client had no idea about any warrants or anything with regard to this car being involved in this incident. My client did circle back to those friends to see what happened as it relates to the damage of the vehicle, but otherwise did not have any knowledge as it relates to any involvement or his alleged involvement with any incident. Judge, if the court would consider the Ayala factors as it relates to my client, he's not likely to reoffend, starting there first. He has a felony on he was arrested and was sentenced under first offender for a felony. However, he successfully completed it, Judge. Outside of that, Judge, he has absolutely nothing else on his record. He's not a threat to the public. Again, he technically does not have a criminal history. This was a boneheaded decision to rent a car, albeit to obtain extra money or whatever the reason he did it for, but to rent a car for someone else to have them drive the car, Judge. But outside of that, my client had nothing to do with the situation. So we do not believe he's a threat to the public. He's not a threat to any witnesses or victims. He's not aware of what happened and what went on, Judge. So this is something that completely blindsided him when he was arrested in December. Judge, with regard to being a flight risk, I know that I laid out that my client is he moved his family to Miami. However, Judge, with regard to this situation, my client does understand that there's a high likelihood, if granted bond, the court will not allow him to move back to Florida. So with that being said, Judge, he does have temporary residence until this case is resolved in Georgia. It would be outside of Fulton County. And I apologize, Madam Court Reporter, if I'm talking too fast. It would be outside of Fulton County. He would go live in Dublin, Georgia, with his girlfriend, who he's estranged from his wife at this point, but he lived with his girlfriend and her family in Dublin, Georgia, Judge, at 611 Caitlin Court down in Dublin. Outside of that, Judge, my client was putting the pieces back together in Miami. Again, as the court has heard, he does have 2 children. He was working as a chef, as a manager in a restaurant, the Tavern in Miami on South Beach. Again, his mother is in Miami along with his brother and the rest of his family, Judge. His girlfriends and her parents are in Dublin, where my client will stay. Again, Judge, he's been in custody without a bond for almost 5 months, almost 5 months. And we're just asking the court to set a bond. What we're asking for, Judge, as it relates to bond, is for count 1, murder, $50,000. For the other count, the drug offense, $5,000. For a total bond of $55,000. We'd be asking for a surety bond or a good bond. Mr. Rodriguez is willing to submit to an ankle monitor as a curfew. This way, the court will know all of his whereabouts when he's in Dublin, if the court would allow him to be released and he ultimately makes bond to do so. We're asking for a curfew of 8 p.m. to 8 a.m. With the exception of work, if my client is able to find a job, medical, legal, and of course, any emergencies that he may have. If the court sees fit to have my client check in with regard to pretrial services, he's willing to submit to that as well, Judge. Again, just to make sure the court knows where he's at all times. And if the court would allow him to move back to Miami, he is able to return back to his job and would be okay with any other special conditions that the court sees fit to set in this situation. Thank you, Your Honor.
Thank you. So Mr. Rodriguez is no longer living, well, he's at jail right now, but if he were released, he would not return to his wife and kids. He'd be with a girlfriend in Dublin and hopefully find work down there.
Yes, Judge, he does have the opportunity to go back to Miami where he would be closer to his kids, to reside either with his wife if the court prefers him to be there, or it more than likely will be with his mother judge, who's there as well, but would have a job and he would be working in Miami if allowed to return there. That job is waiting for him if he's released. If the court is not comfortable with him going back to Florida, judge, we do have Georgia residency established if he needs to remain in the state.
Got it. Okay. Ms. Ocom, good morning.
Good morning, Your Honor.
So I'd like to hear from you, and in particular, just in looking at the warrant for Mr. Rodriguez, I noticed that there are purported co-conspirators, a Mr. Corbin and a Mr. Fleming. So hopefully you can shed some light, because Mr. Partridge's version of events is that Mr. Rodriguez lent his car to the wrong guys at the wrong time, and a big marijuana deal went bad.
Your Honor, that's not the state's position. The state's position, from the information I have as of now, is that the defendant was actually present at the drug deal. It was a drug deal with his co-defendants, Mr. Cobbing and another defendant, I apologize, Your Honor.
Fleming.
Mr. Fleming. They went to the drug deal. The defendant was actually the driver of the BMW. Mr. Fleming and Mr. Cobbing got out of the vehicle and shot the victim, Mr. Emmanuel. Mr. Cobbing and Mr. Emmanuel fled, and then the defendant also fled in the vehicle in the same direction as his co-conspirators. He was tracked by Google Maps and his cell phone records to show that the defendant was actually present at the scene of the murder.
Hold on one sec. You're going to need to slow down. Your connection.
Apologize.
It's okay. Your connection is a little choppy, and it's hard for the court reporter to follow you. So you said something about people being tracked with cell phones, and I'm interested in hearing that. In particular, if what you're saying is a cell phone that you contend is connected to Mr. Rodriguez, as opposed to Mr. Corbin or Mr. Fleming, was tracked leaving the scene.
Yes, Your Honor. From the information I have as of now, as Your Honor understands, the detective tracked Google Maps and location-based information. He got search warrants from Google and T-Mobile. And from that information, he was able to map that the defendant, Mr. Rodriguez, was also present at the scene of the murder at the time of the murder. Investigator McClaw is the one that provided that information through his supplemental incident report. The defendant's he rented the BMW, he was the driver of the BMW, and he was present at the time of the murder, is the state's position. So this is not, I rented a car to my friends and I don't know what they did. The state's position is that he was part of the drug deal, he was present at the drug deal, and he was present at the scene when the murder happened. The state's position is also that the defendant lives in Miami, so he's not, based on the other factors, he doesn't have strong ties to Georgia. I understand the defense is saying that he has a girlfriend, but the fact is that he moved to Miami with his wife and his kids. And he was there before he was arrested and brought back here. So I do believe that he doesn't have significant ties to Georgia as his attorney has stated, that he lives in Miami with his family and he purportedly has a job over there. The state also agrees that the defendant has no prior felony arrest because his felony, he did get the first offender program, and he's completed that. But the state would also note that he had been arrested 8 prior times before this, so he has a likelihood to reoffend. Yes, he doesn't have any felonies, but he has been arrested 8 prior times before this murder. For all of those reasons, Judge, Your Honor, the state is objecting to him getting a bond.
Okay, thank you. Mr. Partridge, I'll let you have final word since you're the movant, but let me start with a question. As is often the case in these pre-indictment postures that we find ourselves in, is it safe to assume that some of the information that Ms. Ocom was referring to we don't have yet, because obviously discovery hasn't started to flow between state and defense attorney?
Yes, Your Honor, that would be accurate.
Okay, all right. Given that, tell me if there's anything else you'd like to share.
Judge, just the opportunity for Mr. Rodriguez to get a bond, Judge. Again, there's the one felony matter that is on his record with regard to anything being close to adjudicated and him completing first offender, Judge. I think the purpose of bond is to ensure that the defendant will come back to court. I believe he's shown that sufficiently through completing first offender, which is a tough task. In addition to that, Judge, I understand the state is stating that my client has been arrested 8 additional times prior to this incident. However, that could be anything that he has been arrested on. And moreover, Judge, I think what's important is that he's not been convicted, or those cases have not been adjudicated at this point. So it is not a true indicator that he would be likely to offend at all. And Judge, with the ankle monitor, as well as having in-state residency and being on a curfew and being subjected to checking in with pretrial if necessary, I believe it would be sufficient for the court to know exactly where my client would be. And he understands that if the court does place the condition on him that he has to remain at the Dublin address, if he's granted bond today, my client knows that if he violates that and goes back to Florida at all or does anything different without the court's permission, he'll be revoked and he'll be sitting until this case is resolved. So we're just asking for the opportunity for Mr. Rodriguez to show and prove, Judge, and to try to get back out and grab a job and help support his kids up until the time that this case is brought to trial and resolved one way or the other.
Got it. Okay. So what I'm going to do right now is deny the motion, and here's why, but hear me out. I'm also going to ask the state to get you some information, Mr. Partridge. I've got 2 concerns. One is Mr. Rodriguez's lack of connections to Georgia, but in particular the Fulton County area. And I appreciate the work you've done, Mr. Partridge, to find a Georgia-based location, Dublin. It's not quite in Metro Atlanta, but at least it's in the state of Georgia. And so in theory, it's easier to get Mr. Rodriguez to court from Dublin, Georgia than Miami, Florida. But there is a center of gravity about 800 miles south of here with family and kids. And that's a port city. And it makes me a little nervous that Mr. Rodriguez has all those things tugging him in that direction. Ankle monitors are useful as long as they stay on. I have a hearing later today where I get to see someone who's been gone for 4 years after he cut off his ankle monitor in the middle of his murder trial and disappeared. But fortunately, law enforcement caught up with him. So he and I will chat about how his last 4 years went, but it has caused me to not put a whole lot of faith in the notion of an ankle monitor, especially if you start in Dublin, because by the time we could dispatch someone to say, wait, the ankle monitor alarm just went off because it was snipped, who knows where someone would be. That being said, right now, Mr. Partridge, you don't have any information to suggest anything other than Mr. Rodriguez loaned his rental car to, I assume it's Corbin and Fleming. Ms. Ocom seems to have a whole bunch more information. And so I'm going to direct her to get to you within 2 weeks of today. That cell phone information she was talking about. It's clearly discoverable. It will get to you anyway when the state indicts this. And if you should look through that and discern that, wait a minute, that's actually Corbin's phone or Fleming's phone, and there's some misapprehension on the state side about your client's connection to the murder and the vehicle and all that, then I invite you to reach out to Ms. Nelson and say, we need to have another hearing because it's not quite like what the state shared with you. But based on this, the outline that I've received from the 2 sides and the conflicting nature of that outline, Mr. Rodriguez's lack of ties to Atlanta and Georgia in general, at this point, I am not going to set a bond. I am not troubled by the arrests. I hear you, Mr. Partridge. Arrests could be anything. And the one conviction is not a conviction. It was first offender. So that's not weighing on me. There are things to consider, but the things that weigh the most are what Ms. Ocom had to say about Mr. Rodriguez's connection to it. And even more so, the concern I have about ensuring that Mr. Rodriguez would show up in court in Atlanta, Georgia, when we have court in Atlanta, Georgia. So one or two things. If too many days go by and your client's not indicted, we need to talk again because it's time to make sure things move along. But number two, if either you don't get that discovery in 2 weeks or you get it and you look at it and you have a very different interpretation of it, then let's talk again. Okay?
Yes, Judge. Thank you so much, Your Honor. I understand loud and clear. I'll message Ms. Ocom by email.
Ms. Ocom, any questions about that? You're on mute.
I apologize. I will try to get that information. I would just need to get Mr. Partridge's information so I make sure.
Okay, yeah, don't try, do. We got an outreach recently from Mr. Moniz in the newborn case, and he's saying he still hasn't received from you the discovery that I asked you or directed you to share with him. Let's not add this case to that list. So
I understand, Your Honor, but Mr. Newborn, I did speak to him.
okay, different case. All I'm saying is,
the information.
don't try. Do get that material to Mr. Partridge. He will not be hard to find. I'm confident.
Your Honor, man.
All right, yes, sir, Mr. Rodriguez.
I'm saying, like with the phone situation, I have two phones. I was only had the phone in the car to track.
Okay, hey, you do not want to talk about that right now. You're going to want to talk about that with Mr. Partridge. And like I said, we'll reconvene. But you two talk about that. And if we need to reconvene, we'll do that. All right? Thank you.
Mr. Rodriguez, hang tight. We'll talk.
All right, let's move on to Mr. Harris, please.
Good morning, Your Honor. I'm back.
Hey, how are you?
I'm fine. How are you this morning?
I'm doing well. Very different setting.
Yeah. Yeah, my son had a final today and left his notes sitting on the counter. So I had to dash to get him to him so he could take his final.
You're a good dad.
Yeah. Thanks, Judge. Here we go.
I'm just calling up the case on Odyssey. There it is. And there is Mr. Harris. Good morning, Mr. Harris. Can you hear me?
Yes, sir. I can hear you, sir.
I'm Judge McBurney. I don't think we've met before. I am handling bond in your case. And we're going to go on the record now. This is 21 CP 196699. You're charged with murder. And according to my calendar, you've been in jail now for about 4 months. You do not have a bond. And Mr. Richardson, your lawyer, who is on the screen there, has filed a motion for bond. So we're going to talk about that. That's all we're working through today. And that's my only connection to the case. If the state ends up indicting you, that may be assigned to me, but it will likely go to a different judge because there are 15 of us and it's randomly assigned. So
You said I have been indicted, sir?
If you are indicted, when you are indicted, it will be randomly assigned to one of 15 different judges. I'm one of those judges. So we may not see each other again after today is all I'm saying. I've got your case for bond. If it ends up being assigned to me, if you're indicted, that's just a coincidence, okay?
I understand, sir.
Great. Mr. Richardson, tell me about your client and why he should get a bond.
Well, Judge, first of all, he has been in custody, served with this warrant on January 11th of 2021. So as of today, he has been in jail for 4 months. He's charged with a single count of murder under this CP number. Judge, my client is a lifelong resident of the Metro Atlanta area. He attended Southside High School in Atlanta, graduated early, but was an all-county basketball player. Ultimately was awarded a scholarship to Fort Valley State University on a basketball scholarship. He is, like I said, a lifelong resident. He has a daughter who resides here. She's a school teacher with a master's degree at the International School over near Capitol Homes. He has 2 grandchildren. His paternal grandparents are both alive and who reside here in Atlanta. His maternal grandmother is alive here in Atlanta. His mother recently passed, but she was a lifelong resident of the Metro Atlanta area. Her name was Betsy Eli, and I believe she worked for the county for numerous years. Let's see. Judge, he has 5 siblings, all who reside here in the metropolitan Atlanta area. As I indicated, he has a daughter and 2 grandchildren. So when I take this in aggregate, Judge, he has 1 living parent, his father, who lives here. He has 3 grandparents who are alive, live in the metro Atlanta area. He has, 8 aunts, 5 siblings, 1 daughter, and 2 grandchildren. So I'd say that to say that he has substantial ties to this community in terms of satisfying the Ayala criteria. in terms of ties to this community. Judge, he's employed or was employed with 1K Nation Auto Sales, which is a privately owned auto dealership on 3013 Rainbow Drive in Decatur, Georgia. He has been employed there for a few years. He's a member of Atlanta International Christians Praise Center, which is at 3480 Greenbrier Parkway. His pastor is Bishop Richard B. Langford, I guess the former sheriff. Judge, this case, as I understand it, derives from an events that alleged to have occurred in 2008, I guess is my information. I'm sorry, maybe 18. So it's not a new situation. It's something that I think through some type of forensics, they were able to try and connect Mr. Harris to this case. He, let's see, does have a felony conviction, but it's been several years ago. There has been no,
You still there?
I'm sorry, Judge, I got my notes turned around here. Well, Judge, I guess let me go back to my Ayala factor. So I think that he has substantial ties to the community. Judge, there's no indication that he is a risk to the community or a threat or witness, a risk of intimidating witness or otherwise an obstruction in the administration of justice. He's not a flight risk, certainly with his ties to the community. He doesn't own a passport. If he did, I would have him as a condition of bond or make a condition of bond that he surrender his passport. Defendant did not attempt to evade officers when they arrested him or cause any type of difficulty to them. Judge, I think he meets the basic criteria for Ayala. He has been in jail for, like I said, 120 days. The state has been aware that he's been there for 120 days. So I'd ask the court to set a reasonable bond in amount of $50,000, total good bond, with the condition that he not possess firearms, that he not make contact with any of the witnesses associated with this case, and that he maintain an address. And I've been told that he will live with his daughter in Atlanta over in the southwest quadrant off of Hampshire Walk Drive, which is not very far. In fact, walking distance from the courthouse. That's all I have, Your Honor.
Okay, thank you. Ms. Ocam?
Thank you, Your Honor. The state's position is that the defendant should be held with no bond. The state's position is that the defendant is an extreme danger to society. I believe the defendant has two open cases. One is 19 SC 172-318, and the allegations of that is that the defendant shot twice at the victim and took the victim's jewelry and robbed him. So that's the first shooting. He also has an open case. I know it's unindicted, but it's 21 CP 196617. Again, the defendant is alleged to have shot at the victim because he believed that the victim was talking bad about him.
All right, so I need you to give me the 19 SC number again, please.
19 SC 172-318.
318. And then there is a different 21 CP. We're here on a 21 CP, but Mr. Harris has yet another one.
Yes, Your Honor.
Okay, and that number is
21 CP 196617.
wow, it's not far apart from this one. Okay, got it.
Yes, and all of those two allege that the defendant actually shot. So it's not that he pointed the weapon; he actually used the weapon. And then this 2019 case, it's actually March 26th of 2019. The defendant shot at the victim because the victim and him had an argument over a parking spot. The victim in this case, the defendant shot.
Hold on one second. Can you stop for a second, Ms. Ocam? Yeah, can we get that screen? That screen should be able to show what's going on, the one right in front of you. Let me see if I can. Well, okay, but it may take just 2 seconds. Let me see if I can. Which one would that be? The one on her desk. It's not waiting, witness, podium. You think it's gallery? I'm looking at, there's lit manager. Is it lit manager? No, there's nothing for it. It says witness? Thank you. It says it's in a meeting. I wonder, well, we'll work on that. Yes, Ms. Rivers, if you want to move somewhere else, we'll see if we can get IT down here to get that one talking. So I'm looking at the names of the machines and is that one on? Okay, all right. Sure. It should now have asked you to start the video. Did something come up? No, so that shows your camera is showing, we could see Ms. Rivers, but it's not on her screen. So that's why I had turned yours on. All right, sorry about that, Ms. O'Connor. If you could slow down a little bit, we're gonna pick up where you left off. So
Thank you, Your
Mr.
Honor.
Harris has some other open cases. One's been indicted. It's a Judge Edwards case. It's an armed robbery case where he's in no bond status. And then there's another 21 CP that ends in 617.
Yes, Your Honor.
Okay.
Yes, I did misspeak. I said it was about a parking spot. It was more of, it's about parking, but it's not a parking spot. The victim at the time told the defendant that he should be careful when he was driving out.
Slow down. Slow down,
Sorry,
please.
Your Honor.
Okay.
The victim at the time told the defendant to be careful and not to hit his car. And then the defendant shot at the victim 4 times. The victim was hit. He didn't die at the time, but he became a quadriplegic and eventually succumbed to his injuries. And that is why it is now being charged as a murder, even though it happened in 2019. It took a while. The victim died in 2020. The defendant was tracked because he had used the same weapon to shoot the other 2 prior victims, as I had said. He used it in the shooting in the case ending in 318 and in the shooting in 617. And that's how he was tracked by ballistics, because it was the same gun in all 3 shootings. This defendant also has a lengthy criminal history. He has a possession of a firearm during the commission of a felony in Fulton County under 01SC07947. He has possession of drugs by an inmate, 03SC05648. Possession of marijuana with intent to distribute, 04SC24121. Possession of cocaine, 05SC27772. He also has a robbery in Fulton County where he served 12 years, 05SC27774. He has an escape from Clayton County, 2013 CR 02266. Is currently on probation in Cobb County for possession of cocaine with intent to distribute, 179033321. The state's position is based on the seriousness of these crimes, based on the Ayala factors. He is a danger to the community. He gets weapons and he shoots at people. He has 3 open cases now for shooting at 3 different people, which in this case, the victim is dead, but the other 2 people did not die. Based on all of this and the Ayala factors, the state objects and then it should be held without bond pending the the conclusion of this case, Your Honor. Thank you.
Thank you, Ms. Ocom. Mr. Richardson,
Yes,
anything you want to say in closing?
I do, Judge. I won't attempt to lecture the court, but I will cite Vanderford versus Brand and Stack versus Boyd. And Vanderford versus Brand is kind of our landmark case, if you will, for Georgia. And it says basically that the presumption of innocence has always remained with the person accused of a capital offense, even during the trial, and that a person should not be punished based on allegation. The court has information that Judge Belinda, there was a case that was indicated being armed robbery being held without bond. Judge, I actually did that case. He has a $25,000 good bond in that case that was set by Judge Russell. I guess the new judge took over the case. What occurred on that judge is that he posted bond in Fulton County, a $25,000 good bond, and he was arrested by another agency. When the court date came, he was unable to appear because he was in custody at the time. He ultimately was granted bond. I think it may have been Cobb County. So he was released on that case. Judge, the background of that information is that the alleged victim in the alleged armed robbery and aggravated assault in that case was subpoenaed by the district attorney's office and instructed to be in the court on not only one occasion, but two occasions. The victim didn't show up. Judge Russell had a bond hearing, a complete hearing, listened to the evidence, listened to the allegation, listened who the alleged victim was, who probably didn't show up because he's wanted for murder and home invasion in Gwinnett County. We're probably not going to ever find him. But so the judge granted him a good bond on that case. The aggravated assault with the alleged gun, a young man came into my office and I didn't want to really get into the facts of it, but since the state presents them, came into my office and signed an affidavit. I didn't subpoena him, didn't contact him. In fact, he contacted me and said, I heard that Lorenzo was arrested and charged with shooting at me. He's not the person. I told the officers as much. They've come back to me numerous times, kind of heavy-handed. Here's my affidavit. I'm not sure where it goes, but I have that, and I certainly can present that to the court and to the state. And I thought at an appropriate time when we were trying the cases, we would address that. So that is the aggravated assault case. Now, the way he ends up charged with this murder case is because I think the ballistics in the alleged shooting of that young man matched the ballistics in this case. And that's why the CP numbers, I think, are almost consecutive. While he's in custody on the aggravated assault, officers show up at the Fulton County Jail and serve him with a subsequent warrant for this murder case. So that's how he ends up in that case, Judge. I heard the state mention that he had offenses in 01, 03, 04, 05. So most of those are what, 15, 16 years old. And they had a 2017 case. I couldn't remember exactly what it was. Judge, he's always appeared in court. When he was ordered to appear in court, he is not intimidating or attempted to intimidate or threaten any of the witnesses in these alleged cases. And for him to be held is contrary to what Vanderford says and what Stack versus Boyd, which is the United States Supreme Court case, 342 U.S. A 1951 case, but it still gives laws. It said the most fundamental premise of our criminal justice system is that a person ought not be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt. And then it cites the ABA rules. Well, the state has had the armed robbery case for 2 years, well before COVID came. They could have indicted the case, presented the case, tried the case. They couldn't, so now they get a chance to hold it over his head against him, so he's being punished for a case that I don't believe the state can prove. The state has also known since January 11th of 2021 that he's been held in Fulton County on a capital case, a murder case, the most serious case we have. They've indicted theft by receiving, they've indicted burglary cases. You have a person who is potentially facing a life sentence or more if they elected to, and they have not chosen to indict his case now for 120 days. Now they ask the court, well, let's continue to punish him without some form of adjudication. These cases, to me, should have jumped to the forefront when the grand jury was open. They knew he was sitting there. He's been sitting there for 4 months. They have indicted it. They haven't given the court a window of time when it's going to be indicted. We could lose witnesses. We can lose victims. We still don't know. They say, well, this young man was shot and he succumbed to his illnesses or his injuries 2 or 3 years later. Well, we don't have any medical information to prove that. We don't know if the residents or the doctors are going to be around, et cetera, Judge. So he is effectively being punished contrary to what the law in the state of Georgia says. The state hasn't proven the case, but they want to use that as a reason that he should be held in jail. And they have the power and the authority to indict the case, and we'd be ready to rock and roll. So, Judge, I'd ask the court to grant him a good bond. He has the ties to the community. The court can put him on 24 hours house arrest with ankle monitor that he can defray the cost. He has a place to live. He has employment. So there are a set of circumstances that the court can have him under control and allow him to participate actively in his defense for very serious offenses, Judge. That's all.
All right, thank you. I appreciate that. And you are, of course, correct that Mr. Harris enjoys the presumption of innocence in each of his many, many open cases. And that will stay with him unless and until he enters a guilty plea or a jury finds him guilty. That does not mean that he is entitled to a bond regardless of other information. And given that other information, active probation, indicted for an armed robbery, not just arrested, and 2 open cases involving alleged shootings, I think I would be remiss if I were to conclude anything other than Mr. Harris poses a danger to the community. In terms of witnesses disappearing, somehow Mr. Harris's reputation is such that people walk out of the blue into your office to say, well, now I'm not so interested in being a witness against Mr. Harris. It was the police who made me say it. So you seem to be doing fine, Mr. Richardson, in getting evidence that supports Mr. Harris's case, even while he remains in custody, where he will remain until there are further developments in his various cases, be it the armed robbery currently assigned to Judge Edwards, or these 2 unindicted shootings, one of which has resulted in someone's death. So I do not find that Mr. Harris lacks ties to the community. Unfortunately for him, some of his ties to the community suggest that he is a threat to others. And until more is developed on that front, I think it is safest for him and for all the other folks in his community that he stay in custody. So I am denying the motion for bond. Thank you.
Judge, will the court encourage the district attorney's office to indict his cases so that we're just not kind of lame duck sitting here? We'd like to, I know he's a single defendant. He's perfect for the type of case they're trying to try.
Right. We could go to trial as soon as you would say, Mr. Richardson, let's do this. And I know you're willing to do that. So I will, but I think Madam DA, Ms. Willis, knows full well that all eyes are on her office in terms of moving cases like Mr. Harris's, where a defendant is stuck without a bond and no ability to move forward, even if he's willing. He wants his day in court and he can't get it. We on the court are bound and determined to get those cases tried, but of course they need to be indicted. So Ms. Ocom, add this to the list. I know your team is working hard and we routinely have these conversations, but it would seem, as Mr. Richardson noted, that Mr. Harris would be a prime candidate to get some indictments flowing, given that if both the CP cases are indicted, he'd have 3 capital cases, or at least 2 plus an aggravated assault that would be ripe for trial. And that seems like something that we'd all want to move forward. So I trust Ms. Ocom will pass that along to this new unit that has been stood up to get cases indicted. Thank you.
Thank you, Your Honor. May I be excused?
You may. Appreciate you joining us.
Take care. Thank you. Thank you, Ms. Ocom.
All right. Our final bond hearing is Mr. Caldwell. And let me see if our breakout room, nope, it's closed. Good. Mr. Sharp, are you back with us? You are. There he is.
I am, Judge. I will say that Ms. Singleton asked that I I ask you if we could let someone else go first because she had to go to Judge Carnsell. She's going back and forth. So I'm prepared to go, but forward right now, but Ms. Singleton did ask me if we could just have a couple minutes because she has information she wants to share on this case.
That's fine as long as it is okay with the folks in DeKalb. Are you okay in DeKalb if we keep you on hold a little bit longer?
Yes, sir, that's fine.
Okay, thank you for your patience.
If that's the case, may I go check in with Judge Krause and come back then?
Yeah, you can blame me. Thank you.
Thank
Don't be
you.
gone long.
Yes, Your Honor.
So we have at 9:30 a plea. Is our interpreter still here? He stepped away. We can't do the plea right now. That's your case, Mr. White. As soon as we get our interpreter back, we'll do the plea. We've got our final plea calendar, so why don't we pivot to that and see what we're going to do. The folks here.
Your Honor, may I address something before we proceed with that?
Yes, sir.
I realize we're not doing it yet. Your Honor, I am under the weather. I have been since yesterday. It was my intention to visit my client last night at the jail to explain to him what's going on. I could not do that, obviously, so he is pretty much unaware of what's going on. I have spoken to the state extensively, the amount of time he spent in jail and everything else like that. We're just trying to get him out.
Okay.
I also understand he may have an I-247 detainer on him.
Okay. Well, he's here. I assume. Is there a Mr. Vergara Cruz up? Yeah. So he's here, Mr. White. No one's talked to him. Obviously, he's your client. Are you asking that we set this to another day, or what is your preference?
Your Honor, I would proceed to go forward, but like I said, it's the unfortunate circumstance where I'm not sure what he does know and doesn't know.
Right.
I wasn't to visit with him.
Well, I'll tell you what. When the interpreter comes back, I can see if there is a phone number that I could get you for the interpreter. You could talk to the interpreter, so he could talk to your client.
All right, that would fit the bill, Your Honor.
Okay. Otherwise, I'm happy to reset if we need to make this happen on another day.
All right. Thank you, Your Honor.
Okay. Sit tight. Let's turn to the final plea calendar, where we're going to understand if cases are being resolved today or if they should move to a trial calendar. The first position I have is DeMonta Williams. That's Mr. Shepard's client. And is that Mr. Williams? That's Mr. Williams.
As to matter that we are ready to present. I know the co-defendant is number 2. And based on my information, they're also ready to go. We want to do them together.
We need Mr. Balls to do that. Is Mr. Griffin here? Maybe I'm missing Mr. Balls. Oh, he's on the screen. Okay. There he is. Hey, Mr. Balls. How are you doing? Whoa, you're definitely there. Is it your understanding, Mr. Bowles, that there may be a plea in Mr. Griffin's case?
That is my understanding, Judge.
And Mr. Griffin is back in lockup? So it would be efficient, if it is safe and appropriate from the state's perspective, to take the pleas together. Ms. Condrey, does it make more sense to take them separately? Or I'll do it either way. We're here all day.
Yeah, I'm trying to think through that. Please won't be the exact same nature, but I can take it together.
Well, let me ask Mr. Bowles. Do you have a preference, Mr. Bowles? We're going to do Mr. Williams first. He's first on the calendar. Do you think it makes sense just to do Mr. Griffin right after that, or to do it simultaneously with Mr. Williams?
Judge, I don't have a problem with doing them simultaneously.
But it's up to you, and no pressure. If you want to do 2, we can do 2. We'll do them together. Okay. Why don't you come to the witness stand? If Mr. Franklin and Ms. Patel, if you don't mind moving, Mr. Shepard, if you and Mr. Williams, well, I guess you and Mr. Williams will come to the podium, and we'll get, if it's all right with the deputies, we'll get Mr. Griffin seated at the table so he can see Mr. Bowles and Mr. Bowles can see him. And Ms. Rivers, where do you want it? Because it's all in court, do you want to come back here, or are you comfortable being where you are? Wherever you want to be. Ms., I'm going to not pronounce your name correctly. And yes, ma'am. I have signed the paperwork. I appreciate your patience. I'm going to give it to the deputy. He's going to give it to you. Good luck with everything. Are you good? Is that here or it's coming? Okay. Okay. Oh wow, the bonds came in. This is great. Okay. Got it. All right, Ms. Rivers, you ready? We're going to go on the record now. This is indictment 17 SC 156244. And we have two defendants here today. We have Mr. Williams. Good morning, Mr. Williams. Good morning, John. You need to make sure I can hear you. Just make sure you're speaking into the microphone. You're represented by Mr. Shepard. Good morning, Mr. Shepard. Good morning, John. And then we have Mr. Griffin. Good morning, Mr. Griffin. Good morning. Mr. Griffin, your lawyer, Mr. Bowles, is appearing remotely. He just waved. You see him on the screen? Yes. Mr. Griffin, you have a right to have Mr. Bowles here by your side, but you can waive that right and agree to proceed with your plea with Mr. Bowles appearing remotely. Do you waive that right to have Mr. Bowles here in court? Yes. Okay, then we're going to proceed. If you at any point, Mr. Griffin, have any questions, let me know and we'll figure out a way for you and Mr. Bowles to talk. And the same applies to you, Mr. Williams. If we start talking about things that aren't going the way you thought they were, or they don't make sense, let me know, and of course you and Mr. Shepard can talk through that, okay?
Yes, sir.
In a moment, Ms. Convery, the prosecutor, is going to put both Mr. Griffin and Mr. Williams under oath. Once you're under oath, it's important that the two of you answer truthfully and completely all of Ms. Convery's questions and mine. If you can't hear what she says or the question doesn't make sense, let me know and we'll work through that. Please don't answer at the same time. The court reporter has to take down your answers separately. So Ms. Convery will be asking you some of the same questions, but she'll say, Mr. Griffin. Mr. Griffin will say yes or no or 17, whatever the answer is. And then she'll ask those same questions of Mr. Williams. Just make sure you answer separately.
Yes, sir.
Thank you. Ms. Convery.
Sir, if you, both of you, Mr. Williams and Mr. Griffin, please raise your right hand for me, best that you can. Do you swear or affirm the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, nothing but the truth to help you God?
Yes, ma'am. Yes.
Okay, thank you very much. Both lower your hand. Mr. Griffin, please state your true, correct legal name for the record.
Andre Griffin.
And Mr. Williams, please state your true, correct legal name for the record, sir.
Demonte Williams.
Mr. Griffin, how old are you?
28.
How far did you go in school?
10th grade.
Are you able to read, write, and understand the English language?
Yes.
And at this time, are you taking or under the influence of any alcohol, drugs, or prescription medications?
No, ma'am.
Okay. Mr. Williams, how old are you, sir?
23.
How far did you go in school?
All the way. High school. I finished high school.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
And at this time, sir, are you taking or under the influence of any alcohol, drugs, or prescription medications?
No, ma'am.
All right. Do you understand, Mr. Griffin and Mr. Williams, that you're charged in 17 SC 156244 on the original indictment with 11 counts? The 11 counts are 1 count of participation in criminal street gang activity, 4 counts of felony murder, 1 count of armed robbery, 3 counts of aggravated assault with a deadly weapon, 1 count of criminal damage to property in the 1st degree, and 1 count of possession of a firearm during the commission of a felony. Do you understand each of those, Mr. Griffin?
Yes.
Mr. Williams?
Yes, ma'am.
Do you understand, Mr. Griffin and Mr. Williams, that you have the right to either plead guilty or not guilty to the charges that I just read off to you? And if you chose to plead not guilty or to remain silent, you may receive a jury trial. Mr. Griffin?
Yes.
Mr. Williams?
Yes, ma'am.
Have you both had enough time to speak with your attorneys about all the facts and circumstances of the case and the charges that I just read to you, including any and all potential defenses to those charges? Mr. Griffin
Yes.
and Mr. Williams?
Yes, ma'am.
Do Do you need any more time to discuss this case with your attorney, Mr. Griffin?
No.
And are you satisfied with his services?
Yes.
Okay, or do you need any more time to talk about this case with your attorney, Mr. Williams?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Counsel, for Mr. Griffin, do you waive a formal reading of the indictment?
So waived.
And do you waive any and all defects therein?
For the purpose of this plea, so waived.
All right. Mr. Shepherd, as it pertains to Mr. Williams, do you waive any and all, do you waive a formal reading of the indictment?
So waived.
And do you waive any and all defects therein?
Also waived for the purposes of this hearing.
All right, Mr. Griffin, has your attorney advised you of the minimum and maximum for each of the counts in the indictment?
No.
Okay. Has he advised you of the minimum and maximum for the charges that you're actually going to be sentenced to today, or that the state's recommending that you plead to today?
Yes.
Okay. Do you need any more time to talk to him about the ranges of the other charges in the indictment?
That's the range, but you're not.
No.
Okay, and I'll go over those with you in just a moment. And Mr. Williams, have you talked to your attorney about the minimum and maximum sentence for the counts that you're pleading to today?
Yes, ma'am.
And just so the court knows, the state's going to be making a recommendation on Mr. Griffin and Mr. Williams for the following reduction or recommendation. So it's a guilty plea to count 1, participation in criminal street gang activity, and count 11, possession of a firearm during the commission of the felony. The remaining counts 2 through 10 will be null pros.
So for both defendants, 1 and 11, and for both defendants, 2 through 10, null pros.
Correct. And the
Okay.
state has a different sentencing recommendation, but those are the two
Okay.
counts for both of the defendants. And so for count 1, Mr. Griffin, do you understand that the minimum is 5 years to serve and the maximum is 20 years to serve? That's for participation in criminal street gang activity.
Yes.
Okay, and for possession of a firearm during the commission of a felony, that's a 5-year sentence to run consecutive to the court sentence on whatever other count you're sentenced on. Do you understand that?
Yes.
Mr. Williams, do you understand the same, that sentencing range for participation in criminal street gang activity is 5 to 20, and the sentencing range for possession of a firearm during the commission is 5 years to run consecutive?
Yes, ma'am.
He didn't hear you.
Speak loudly.
Oh, yes, ma'am.
You gotta speak up.
Do you understand, Mr. Griffin, that today's plea is what's called a negotiated guilty plea, which means your attorney and I will make the same recommendation to the court as it pertains to sentencing, but ultimately it's the court that will sentence you anywhere within that range of law that I just outlined for you. Do you understand that?
No.
Okay.
So let me try. For both of you, there's a negotiation, and in a minute, Ms. Convery is going to say the state and Mr. Shepherd recommend that I, the judge, sentence Mr. Williams to X, whatever that is. I'm going to hear about it in a minute. I'm not bound by that. Let's say the recommendation is 5 years probation, and I'm making that up. I don't know what it is. And I hear more about the case and you, and I say, you know what? I think the right sentence for Mr. Williams is 10 years probation. I can do that. That's a legal sentence because you're pleading to something that has a range of 5 to 20 years. So I could give you 10 years probation, or I could say, I think you need to go to prison for 2 years. You have the right to withdraw your plea today and today only if I sentence you more severely than what your attorney negotiated. So if what I hear the negotiation was 5 years probation, and I give you 6 years probation, you'll have a chance to talk with Mr. Shepherd about, I'll go with that. It's not what I asked for, but I'd rather do that than have this case hanging over my head. And Mr. Griffin, same situation for you. I don't know what Mr. Bowles has negotiated with Ms. Convery. I'll listen to it, and I may well follow that sentence, but I'm not required to. The negotiations were between your lawyer and the state. I was not part of them. So I may think that's a very reasonable resolution. I know a little bit about this case. I've taken the plea for your third defendant, Mr. Cannon, so I'm familiar with some of the allegations, but I'm going to hear more about it from Mr. Bowles and from Mr. Shepherd. But the important part for you to know is your negotiations don't guarantee that that's the sentence you get. But if I sentence you more severely or harshly than what your lawyers arranged, you'll have the chance to say, I'm backing out of that. I'd just soon go to trial. You gave me 20 years to serve. You know what? Let's go to trial. Okay? Does that make sense? Does that you follow that, Mr. Williams?
Yes, sir.
Mr. Griffin?
Yes, sir.
All right.
All right, thank you very much. Do you understand, Mr. Griffin, that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions in the future, including federal courts?
Yes.
Do you understand that, Mr. Williams?
Yes, ma'am.
Do you understand, Mr. Griffin, if you are currently on probation or parole, your probation or parole may be revoked based on your entering of this guilty plea today.
Yes.
Do you understand that as well, Mr. Williams?
Yes.
Yes, ma'am.
Okay. Do you understand, Mr. Griffin, that if you are placed on probation of any kind as a result of today's plea, you may not violate, excuse me, any criminal laws of any governmental unit or any special conditions of that probation without then being subject to a revocation for the balance of the sentence? Do you understand that?
Yes.
Do you also understand that, Mr. Williams?
Yes, ma'am.
Mr. Griffin and Mr. Williams, do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Yes.
Do you understand, Mr. Griffin, that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that, Mr. Williams?
Yes, ma'am.
Mr. Williams and Mr. Griffin, do you understand that neither the court, the district attorney's office, the court or the district attorney's office has anything to do with parole, the Department of Corrections or Board of Pardons and Paroles, and no one can guarantee you parole? I don't believe that's applicable in either of these situations, but do you understand that, Mr. Griffin?
Yes.
And do you understand that, Mr. Williams?
Yes, ma'am.
Do you also understand, Mr. Griffin and Mr. Williams, that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following the conviction after a trial? For example, your guilty plea may affect your right to vote, hold public office, serve on a jury, obtain a passport, or the right to receive, possess, or transport a firearm. Mr. Griffin.
Yes.
Mr. Williams.
Yes, ma'am.
All right. Do you understand, Mr. Griffin and Mr. Williams, that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or if you used a firearm in another felony, you would be guilty of a subsequent felony, which will carry a sentence of 1 up to 15 years in prison? Do you understand that, Mr. Griffin?
Yes.
Mr. Williams.
Yes, ma'am.
And Mr. Griffin and Mr. Williams, are you both asking the court, excuse me, to be treated as a first offender?
Yes.
Yes, ma'am.
All right. Have either of you, start with Mr. Griffin, ever pleaded guilty or nolo or been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Mr. Williams.
No, ma'am.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act? Mr. Griffin.
No.
Mr. Williams.
No, ma'am.
Has your lawyer explained the First Offender Act to you? Mr. Griffin.
Yes.
Mr. Williams.
Yes, ma'am.
You understand then, if you violate the terms of your first offender sentence, should the court choose to sentence you that way, or if you commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up until the maximum for each of the charge that you're originally sentenced on. Do you understand that, Mr. Griffin?
Yes.
And Mr. Williams?
Yes, ma'am.
Okay. Do you understand that you will waive any and all defenses, including any mental health defenses, by entering this plea of guilty today, Mr. Griffin?
Yes.
And Mr. Williams?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront the witnesses called by the state to testify against you, and the right to remain silent or not incriminate yourself or testify on your own behalf? Do you understand each of those, Mr. Griffin?
Yes.
And Mr. Williams?
Yes, ma'am.
Do you understand them, that by pleading guilty, you are giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you, and if you could not afford an attorney, the right to a court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved by the state beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that, Mr. Griffin?
Yes.
And Mr. Williams?
Yes, ma'am.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea today, Mr. Griffin?
No.
And Mr. Williams?
No.
Is it your decision to waive the rights that I just outlined to you and enter a guilty plea because you are in fact guilty of the charges that I'm going to present to the court? Will be count 1, participation in criminal street gang activity, and count 11, possession of a firearm during the commission. Mr. Griffin?
My client is going to enter his plea under North Carolina versus Alford because he believes it's in his best interest to do so.
That goes for Mr. Griffin too as well, Judge.
Okay, I guess I'll need to hear, again, I mentioned I'm familiar with some of the facts of this case and the gun deal and bullets flying in every direction. So, but I guess what's being pled to is the street gang. And then to both counts, to the possession of a firearm during commission of a felony is also an Alford plea, or is it to count 1?
It's offered to both. My client never possessed the gun.
Okay, Mr. Balls, is it to both counts or just the street gang count that it would be an offered plea?
Offered to both, Judge.
Okay, well, I will cover that with your clients when it's my turn, and I'll let you know if that works for me.
All right, Mr. Griffin, how then do you plead, understanding that you intend to present an offer plea to the court to the charges of count 1, participation in criminal street gang activity, and count 11, possession of a firearm during the commission of a felony? Guilty or not guilty?
Guilty.
Right, and I understand the court will go over Alfred with you, and your attorney has let the court know you'd like to plead under the Alfred statute. Same question, Mr. Williams. How do you plead to count 1, participation in criminal street gang activity, and count 11, possession of a firearm during the commission?
Offered.
Guilty.
I'm guilty on the offer.
All right, and is that for count 1 and 11?
Say yes.
Yes, ma'am.
Mr. Griffin, is the guilty plea that you just offered to the court freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Mr. Williams, is the guilty plea freely and voluntarily given with full knowledge of all the charges against you?
Yes, ma'am.
Mr. Griffin, do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Mr. Williams, do you understand that as well?
Yes, ma'am.
Mr. Griffin and Mr. Williams, do you understand that you'll have 4 years from today's date to file what's called a habeas petition that would challenge the voluntariness of today's plea? Do you understand that, Mr. Griffin
Yes.
and Mr. Williams?
Yes, ma'am.
All right. Do I need to sign the indictment for the court?
So I can do this now. Mr. Griffin and Mr. Williams and counsel, I have a copy of the indictment. That's what we're working off of right now. Normally, you'd actually be signing some other paperwork as well, an acknowledgement of rights, et cetera. But we try not to pass paper around. And so what I'm proposing is that I will sign for the defendants and the defense attorneys and the prosecutor, indicating the guilty plea to, well, the offered plea to counts 1 and 11. Mr. Griffin, do you authorize me to sign on your behalf?
Yes.
Mr. Bowles, may I sign for you?
Yes, Your Honor.
And Mr. Williams, may I sign the indictment on your behalf?
Yes, Your Honor.
Mr. Shepard?
Yes, Your Honor.
And Ms. Convery?
Yes, Your Honor.
Okay, I will do that. That just makes official on the indictment the offered plea to counts 1 and 11, and the other counts will be null pros. Thank you.
All right, the facts giving rise to the plea that I'm offering to the court occurred on July 2nd, 2017. Should this case have advanced to trial, the state would have been prepared to prove that on that date at approximately 10:40 on that evening, Mr. DeJuan Cannon, Mr. Andre Griffin, Mr. DeMonta Williams, and the victim in this case, Mr. Traviante Daniel, traveled to that location under the guise of a transaction involving a weapon with Mr. Parsons and Mr. Bro. Mr. Parsons and Mr. Bro were actually known by the defendant, Mr. Griffin. They had encountered each other the day before at a gas station, and there was a conversation about an attempt to purchase Bro and Parsons selling, and the other group that I just outlined to the court attempting to purchase a revolver that was discussed at the gas station. So on the next day, which was July 2nd, they arrived to a location which was 1105 Research Center Drive, which is the Walmart parking lot in Fulton County, Georgia, to actually facilitate some part of that transaction. At the location, there were 2 vehicles. So we've got Mr. Bro and Mr. Parsons in the first vehicle, and the other vehicle that arrives has Mr. Cannon, Mr. Griffin, Mr. Williams, and Mr. Daniel inside. When the 2 cars arrive to the location, initially it's Mr. Griffin that approaches the seller vehicle, or Mr. Bro, and that's BREAUX, and Mr. Parsons are seated. Mr. Bro is in the driver's seat of that vehicle, and Mr. Parsons in the front passenger seat. Mr. Griffin gets in the back seat. There's an exchange about the firearm. Firearm is sort of being examined, for lack of a better term. Mr. Griffin, who is in the back seat of the vehicle, requests that he take the gun from the vehicle and be able to show it to his car that he arrived with. Mr. Parson and Mr. Bro decline that attempt and instead suggest that he could have someone come over to the car. Mr. Griffin leaves the vehicle and goes over to the car he originally arrived in, where Mr. Daniel is in the driver's seat of that vehicle. There's a brief conversation at the driver's side window, He eventually opens the door so that Mr. Daniel can get out. There's some sort of a malfunction with the driver's side door, but he opens the door and then the two travel back to the seller vehicle. So now we've got Mr. Griffin and Mr. Daniel in the back seat of the seller vehicle with Mr. Bro and Mr. Parson in the front seat. There's a continued exchange about the firearm, and at some point, Mr. Griffin asks if he's going to be able to fire a live round out of the weapon. At some point during that exchange about getting a bullet for the gun, Mr. Cannon approaches the driver's side window of the vehicle and brandishes a firearm. In the next few seconds, Mr. Griffin and Mr. Daniel are attempting to actually get out of the vehicle. I've spoken with, law enforcement spoke to Mr. Bro and Mr. Parson. I've recently spoken to Mr. Bro, who describes seeing the backseat occupants kind of low to the ground, like trying to get out themselves. In the few seconds that follow, the front seat passenger, who is Mr. Parson, produces a handgun of his own, and in response to the handgun from Mr. Cannon at the driver's side window, starts firing rounds as he leaves the scene on foot. Mr. Bro, who's in the driver's seat of the vehicle, is also able to get off a response round from a .40 caliber weapon and sort of peel off and drive away.
So neither of those guns is the revolver that Mr. Griffin and others were interested in buying.
Right. That weapon is actually subsequently recovered by the South Fulton Police Department, sort of in a flight path for individuals leaving the scene. Mr. Cannon sustains approximately 8 gunshot wounds as the result of his position in the exchange. Mr. Daniel receives 1 gunshot wound to the back and succumbs to his injuries as a result of where he actually received the wound. Mr. Parson is also grazed in the leg, but is able to get to a nearby MARTA bus where he's spotted by individuals on the bus, and APD is contacted and they're able to facilitate getting him to the right place, which eventually is the South Fulton Police Department. The investigation includes an interview of all individuals involved in the transaction, except for Mr. Griffin, who I don't believe is interviewed by law enforcement. He's subsequently identified during this investigation. Our office's investigation includes a review of social media, to include the social media of the defendant, Mr. Williams, who posts just a couple days after the incident, all we were trying to do is get some money. There's some additional remarks in that, but that was a important part of the decision ultimately with who was on the initial indictment in this case. As a result of Mr. Cannon's plea, I've made the reduced recommendation because of individuals' role in the series of facts that I just outlined to the court. It is Mr. Griffin who initially connects the parties, actually gets into the vehicle and sort of prolongs the encounter with the back and forth of the firearm and the parties getting into the back of the vehicle. Mr. Williams does not leave the initial vehicle that arrives there at the location. He never goes to the first car. And so I'm going to make the following recommendation. I'll talk to you just a little bit more about Mr. Griffin and the participation in criminal street gang activity, as well as Mr. Williams. Mr. Griffin, because of our ability to review and pull social media, was easily identifiable as an associate of the criminal street gang, the Gangster Disciples. He has tattoos and social media postings consistent with his affiliation with that organization, to include multiple firearms close in time to the actual incident itself, and a discussion of gang-related affiliation and commitment. There are several captions in the posts themselves that indicate his affiliation with this particular organization, and a replacement of letters and numbers that are consistent with that as well. The criminal street gang, Gangster Disciples, is a national gang that boasts thousands of members, to include here locally in the Atlanta area. And unfortunately, the use of firearms, the participation in armed robberies to get those firearms, and shooting cases are common things that we see as offenses done by associates of this criminal enterprise. Mr. Williams, based on a review of his social media, associates with the criminal street gang Bloods. There's some other associations that include local hybrid subsets, but most consistently is the Bloods. He has had one incident while he was incarcerated that also include gang allegations as well. It is not uncommon, I think I discussed this with the court, for Mr. Cannon's plea. Mr. Cannon was affiliated with the local group ABG, which is also a Blood subset, for groups to work together in order to successfully complete criminal acts. And that's what would be the state's position if we advance forward on the gang count as to what actually happened here. State's recommendation is to sentencing is based on the totality of the evidence. And again, Mr. Cannon accepting responsibility and entering a guilty plea to all of the charges on the indictment. I do want to let the court know that the family of the victim in this case, again, is present. I think I told the court before, they've been here every time. They are not in agreement with the state's recommendation, but do understand, how I've arrived here at this process. I don't know if they want to speak today, but I did want to make sure that you knew that they were here. Both Mr. Daniels' mother and father are present, have been supportive of the prosecution, and have been here for every step of the way and very committed to seeing this through. So the state's recommendation as it pertains to sentencing for Mr. Griffin will be 15 years to serve 3 years, the balance to be served on probation, credit for the time he's already served. Mr. Griffin has served a substantial amount of time in custody, and I believe this sentence is going to complete his time in custody because of the time he's already served. It will be, my recommendation for count 11 will be 5 years to run consecutive suspended. The special conditions I'm recommending for probation will be no affiliation with any criminal street gang, in fact, or through any other method, including social media, that he possess no firearms or replicas of firearms. He have no other violation of the law. And I can't, if he has not, I can't remember what he said about GED, but if he has not completed it, that he do so.
Mr. Griffin got through 10th grade.
Okay. So that would be my recommendation to the court as a special condition of his probation.
Okay.
My recommendation as it pertains to Mr. Williams is 10 years to serve 1 year on count 1, commuted to the time he's already served. I think he served approximately 568 days in custody. That would be the balance of 9 years to serve on probation. My recommendation for the final count, count 11, is 5 years consecutive suspended. The special conditions are the same with the exception of the GED. I believe he said that he successfully finished high school, or that's what he said on during the plea colloquy. So no further criminal street gang affiliation, in fact, or through any other platform, and that he have no firearms or replicas of firearms, and then he, of course, not have any further violations of the law while he's on probation.
So you said 10 to serve 1, reduced to time served, but if Mr. Williams has spent in connection with this case more than 365 days in jail, it can be 10 to serve 1 credit for time served.
Right, and that's probably what I should have
Okay,
said.
and I'll hear from you, Mr. Shepard, but I want to reduce the time served in a shooting case. I'm not a big fan of that, and so I might adjust the time, but I'll work through that.
Yeah,
Okay,
and that's why I recommended 1, because he's done well over that.
sure. Both defendants are asking for a first offender. I don't think one of them is eligible, but I'll work through that with that defendant in a minute. Does the state oppose first offender for either defendant?
No, Your Honor.
Okay. Got it.
I think I usually mention to the court felony criminal history. That was another part of the state's decision in this case. Neither Mr. Williams or Mr. Griffin has a felony criminal history of any kind that the state can find or is aware of.
Okay, we'll see about Mr. Williams, but I'll ask Ms. Crawford about that as well.
News to the state as well, so.
Okay. But before we pivot to Ms. Crawford and then to the defense attorneys, I don't know if the family of Mr. Daniels, if they've got the same last name, but I want to make sure if there's anyone who wants to be heard. No? I appreciate you all being here. Chapter 17 of this case, but there aren't any other defendants. So at least we're moving on. And I appreciate you staying involved with this. And your loss doesn't go away because of this, but at least there's a little more closure. And I wish you all the best with that.
Ms. Butler, I'm sorry, I should have said that.
Ms. Butler,
She
okay.
addressed the court last time as well.
I recognize her. Okay. Slightly different setting than last time as well, based on the facts as we understand them. Ms. Crawford, do you have any felony criminal history for Mr. Griffin?
Good morning, Judge. No criminal history from Ms. Judge. I'm sorry, from Mr. Griffin. Also, after a second check, Mr. Williams doesn't have a history also.
Okay. Oh, look at that. You sent a chat message to that effect. I got word in the middle of the plea that Mr. Williams had taken a first offender plea in 09 SC 77159. And in fact, that case is DeMonta Williams, but Ms. Crawford, being Ms. Crawford, is extra thorough, and it was someone with the same name, but it is
12 years old.
okay. Well,
Only 12-year-olds.
good thing he didn't need to go through it back then, and we're not worried about it because it's someone with the same name, but it's a false alarm.
Thank you.
You bet. Mr. Bowles, anything you want to tell me about Mr. Griffin and this situation?
Yes, Judge. Before he was Mr. Griffin, he's, like he said, he's 28 years of age, Your Honor. And the reason for the Alfred plea, Your Honor, is this. The case against Mr. Griffin and Mr. Williams as well depends on one key issue. And that issue is, were they involved in the transition of the incident from a gun sale to an armed robbery? And pretty much most of everything that Ms. Convery said is true, except that's where we disagree. That's where we part ways. Our contention is that Mr. Griffin was there for a gun sale. And the reason for the Alfred plea, Judge, is because both charges depend on an underlying charge that would only come about if he actually was responsible for an armed robbery. Everything else falls from the armed robbery, including the unfortunate death of Mr. Daniels. So that is why we're entering an Alfred plea, Judge. The fact of the matter is this, like Ms. Convery said, which is true, they will be able to connect Mr. Griffin to gang life. And that is of great concern to me, Your Honor, at a trial. With everything that's going on now, and I have to go in front of a jury and explain why he was connected to a gang, but then at the same time explain, but, you know, it has nothing to do with this incident, which I feel confident I can do, but I'm rolling the dice with Mr. Griffin's life, not mine. So I recommended to him that he take the plea, which I believe outside of that is generous, and we thank Ms. Convery for that. But that is the reason for the Alfred plea, Judge, that it all depends on something where the one key element where we disagree about the armed robbery, we say Mr. Cannon is the one that took it upon himself to do this. And I know he has already resolved his case in front of Your Honor. Other than that, Judge, we agree with what the state said, and we just ask that the court accept the negotiated plea.
Okay, thank you. Mr. Griffin, is there anything you want to add? You have the right to be heard. It is your plea hearing, not someone else's. I mean, it's Mr. Williams's as well. But anything you want to add to what I heard from Mr. Bowles?
No, sir.
Okay. All right, Mr. Shepard.
Good morning, Your Honor. As the state outlined that 4 people in a car go to a Walmart and one of the people in the car is planning to buy a gun. And that's not my client. This was not a group purchase where everybody chipped in. It's not like they were buying, you know, a bag of weed and everybody chipped in $5 and then they were going to share the weed. This gun was going to be purchased for the sole possession of Mr. Daniel with Mr. Daniel's money. And my client had no role in the purchase of the gun. My understanding is Mr. Daniel had no felony convictions and he was perfectly legal. He could buy a gun like any other legal citizen. He can buy a gun. So the gun purchase itself was not illegal. And my client had no involvement in the gun purchase. As Ms. Convery noted, my client never even left the vehicle they arrived in. All of this happens at another vehicle in the parking lot where my client never even goes over there. Now, during this transaction that is believed to have been a legal gun purchase, Mr. Cannon, for whatever reasons, Mr. Cannon, with no forewarning to anybody else, decides to do what he does. My client has no involvement. My client doesn't even know Mr. Cannon. He doesn't know the people in the other car. He doesn't even really know Mr. Griffin. So
what was he doing in the car? He knew Mr. Daniel? Or why is he in the car?
Yes.
Okay.
So he knew Mr. Daniel. In any event, that's why he's in the car, but not anything else. So he basically never has a gun. He's by the car on his phone when all of a sudden he hears gunshots. When he self-surrenders, he tells everything, exactly the same story Ms. Convery just told. And you were on the telephone one day when we were like, we will testify for free. We will just testify and tell everything he knows at the trial of Mr. Cannon and possibly Mr. Giffen, because he didn't do anything wrong. That's why we're pleading under Alford. There's really very skimpy evidence that he's in a gang. He has no gang tattoos. He has no face tattoos. I do understand there is some social media posts that are gang-like in nature, that's just a kid being a kid. That doesn't mean you are a blood. So we disagree with that. We disagree that he was participating in anything gang related, and we disagree that he possessed a firearm because he was never within wingspan of a firearm. All the firearms were in the other car. So in any event, we're entering our plea under Alford. We have the same issues as Mr. Corey Bowles has as to the state's ability to prove their case at trial, but we also don't want my client to possibly go to jail for the rest of his life. And I'm not willing to gamble with his life on a jury trial. So we are asking the court to accept the sentence. And just so you can remember, these are the notes from the bond hearing we had back in 2020. Mr. Williams has been out on bond now for almost a year and a couple months with no hiccups. Nothing has gone wrong. He served about 18 months in jail before I was able to get him out, about 18 months. And that's our concern with the way that we phrase the sentence, because we don't want him to have to go back in and then get an affidavit, custodian's affidavit, and get out. So we're asking the court to make it 10-serve-1, commuted to time already served, which is 18 months, and then balance probated with 5 consecutive suspended. But a little bit about Mr. Williams. I've known him now for almost 3 years, and he actually is not the person who the state thinks he is. He is not that person. He was born on December 22 of 1997. He was 20 years old at the time of the bond hearing, so I guess that would make him like 23 now. So I've known him for a while. At the time of the bond hearing, he had been enrolled in Life Christian Academy, and he was planning to get his high school diploma. He was on track to graduate in May, and he did in fact get out and did in fact graduate, and he does have a high school diploma. So that's one promise he kept to me when he told me he was going to do this. He also has planned to go to a college or a university, but his life has been on hold since 2020. He at the time worked at True Food Kitchen in Buckhead, Lenox Mall. He's been employed the whole time I've known him. He now works at Fast Staff Warehouse on Fulton Industrial. What do you do, if you don't mind just briefly telling the job what you do?
I'm a package handler.
What does that mean?
I unload trucks, or anything on the belt line, I grab and load on the truck.
Okay. At the time, he had no kids. Is that still true?
Correct.
Okay. He has no children. He has strong support from family. The mom's name is Consuelo Williams.
She's not in there. My father's here.
Michael Pass. And I know there are 2 other people. If you could just stand up and briefly say what your relationship is. So he does.
Thank you for being here. Appreciate it.
He does have family support, and I spoke with them in the hallway, and they're going to make sure he completes this probation successfully, as they have made sure he's completed over a year of being out on bond successfully. I know his grandmother is Claudia Williams. I don't think she could be here today, but as probation noticed, he has no prior felony convictions. And I mean, this was a life-changing event for him, because he's simply standing by a car in a parking lot, and all of a sudden these other people get involved in a gun battle that he has no participation in, no foreknowledge, no anything. Obviously, we're not thrilled with the outcome of him having to, do this. But on the other hand, it's a very generous offer from the state. It really is. It's a generous offer that he has to take. And therefore, we're just asking the court to accept the recommended sentence, but modify it so that he doesn't have to go back into custody, get a custodian's affidavit, and then get out. It would simply be 10-serve-1, commuted to time served, balance probated with all the conditions outlined by the state, and then 5 years consecutive suspended. But once again, he never was within, yards and yards and yards of any gun, because he didn't have a gun that day.
All right. Mr. Williams, anything you want to add?
No, Your Honor. Thank you.
Okay.
Judge?
Yes, sir, Mr. Bowles.
Yes, I just wanted to point out, I can't confirm because I haven't seen her face, but I think Mr. Griffin's mom is in the courtroom. Maybe she called me this morning asking for your, asking where you were. So, okay, she is present.
She is here. Thank you. Thank you for flagging that. I appreciate that. And thank you, ma'am, for being here. Okay. Let me cover a couple things with the 2 defendants, and then I will proceed to accept their pleas. First offender. I need you both to listen, then I'll ask you the same questions. First offender is primarily an opportunity. If you successfully complete your sentence, then you won't have anything on your criminal history. It is not a conviction. When you leave here today, you will not have a conviction. You will be under a first offender sentence. So if you're looking for a job, trying to go to school, anything where that box is on there saying, have you been convicted of a felony? The honest and correct answer is no. So check no. That's the benefit of first offender. If you think you can stay out of harm's way, stay away from gun deals that go bad, all that kind of stuff, while you're on probation, you're both going to be on probation for a minute. It's not a short sentence. But if you think you can do it, it's a great deal, because when you're done with your sentence, you're free and clear, no criminal history. The downside of first offender is that if while you're on probation, and it will be a few years that you're on probation, you get wrapped up in something, you get arrested and you get new charges. If I find that the new charges are legit and the state doesn't have to prove it beyond a reasonable doubt, just by a preponderance of the evidence that there are these new charges, you get caught with a gun. You can't have a gun while you're on first offender probation. So it's that simple. If you get pulled over and there's a gun in your waistband, you can get charged for that. Not only can you have your probation revoked, you can have your sentence redone up to the maximum, which for you two is 25 years. So in theory, and I'm not saying this would happen, but if it was something serious enough, and you were caught with guns and there was shooting that went on, I could, without a trial, because you've entered a plea, even though it's an offered plea, resentence you up to 25 years to serve, to the door. You're done. No trial. So that's the risk of first offender. Now, if you're pretty sure you're done with rolling the way you were rolling back in July of 2017, it's a great opportunity. But I need to make sure you both understand the risk that comes with the benefit of first offender. Mr. Williams, do you feel like you understand how first offender works?
Yes, Your Honor, I understand.
And understanding that, do you want to be sentenced as a first offender?
Yes, Your Honor.
Mr. Griffin, do you feel like you understand the risks and the benefit of first offender?
Yes, sir.
And understanding that, do you want to be sentenced as a first offender?
Yes, sir.
Okay. You certainly both qualify, and I'll do that. The other thing I need to let you know about an offered plea, and now that I understand a little bit more about the situation, I'll accept this as an offered plea, is that it doesn't mean that it's not a finding of guilt. It'll say offered plea, but if things go south during your probation and I revoke your probation and take away your first offender status, it's a conviction. And folks aren't going to look at it differently because it was an offered plea. It's not printed in a different color on your criminal history or anything like that. It's a way of a defendant saying, I don't agree with everything the state has charged me with, but I think it's in my best interest to take this deal and get moving on. Does that describe your situation, Mr. Williams?
Yes, Your Honor.
You want to move forward with an offered plea?
Yes, sir.
And Mr. Griffin, does it describe your situation?
Yes, sir.
You want to move forward with an offered plea?
Yes, sir.
Okay. Well, I do find, despite the offered plea, that there's a factual basis for both your pleas to counts 1 and 11. I also find that your pleas are knowing and voluntary. A knowing plea means you've understood what we talked about and you don't have any other questions. Is that correct, Mr. Williams?
Yes, Your Honor.
Mr. Griffin?
Yes, sir.
A voluntary plea is one where no one has forced you into the plea. You may not be real excited about it, but you've decided that this is the way you want to move forward. Is that true for you, Mr. Williams?
Yes, Your Honor.
Mr. Griffin?
Yes, sir.
Then I will accept your pleas. I will sentence both of you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a technical slip up, you miss a meeting, you test positive once for something minor, you don't have to come back in front of me. But if you get arrested for something new, or you run from probation, you don't show up for meetings month after month after month, they'll bring that back to me. And like I mentioned, your whole first offender status is on the line. So you're going to want to do what probation asks you to do. All right. Mr. Griffin, I'm going to sentence you on count 1 to 13 years to serve 3 years. You'll get credit for the time you've been in, and the balance will be probated. Count 11 will be 5 years suspended. So I'm changing the sentence a little bit. I think 10 years probation is a mountain of probation. If things aren't going to go well for Mr. Griffin, we're going to know that in 2 years. We're not going to know that in 9 years. And I want you to get off probation if you're doing well. If you're working, if you're taking care of your family, whatever you need to do, then let's let you be a productive member of our community. So I'm modifying it slightly, but in a direction that's favorable to you. I don't think the state's recommendation was unreasonable. You spent a ton of time in jail already, but it will be 13 to serve 3, balance probated, plus 5 years suspended. Special condition of probation number 1, no involvement with gangs. Nothing online, nothing in person, no new tattoos. So if some officer who's doing gang research sees you doing something with social media, flashing signs with guns or this or that, first of all, you can't have guns because you're going to be on probation. But second, it's a condition of your probation that you're not mixing it up in a way it is alleged you used to mix it up. You'll also need to get your GED or a high school diploma. However you want to do that, get that credential. It'll help you move forward. Mr. Bowles, any questions or concerns about that sentence for Mr. Griffin?
No, Your Honor.
All right. Mr. Williams, your sentence as to count 1 will be 10 years to serve 1 year with the balance probated, and count 11 will be 5 years suspended running consecutively. So you're going to have 9 years probation. I will determine after some outreach to the sheriff's office if I can simply say 10 years to serve 1, credit for time served, or if I need to structure it the way Mr. Shepard asked. I do not intend for you to go back into custody. So you will not go back into custody on this case, unless, of course, you violate your probation. You'll be on probation for a while as well. Your 2 special conditions are no involvement with gangs in any way, and obviously don't be around guns, but that's also a condition of the law while you're a first offender probationer, no guns. Mr. Shepard, any questions about Mr. Williams' sentence?
No, Your Honor.
Ms. Convery, anything else on behalf of the state in Mr. Griffin's case or Mr. Williams' case?
No, Your Honor.
Thank you for managing these together. That was more efficient. Mr. Bowles, thank you for dialing in. Mr. Shepard, I will see you this afternoon.
Yes, you will.
Good.
Yes, you will.
Hold on 1 second. Oh, do Parsons and Blow want a no contact?
Probably so, and I should have mentioned.
Yeah,
that.
so we did that with Mr. Cannon. So, and that may apply more to Mr. Griffin because he supposedly had bumped into these guys before, but it's a condition for both of you on probation. No contact at all with Mr. Bro or Mr. Parsons. Those would be the 2 gentlemen that you may never have seen. They were in the other car. You saw at least one of them, Mr. Griffin. No contact with either of those guys. They want to go their way and want you 2 to go your way. Okay? All right. Thank you, everyone.
Is it 1:30 today?
It is 1:30 today. It may get a slightly late start because of something that happened yesterday, but we will get started as soon as we can. And I'll tell you how we're starting. You're going to tell me from this giant stack what motions really need to go forward and what were placeholders because you wanted to protect your client's interests.
Yes, I've already spoken with Ms. Hall
Great.
about some of that.
So it's streamlined.
Suggested that maybe she could come up with an offer and.
Great. She's had some time this morning.
Yeah, that's what I asked her to do this morning, motions don't close cases. So thank you, I'll see y'all at 1:30.
You bet.
So we got to cover back for Mr. Griffin's case.
Let's do it. We've had Mr. Elias here for a while.
He did try to reach out to Mr. White and answer his phone. So we just need them in contact so they can talk to the defendant.
Okay, sure. Let's do that. Mr. White?
Yes, Your Honor.
Is there a good phone number that Mr. Lares, the interpreter, could reach you at so that you could talk with him and then he could speak with your client?
Yes, Your Honor. 770 572 3102.
Did you get that, Mr. Lares?
I did, yes. I called that number, left a message.
Oh, you called that number already?
Did about a half an hour ago with the
I'm
DA.
on my phone right now, Your Honor, for the virtual, so I did not answer the phone.
Oh,
okay. Why don't you drop off and Mr. Lares will call you and you can dial back in. That's how we'll know that everyone's ready to go, okay?
All right, thank you, Your Honor.
Sure. Thank you, Mr. Laris.
I guess I will do it in the back.
So you're gonna call him, the way, what we talked about is that you'll talk with Mr. White. He's gonna tell you what's going on. He meant to visit his client last night, but was unable to do so. So he's gonna give you an update, and then if you could share that with his client, then we'll be good to go.
Okay, Judge. That's fine.
Thank you.
So I gotta talk to the lawyer first.
Investigator Pope, I'm almost done. I got one of them. It's good to go. I'll swear you in. I just need to get through the other one. Ms. Convery here, I mean, she wouldn't stop talking. I can't deal with her applications. Okay, Mr. Shart. Are we in a position to do Mr. Caldwell now?
We are. I see DeKalb there, and I see Miss.
Yep, DeKalb is there. Ms. Singleton is there. We need Ms. Ocom. She's back. So why don't we do Mr. Caldwell? Let's see if we can get everyone. Ms. Ocom, are you there?
Yes, Your Honor.
Great. DeKalb, YDC, you guys, you are ready. Great. Appreciate your patience. Can we get Mr. Caldwell on the screen? Do you need a break or are you good for a minute? Okay. Can you see him on that screen? Yes. Okay. We will figure out how to get your screen on. That's the point of having that screen there.
Right, somebody did, huh?
There's DeKalb.
I don't see us, no. They can see you then.
All right. Are you Mr. Caldwell?
Yes, sir.
Can you hear me?
Yes.
Great. I'm Judge McBurney. It's nice to meet you, Mr. Caldwell. I am handling your bond hearing today. Mr. Shart, your lawyer, you talked to him earlier today, has filed a motion to have bonds set in your case. So I'm going to hear from him a little bit, and then I'm going to hear from Ms. Ocom. You'll see her on the screen as well. She's wearing yellow, and she'll maybe wave in just a second. There she is. That's Ms. Ocom. She's the prosecutor. I'll hear from both of them, and then I'll let you know what I'm going to do. I may also hear a little bit from Ms. Singleton. She often has some helpful things to share, and then we'll take it from there, okay?
Okay.
All right, Mr. Shart.
Yeah, please, the court. Mr. Caldwell, as you know, is an SB 440 case. He's charged with murder. He was 16 years old at the time of the alleged incident. He is 16 years old now. He is in Metro YDC, in the DeKalb YDC currently, and he's been there since January 14th of this year. Mr. Caldwell, I think if we look at the Ayala factors for bond, obviously he does, he is guaranteed the presumption of innocence. And I think that it's fair to say, as much as a 16-year-old can have substantial ties to the community, he does in fact have substantial ties to the community. He lives with his father. He's essentially his mother. I'm trying to put this delicately, has lived a rough life, is my understanding. And his father is the custodial parent for all the children, which he has. James has a brother and two sisters, but the family lives on Feld Avenue, which is in Decatur, over by downtown Oakhurst. He's lived in that area his entire life. They live in a single family dwelling. Mr. Caldwell has no passport. He's never been outside of the country. He's, at the time of his arrest, my understanding, he was enrolled in Decatur High School. He was in the 10th grade. He did have limited extracurricular activities. He reports to me that in the 9th grade, he was involved with the wrestling program there. So as far as ties to the community, Mr. Caldwell certainly has them as much as a 16-year-old can, and he has no means or ability to, or any ties to any other community that would suggest that he is a flight risk at all. I should also add that he recently became a father. He does maintain a relationship with the mother of the child. She was a student at Decatur High School. That's where they met, and that child lives locally as well. I will defer to Ms. Singleton as far as his juvenile history. My understanding is that there was a delinquent act of aggravated assault. My understanding is that involved a pole. It was not a gun charge. I just wanted to point that out. But I will defer to Ms. Singleton as far as the juvenile history, certainly which would play into one of the factors for bond. I'll also point out as far as the threat that Mr. Caldwell would affect the administration or hinder the administration of justice or would intimidate any witnesses. My understanding of the case is that, and I apologize, my boxer has decided to drink out of his bowl very loudly behind me in the middle of this presentation. But my understanding is that from the case is that the witnesses in this case are primarily, if not exclusively, law enforcement and information from the internet and different things of that nature. So I don't believe that there's any lay witnesses to even intimidate in this case. So I don't think that that's a realistic risk at all. So, Your Honor, what I would ask, and I know I'm going to get a second chance to come back after the state speaks, and I'll talk about the logistics of how I would fashion this if Your Honor would consider giving him a bond. But just generally, I would point out that obviously Mr. Caldwell, being an SB 440, is eligible for the services and the wraparound services that can be provided through pretrial services and Ms. Singleton. That would include family counseling, which I think he would benefit from. That would include individual counseling. And most importantly, I think for the concerns in this case, that would involve an ankle monitor. Now, I understand that an ankle monitor is not foolproof, and I get that. But I will say in the SB 440s and through pretrial services with Ms. Singleton, I think that the ankle monitors work a lot better than if we rely on a private company. I've seen Ms. Singleton track people on her phone. She gets real live updates, and Ms. Singleton's very good at what she does. So I think it takes the unknown of the monitoring company, who I've dealt with in the past, different monitoring companies, and I think it's fair to say that the court could have more confidence in Ms. Singleton and her ability to monitor Mr. Caldwell. So while ankle monitors are not perfect, obviously, I think that monitoring through pretrial services is the best option. So I would ask that Your Honor would consider a reasonable bond in this case. I would ask for a total $50,000 bond based on his ties to the community, the lack of him being a flight risk, and the fact that he is not a threat to hinder the administration of justice. And I do acknowledge that there is a juvenile history, but I don't believe that it's something that necessarily makes him a substantial threat to or substantial risk to commit future felonies.
Okay, thank you, Mr. Sharp. I followed all that. Was Mr. Caldwell living with his father at the time of the alleged murder, which looks like it was January of this year?
He was, that's correct. Mr. Caldwell, were you living with your father in January?
I muted it there, so you can nod. We'll unmute it if we need to hear more, but it was creating some tricky background noise having it unmuted.
I'm confident that he was.
Okay.
He was, and I should add, his father is a mechanic, and while he's not on this call because he doesn't have the technology for Zoom on his phone, both myself and Miss Singleton have been in contact with him, and he's very aware of the significance of these charges.
Got it.
He's been in contact with his son as well.
Okay, great. All right, Ms. Ocom.
Thank you, Your Honor. I think the state's position, I understand that he's 16, and that's why this is most concerning for the state, and he has a juvenile history of aggravated assault. Even though he might have been with a pole, the state's position is that this is an escalation. Just brief rendition of the facts. The victim was shot in the right temple in his bed in his home. And then the defendant made away with the victim's car. Officers, there was an APB for the car. Officers saw the car and tried to stop the car, and the defendant fled in the vehicle. The vehicle was stopped because he had an accident, and he came out of the vehicle, and then he ran. And then he was apprehended. The last person to talk to the victim before he died was the defendant. The gun that was found was the gun that shot the victim in the head. I think the heinousness of the facts of this case, I understand that the defense is going to say it's an allegation at this point, but the heinousness of the facts of this case is most troubling for the state, and the fact that he was 16 and he had a prior aggravated assault, and this is an escalation, and that he also fled from the police. I think the facts of these cases are just, for lack of a better word, troubling. And obviously the defendant has prior criminal history. I understand he's 16 again, which makes him, based on the other factors, likely to reoffend again. I think all of this fact is concerning to the state. And the state just believes at this point, until I think services, I guess I would hear from Ms. Singleton what or if any services can be provided for the defendant to ensure the safety of the community.
Sure.
Crimes. I'm sorry?
No, I was agreeing with you that
Yes.
we'll want to hear from Ms. Singleton. She's up
Singleton
next.
first before, but the state's position at this point, till I hear more from Ms. Singleton, is that it's just the defendant's just staying in custody. Your Honor.
Okay, hold on for 1 second. This is just from the grand jury. I just need to wave my hand over it, grand jury situation, or is this something more?
That's it, Your Honor.
It's blessed. Oh,
So
got
I
it.
have that one other coming later.
Okay, but I understand why that one's traveling separately. Thank you. It registers. Good luck.
I'll be back.
Good, okay. Sorry, I'm back. Because I'm hearing this calendar, that means I'm presiding, and there was something of immediate urgency, but I dealt with it. Ms. Singleton, I appreciate you sticking around with us. I know you've had to be in some other places. Can you please put on the record a couple things? One, I know Ms. Ocom has referred to it as criminal history. I appreciate Mr. Shark. It's not criminal history, it's juvenile situations. And so if you could share with me, Ms. Singleton, what you know about Mr. Caldwell's juvenile history, and then the services that you think would be appropriate to put in place were Mr. Caldwell put on bond.
Yes, Your Honor. Your Honor, as for the defendant's juvenile history, he has a May the 19th, 2017 battery. That was a misdemeanor. He has a October the 24th, 2017 affray. These are charges that he was all adjudicated delinquent and placed on probation for, Your Honor. He has a April the 19th, 2018 fleeing or attempting to elude the police, reckless driving, and theft by receiving motor vehicle.
How old would Mr. Caldwell have been in April of 2018? I mean, he would have been like
His date of birth
13
is
years old.
December.
Okay. All right.
Okay. His birthday is December 26th. Okay. Your Honor, he has a October the 1st, 2019 aggravated assault with serious bodily injury. That involved a metal pipe and a disorderly conduct. He has a January the 24th, 2020 terroristic threats and obstructing law enforcement. He has a January the 14th, 2021 theft by receiving, fleeing, or attempting to elude, possession of a pistol or a rifle under 18, and obstruction. And he has an open case that was filed on April the 21st, 2021. I believe that's a refile because the actual charge date of that case is August the 28th of 2020. And that's an aggravated assault with a serious bodily injury that involved a BB gun. I did speak with his probation officer. Your Honor, all of his cases are out of DeKalb County, which is the county that he lives in. And I spoke with his probation officer, Mr. Bates, this morning. He stated that his next court date is May the 24th of 2021 for the open case that he still has. He expects that case to just be continued as open based on the fact that the court there has the information that he has these pending charges here in Fulton. I spoke with his father on last night. Mr. Caldwell Sr. stated that James has always lived with him since he was a baby. He, as Mr. Shard stated, does have custody of all of the siblings, and James does have a twin brother as well. He stated that the defendant did previously attend Decatur High School, and that he does, the father does work from home. He owns his own auto shop. And so he would be able to supervise the defendant. If the court were to grant bond, I would just request that he receive the ankle monitor paid for by the Department of Juvenile Justice, the 24-hour curfew except for school, that he be court ordered to attend school. He was on virtual school previously. That may be a situation that needs to be looked into as ongoing. My experience with the DeKalb County School District and SB 440s is they typically either do not allow them to attend any school setting in person, even prior to COVID, or they are sent to the alternative school on Memorial Drive. So that would likely be his situation, or even the option of a GED at this point, since the defendant is 16 years old. That he, as I stated, have the 24-hour curfew and have adult supervision at all times. And supervision by myself, that he also received the wraparound services, which is the in-home counseling, family counseling, and individual, Your Honor.
How much of the things you just listed would Mr. Caldwell have already been receiving, given the juvenile history you shared with me? Obviously, he didn't have an ankle monitor, things like that, but what kind of services would he have already been getting?
So supervision by his probation officer, Your Honor.
Okay, so less intensive.
Well, he may have had ankle monitoring at different points in time. The juvenile court only provides 31 days max on ankle monitoring for any charges, whereas the SB 440s receive it from the time they get it until the case is resolved, unless the court orders something different.
Okay, got it. Thank you. Mr. Sharp, anything you want to share to wrap things up?
Yes, Judge, thank you. So I am asking that, and I understand his juvenile history, and I understand the concerns with that, but I am asking that you would consider a reasonable bond. But I think that we could all agree if a bond was granted, Ms. Singleton in pretrial services is an absolute must. And the difficulty we have, and the state legislature, they made it a little bit more difficult for me by passing. Yeah, a little bit, a lot, by passing a law that restricts pretrial bonds on certain charges. Now, being the creative lawyer that I am, I've come up with a couple different ways we've been getting around that. Basically, to give greater assurances to the community and to involve Ms. Singleton. So one way that this has been done, because I understand it's only murder and aggravated assault on the calendar today, is to add, without objection from the defense, a charge of 1611-132, which is legal possession of a firearm by a person under 18. Obviously, if he's accused of shooting, which it appears he is, that's what he's accused of, the alleged facts would support that charge, and that charge could be granted a bond through pretrial services. And as long as one count has a bond, a pretrial bond, Ms. Singleton would be involved. The other option that my understanding is some judges have done is make participation through pretrial services a special condition of the bond, and lay that out directly in the bond order to have the peace of mind and the assurances of that pretrial would provide. So I just wanted to add that is my proposal on how to ensure pretrial involvement in any bond that you grant. Thank you, Judge.
Okay, no, I appreciate that, and I appreciate your creativity. I think you're being a little euphemistic in your description of the legislative changes that were wrought in terms of, what's it called now? Unsecured judicial release. It's a terrible name. All right, thank you. I have a question for you, Ms. Singleton. Are you and is your group in a position to provide the supervision that you do if it is simply listed as a condition of the bond, or does it have to be that some count that a defendant, that a juvenile faces, is the bond set there is a pretrial services bond? Does that make sense? My question?
It does, Your Honor. So, Your Honor, I was made aware of that situation as it being a special condition on yesterday. I was provided with a copy of a bond order where it had been placed on it from one of the other judges. Prior to that, what we have had happening is preliminary hearings with an addition of a lesser offense, and then the bond, a pretrial, has been added to that. But I was made aware that situation of a special condition had started in a different courtroom that I have not had any cases come out of. It was an adult case that it was added onto, and I was provided that by my higher ups. So I assuming that is what may possibly be going on some of the other cases with the SB 440s. We have, as Mr. Shard laid out, the first option, we have had an additional charge been added and placing a bond on there. A charge that we have seen in circumstances even prior to this new situation with the House Bill 889. That was something that was occurring, and we had seen that the DA's office historically was not indicting that added charge because it's a lesser offense.
Right.
And so it had not been to the detriment of the defendants either.
Okay, got it. Well, I appreciate that people are looking for ways to keep your team involved, because there are cases where that role is real important. So, Mr. Caldwell, I've listened carefully to what Mr. Shart had to say, what Ms. Ocom shared, and what Ms. Singleton shared. It sounds like you've had a rough few years, and I'm sorry that your mom isn't more present in your life. It sounds like your dad does what he can. But as I heard about, have you been bouncing back and forth in the juvenile court, battery, affray, some kind of adult-sounding things, driving a car at age 13, an aggravated assault, and now even an allegation that you had a gun. And I realize that that's merely an allegation right now. That one you're going to court on in a few weeks in DeKalb. But I think about all those, and I think about the fact that all that was going on when you were living with your dad and had the support network that would be around you if I were to set a bond. I'm not comfortable that there is a set of conditions that I could impose, even if they included Ms. Singleton and the ankle monitor, et cetera, that would keep you safe and that would keep other folks safe. Time will tell what happened in this latest situation where the man was found dead, shot in the temple in his bed. And it's alleged you were found in his car soon thereafter and whatnot. Like Mr. Sharp pointed out, you're presumed innocent and the state has the 100% burden of connecting the dots. But the docket suggests some of those dots are starting to connect in a way that's going to be kind of complicated for you. And I think it's important that you stay safe and that other folks are able to be safe while we get to the bottom of these charges. So at this time, I am not going to set a bond, but Mr. Sharp knows full well that if too many weeks pass and you have not been indicted, we need to have this conversation again, because it is not your fault, Mr. Caldwell, if it takes the district attorney's office 3 months more to indict this case. Based on the case file that already exists, it doesn't look like it's going to be a real complicated one for the state to pull together. And they need to be mindful that there's a 16-year-old young man not able to go to school, be with his dad and his brother, et cetera. And that's just fundamentally different from a 40-year-old guy who is sitting out of jail. That case needs to move as well, but this one needs to move particularly quickly. So, Mr. Sharp, I'm the one who will handle all questions of bond unless and until the case is indicted. If you feel like too much time has passed with no demonstrable progress in Mr. Caldwell's situation, then we need to reconvene. And all you need to do is reach out to Ms. Nelson and we'll get this on a calendar. It doesn't need to be on a Tuesday morning. It's Tuesday mornings when I'm presiding, but it's now my case for purposes of bond only until it gets indicted or dismissed. And so I will keep up with it as needed. Thank you.
Understood. Thank you, Judge. And thank you, Ms. Nelson.
Thank you, Your Honor. That is my last case. May I be excused?
You may. Thank you.
you.
And we're going to turn back to our other calendars. Pope, we're good if you come on up here. Sorry to keep you waiting. Do you swear or affirm that the contents of your affidavits are true and correct to the best of your belief and knowledge? All right, go find this guy. You need to sign. I lost the other little sticky in the 2 places for each one. I've already signed, so you just sign it as well as the applicant. You're good to go. I crossed out April. I wrote May. Yeah. All right. Mr. Lares is still here, so we ought to not keep him here any longer. Mr. White is still on. Mr. Lares, did you have a chance to speak with Mr. Vergara?
I did. Yes, I did, Your Honor. And he is requesting that I withdraw the plea motion for the time being.
So that you and he can speak directly?
Yes, Your Honor. And if I might ask a point of the scheduling of the court would not consider bond for him today without my making a formal motion, would it not?
It's not me so much as the state having a chance to prepare for it and being on notice of that. I notice it's an aggravated battery, and so the state would need a chance to contact the victim to have that discussion. So I'm not going to put the state on the spot on that one.
So this is the case where the charge has actually been reduced to a misdemeanor battery.
Oh.
And the plan today was for him to plead to the misdemeanor battery and be out of jail because he's already in for 18 months.
Got it.
But I guess through conversation, the defendant is not going to plead to misdemeanor battery.
Okay.
So now he has to for a bond. Because of the fact he's already in for 18 months on misdemeanor. On that, I would not object to bond. However, I do have worries about him being flight risk, especially since I think we'll say earlier that he has a hold
So he may not be able to get out with the hold, but he and ICE will negotiate that. And I heard yesterday, completely different case, that ICE isn't necessarily grabbing folks with those detainers. But if you don't oppose a bond, it would have to be a good bond. Aggravated battery is not an offense that I can make unsecured judicial release. So we could make it a low amount, but it would have to have a dollar value on it. If you're not opposed to that, that seems like the right next step. I hear your concerns about flight risk, but if he's only done 18 months and he's fleeing from a misdemeanor, he's fleeing from effectively a closed case. So I don't mean to make the decision for you, but I appreciate you being flexible on this, given the amount of time Mr. Vergara has been in custody. So, Mr. White, if we set a bond at $5,000, then I don't know if he can make it. He's retained you, but I'm prepared to set a bond at $5,000. And I'll notate on there that the state's agreed to reduce this to a misdemeanor if and when it's a plea. He'll need to have no contact with the victim, that kind of stuff. Does that work for you?
It does, Your Honor.
Okay. That's what we'll do. Should I have Mr. Lares, because he's gracious, pop back into lockup and just explain to Mr. Vergara what's happening?
If you would, Your Honor, I would appreciate it.
So just so we're all clear, no plea today. I will sign a bond in this case for $5,000, good bond, for the only count. I'll put some language in there about, because this is going to be reduced to a misdemeanor if he pleads, no contact with the victim, and we'll go from there.
All right. Thank you, Your Honor.
All right. Thank you, Mr. White. It's nice to meet you in person.
All right, well, Your Honor.
You may.
Thank you, Mr. Thomas. Let me count.
All right. If we get back to our regularly scheduled calendars, is that Nesbitt? Let's do that then. Okay. Ms. Rutter, are you ready to do Mr. Nesbitt?
Yes, Your Honor.
Who is on from the Public Defender's Office? Or is it
I am, Your Honor.
Hey, how are you?
Shubo. Yes.
Hello, Ms. Shubo. Do you have more cases on the calendar? No, we're handling Mr. Nesbitt. That can't take very long. And then we're back to the final plea calendar. Okay. Thank you for your time on that one today. You go right where we thought it would.
Thank you. Are they? They get okay. They had to get him out of there. All right, Ms. Rivers, you ready? This is 16 SC 145538, State versus Maurice Alexander Nesbitt, aka Mega Ruckus. Hello, Mr. Nesbitt.
Hello, sir.
How are you?
Okay, considering the circumstances.
Well, what are those circumstances? Well, we've missed you over these many years, Mr. Nesbitt. So we get this on the record. The state is represented right now by Ms. Rutter, who is the head of the appellate section for the district attorney's office. And I have asked the public defender's office to have someone here on your behalf. And Ms. Shubo, who you'll see on the screen there, who is with their appellate unit in the public defender's office, has graciously agreed to be here on your behalf. So we have the full setting. Mr. Nesbitt, you went to trial in late September, early October 2017. The last day of trial, when we were going to have closing arguments, you cut off your ankle monitor and disappeared. The jury found you guilty of the murder of Rashawn Jackson, and I sentenced you to life in prison as a result of that. While you were gone, your attorney at the time, Mr. Bruce Harvey, did file a motion for new trial in an attempt to preserve your appellate rights. That's really all we need to talk about today, because you have a ticket to the Department of Corrections where you will be for the foreseeable future. I'll let you talk with Ms. Shubo or someone else from her office at a later date, but I do need to inform you that I believe something known as the fugitive disentitlement doctrine means that there's not a whole lot for someone to do on the appellate side for you. But your lawyer from the public defender's office will file whatever he or she believes ought to be filed in an effort to pursue your appellate rights. Normally, what would happen after a guilty verdict is that Mr. Harvey would do what he did, which was file the motion for new trial. And then you would get just that. We'd have a hearing about whether mistakes were made during your trial by me, by your lawyer, by someone, such that we ought to give you another bite at the apple. I have since dismissed Mr. Harvey's motion because I believe that he was not in a position to file something on your behalf while you were a fugitive. I may be mistaken, and certainly if there are things that Ms. Shubo or others believe ought to be appealed and can be appealed, they will pursue that. But you may have painted yourself into an appeal-free corner by having gone wherever it was you went. Ms. Rutter, is there anything you want to get on the record at this time?
Your Honor, yes, we would refer the court to the March 26, 2018 order in which we believe this court correctly denied the defendant's motion for new trial based on his absconding and waiving of his appellate rights. We would argue that any reopening of that by defense counsel will be barred by res judicata. It's already been decided by this court. And on the merits, of course, we are happy at that. It is the court's preference to provide case law to reiterate the barring of his appellate rights.
Okay, thank you. I think I cited in that order to the cases that do control, but things can change. Ms. Shubo, what is your thought about what the right next steps are for Mr. Nesbitt?
Well, I believe there are a couple of next steps before we even get to the thing that Ms. Rutter is speaking of. First, you never allowed Mr. Harvey to formally withdraw, so he is still counsel of record. He asked, but that needs to, an order needs to be entered to that, unless you feel that your dismissal order kind of inherently did that. The next question is, does Mr. Nesbitt want a public defender? And then the question after that is, does he qualify for a public defender? Which because of his prior state of hiring Mr. Harvey, as well as making a large bond, there's a possibility that he does not qualify for our services. Once we get through those 3 hurdles, then there's a whole nother hurdle.
Okay, well, let's take a step back. I am confused because I signed an order allowing Mr. Harvey to withdraw. He reached out to my office a few weeks ago when this calendar was published saying, hey, I asked to withdraw a long time ago. I need to withdraw. And I signed it. It is not in the docket. You are correct. And that's why I'm confused. So floating around somewhere in the ether is an order allowing Mr. Harvey to withdraw from this case. Maybe it's in a different docket mistakenly filed, but we will fix that today. The order has been granted. I signed it, and Mr. Harvey is no longer attorney of record. And it was because of that that I asked Ms. Nelson to contact your office. That doesn't mean, to your point, Ms. Schubar, that Mr. Nesbitt qualifies for the Public Defender's Office services. He may have won the lottery 6 times over while he was a fugitive, and then he would need to hire his own attorney. So how do we best set up an opportunity for your office to determine if it's in a position to represent Mr. Nesbitt?
Ms. Patel is in the courtroom right now and is going to be doing that as soon as we're done talking.
Okay, well, let me ask Mr. Nesbitt, because to your other point, of course, he's in charge here. It's his case. Mr. Nesbitt, do you intend to hire an attorney, or do you feel at this point you would need appointed representation to help you with any appeal?
Can you repeat that one more time?
Sure. So I've already shared with you where I think you're stuck with the appeal, but you have the right to have an attorney help you through this appellate process. And it may be a long, robust appellate process. It may end real quickly, but criminal defendants in Georgia have the right to counsel to help with their direct appeal, their first round of appeals. Mr. Harvey's off your case. He asked to be withdrawn, and I granted that order. It's not in the docket, but that doesn't matter. So you can either hire an attorney if you can afford one. If you cannot afford one, one will be appointed to represent you unless you want to fly solo. You have the right to represent yourself. You could have done that at trial. You could do that now. But if you want a lawyer to help you figure out if you have any appellate rights, then you can hire one if you've got the money, or your family does, or I can appoint one to help you. So that's what we're trying to work through.
Yes, I want one to be appointed.
Okay, you feel like you don't have the financial resources to hire an attorney. Okay. So,
Your Honor?
Yes.
At this time, the state would object. It's our position that his motion for new trial and notice of appeal are waived, and any proceedings he would file would be a civil habeas, and defendants are not entitled to counsel in civil proceedings. And so it's our position that his direct appeal has already been waived based on your 2018 order. And at this time, there is no jurisdiction for this court or for Mr. Nesbitt to have any type of counsel by the Public Defender's Office.
Okay, I appreciate your objection. I'm going to overrule that. I'm going to at least allow the Public Defender's Office, if it wants to, and assuming Mr. Nesbitt qualifies, to consult with him about what his options are. I'm confident that Ms. Shubo will be a wise steward of her own resources. And if she determines that Mr. Nesbitt's options are few or none, she's not going to spend a lot of time on that. But if she thinks that there were mistakes made that call into question my order, that don't make this a civil matter, to your point, then I think Mr. Nesbitt can have representation to that effect. So it sounds like, Ms. Shubo, you would like Ms. Patel to speak briefly with Mr. Nesbitt to make sure he qualifies, and it would seem like he would, that he's in custody, but
Right.
Bernie Madoff was in custody too. So we'll let Ms. Patel sort that out. Assuming the answer is yes, Mr. Nesbitt qualifies, what is next for your office?
I think that Ms. Rudder makes a point. I don't agree with it at this point, but I do think that it's something we need to research before we go forward. I think that there are some thorny procedural issues that we need to tackle. And I've done about a 2-hour amount of research, but I would want to do significantly more of that before I can sufficiently advise on what the next steps are.
Okay, so let's do this. My job will be to figure out where my order getting Mr. Harvey off the case is, and I'll get it in the docket. Ms. Patel, you'll talk with Mr. Nesbitt and then let me and Ms. Nelson know if Mr. Nesbitt qualifies for appointment. And then your office will take over if the answer is yes. And then it's up to you, Ms. Hubo. I don't expect Ms. Rutter to do anything. I think the case is where she thinks it should be. If your office files something, I'll take a look at it. And if I feel like the state needs to respond, I'll let Ms. Rutter know that. If I don't need a response from the state, I'll let her know that as well, and I will take it from there. I guess the only other question I have is the ticket that I mentioned that Mr. Nesbitt has to the Department of Corrections. I don't see any reason why the sheriff's office needs to hold on to Mr. Nesbitt. Certainly he can stay here so that Ms. Patel can talk to him today. But beyond that, at a minimum, he's been sentenced to life. And he shouldn't be treated any differently, maybe for a more closer watch on him, than anyone else who got sentenced to life. And so he should be sent on his way. And if you need to communicate with him, we can use WebEx, et cetera, so you can have that contact. Is that fair?
I have no argument against that.
Okay. All right. Ms. Rutter, anything else from the state?
No, Your Honor, just would reiterate on the record that we think that the order you entered was proper and we agree with the law. We've cited it, shepherdized it today. It's still proper law. But we will respond accordingly if Ms. Shuba files anything.
All right. Well, I'm flattered that you like my order. It says what it says. We'll see where we go from there. Mr. Nesbitt, do you have questions about anything?
So
for me, it's just logistical. If you have legal questions, Ms. Patel can talk to you about that. But if it's like, hey, what happens next? How long will I be in Fulton? We can talk about those things.
Okay. So how long will I be in Fulton?
So we'll let the sheriff know today that your sentence remains in effect. And so then you'll just want to ask folks out at the jail, how frequently is that Department of Corrections shuttle running? But you don't have any more business here other than there may be some legal back and forth. And so if you're appointed counsel, that lawyer will let me know, hey, Judge, we think you made this mistake. And if it's something you need to be here for, we'll either bring you here personally, or the new normal is you'd be dialed in through Zoom or WebEx, something like that. So you'd be participating, but you'd be at whatever state facility you're in. So I would assume that your stay here in Fulton is now going to be pretty short.
Okay.
Did that answer your question?
Yes, sir.
Okay. All right. Anything else?
Your Honor, just may I speak just to Mr. Nesbitt in open court? If, assuming that we're going to represent you, we're going to send you a letter and we're also going to make a phone call to talk to you about it. So, and either way, we'll send you a letter about the representation. But if we are, we will definitely set up a call to talk about everything that's going to go forward from then. It's not going to happen immediately, but those are the next steps.
I guess that's one wrinkle. If Ms. Patel shares with me that the public defender's office cannot represent you, Mr. Nesbitt, and you're still here, we may bring you back, because then I'll need to help you figure out who your lawyer is going to be. You are guaranteed of an attorney, so you'll get one. And ideally, it's the public defender's office. Top flight lawyers, this is what they do for a living. But if there's either a conflict or it turns out you've got $100,000 in a bank account, they can't represent you. So then we need to figure out how we'll get you that lawyer who will help you with whatever chance you've got.
Okay.
Okay?
All right.
Can I ask you one question?
Yes, sir.
Where'd you get picked up?
Your Honor, I would object.
She can object. I'm just curious what state you were in. No, I can ask the investigator.
You really don't know?
No, I just didn't ask the guys yet.
Oh, Birmingham.
Okay. That's all. Thank you. Good luck. Yeah, assuming that works with the deputies, we need it to happen. So let's do that, because then they can get him going. All right. Thank you, Ms. Patel. And you just let me know, yes, we can represent him. No, we can't. All right.
Thank
Great.
you, Your Honor.
Thank you, Ms.
Excused.
Shebo. Yes, ma'am. Thank you for dialing in. Thank you, Ms. Rutter. I know you've
Thank
got
you, Your
somewhere
Honor.
else you need to be.
Thank you.
All right. Yes, sir. Come on and get it. Sorry to keep you waiting, but we had these other things. So next up is Ms. Hubbard. And that's Ms. Patel. So we'll pause. Ms. Hubbard, just sit tight. You gotta get your, and that's Mr. Wright as well, and he's been on this call. So let's do, how about you, Ms. Smith? You've been staying here. Mr. Franklin.
We have an updated agreement with Ms. Hilton and
Ms. Hilton's been on. Ms. Hilton, can you come alive on the call?
Yes, Your Honor. Hold on. Let me just put on my suit jacket. Hello, Your Honor. And let me all.
How are you? That's a very nice suit jacket.
Thank you, Your Honor. I try.
Yeah. All right. Ms. Smith has been here. She actually got here for our 9 o'clock calendar. So she's been wearing out those benches back there. Ms. Rivers, are you good or do you need a break? You okay? Okay. Your chair looks comfortable. All right. So this case is on for final plea. Before we get anything on the record, what are we doing today?
So the agreement is going to be a reduction. Well, count 1 is being null pros. Count 3 is being null pros. Count 2 is being reduced to misdemeanor family violence battery. Going to be 12 months of probation.
So it's a plea.
It's a plea.
Okay, let's do it. Yeah. All right. Ms. Hilton, are you ready for that?
Yes, Your Honor.
Okay.
All right.
And it's now.
I'm sorry, Ms. Smith, if you can please raise your right hand.
Oh, hold on. We're not quite that ready. I just want to make sure you were ready to go forward.
Oh, yes, Your Honor, we're ready.
All right, great. So this is position 7. It's 20 SC 176892, State versus Katrina Smith. Ms. Smith is here in court with her attorney, Mr. Franklin. Ms. Hilton is representing the district attorney's office. She is appearing remotely. And it sounds like there is a negotiated plea that involves some dismissals and a reduction, ultimately a plea to a misdemeanor. Ms. Smith, you're going to be put under oath in just a moment. Ms. Hilton's going to have you raise your hand and all that. Once you're under oath, it's important that you answer all the questions truthfully and completely. So if at any time someone asks you something that you're not sure about or it confuses you, it's not what you were expecting, bug Mr. Franklin to make sure you get what's going on, okay? Great. And when you do answer, make sure you answer out loud and into that microphone because Ms. Rivers and Ms. Hilton both need to hear you. All right, Ms. Hilton, now it's your turn.
Ms. Smith, if you could please raise your right hand. And can you hear me?
Yes, ma'am.
Okay. Do you solemnly swear that the evidence you shall give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth? So help you, God.
I do.
You can put your hands down. Please state your true and correct legal name.
Katrina Renee Smith.
And are you the same person referred to as Katrina Smith on indictment 20 SC 176892?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or any medicine?
No, ma'am.
How old are you?
33.
And how far did you go in school?
12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with, in the initial indictment, 1 count of aggravated battery, which carries a sentence of 1 to 20 years, 1 count of aggravated assault, I apologize, 1 count of aggravated battery family violence, which carries a sentence of 3 to 20 years, another count of aggravated assault family violence, which carries a sentence of 3 to 20 years, and 1 count of possession of a knife during the commission of a felony, which would run consecutive to all the other counts, which is a sentence of 5 years to serve. Do you understand that's what you're charged with?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
You understand you have the right to plead guilty or not guilty?
Yes, ma'am.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you, sorry. Okay. Have you had enough time to speak with your lawyer, Mr. Devin Franklin, about this case?
Yes, ma'am.
And have you spoken with him about all the facts and circumstances known to you regarding the charge in this indictment?
Anything else you want to
Yes, ma'am.
Have you spoken with him regarding any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Franklin, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, if there are any?
Yes, for purposes of this plea.
And Ms. Smith, were you arrested on these charges previously?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
She just wanted to make my twin stuff earlier.
Yes, ma'am.
And do you recall me going over the minimum and maximum of each charge?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? As a part of the negotiated plea, we're going to dismiss count 1 and dismiss count 3 of the indictment. Do you understand that?
Yes, ma'am.
And as it relates to count 2 of the indictment, aggravated assault, we're going to family violence, we're going to reduce that to a battery family violence, which is a misdemeanor. Do you understand that?
Yes, ma'am.
Do you understand that the offer on this case is for you to serve 12 months on probation?
Yes, ma'am.
That as a special condition of probation, you have to, 1, complete a family violence intervention course. You understand that?
Yes, ma'am.
2, that you're to have no violent contact with the victim in this case, who is Marcus, Marcus, Worthington, Worthington.
Yes, ma'am.
Understand that you're supposed to have drug and alcohol screening and take any necessary or recommended treatment that is recommended to you.
Yes, ma'am.
You understand that the court does not have to accept that recommendation.
She's saying that we came to an agreement, but the judge doesn't have to accept it. If he doesn't accept it, we can back out. Do you understand?
Yes. Yes, ma'am.
The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other. Do you understand that?
Yes, ma'am, I do.
With one exception, if the state is dismissing counts, I can't sentence you on them. So the only thing I could sentence you on is the misdemeanor. The state's reducing that one count to a misdemeanor. So the most I could do is 12 months in jail. So I'm not saying that's what I would do, but that's just what you need to understand is how this could work, okay? Okay.
If he says that, we can back out, okay?
Okay.
You need some time?
Yeah, no, okay.
You sure?
You sure? You can take a second.
I didn't mean to upset things. I just wanted to make sure you understood how it worked, okay? Okay. You good?
Yes.
All right.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
Yes, 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 ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
So do you understand that like if you want on your record and things can be affected by things on your record, whether it be housing, job opportunities, that stuff we talked about earlier?
Yes, ma'am.
Okay, and just kind of like what your attorney just said, for example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Are you taking this under, I don't think you are, but you're not taking this under first offender, correct?
No, ma'am.
Do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
It's just if you wanted to try, you would be able to do all these things. So she's making sure you understand.
Oh, yes, ma'am, I do.
Okay. Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case.
If we went to trial, you would have me.
Yes, ma'am. Okay.
I know that was, I said a whole lot right there. I'm sorry. The right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charge against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty or because you're taking it under North Carolina versus Alford?
This is an offer plea.
It is or is not?
It is.
Okay.
Are you pleading guilty because you have decided it is in your best interest to do so?
Yes, 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 ma'am.
Okay. Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
With respect to indictment number 20 SC 176892, where you're going to plead to count 2, aggravated assault reduced to battery family violence, how do you plead? Guilty or not guilty?
Guilty.
Is that guilty under Alford?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand?
She's asking you, so are you pleading, understanding everything that you're being charged with, how it's being reduced and stuff?
Yes, yes, ma'am.
Okay. Do you say you may have only a limited right to appeal this guilty plea conviction?
You understand that once you enter the plea, that you don't have a big way of taking back the plea. You have a limited way of doing it.
Oh, yes, ma'am.
Do you understand that you have 4 years from today's date? Oh, excuse me, I apologize. You have 12 months from today's date for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
She's saying you have 12 months if you want to try to take back the plea or challenge the validity of the plea. You got 12 months from today's date.
Oh, yes, ma'am.
And do you know what a habeas corpus petition is?
I can't hear you. I'm sorry.
Sorry, do you know what a habeas corpus petition is?
So habeas would be challenged.
When you,
This would be challenged the conviction or the entry of such voluntariness of the plea. So she's that you have to explain it to her, but do you understand that's what it means?
yes,
You can tell her yes.
yes, yes, ma'am.
And do you understand you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
All right. And Your Honor, that completes the plea colloquy. If this case were to go to trial, Your Honor, the state would expect to show that on May 14th, 2020, at 4265 Shirley Drive, which is the Economy Hotel on near Fulton Industrial Boulevard. The victim in this case is Marcus Worthington. At the time, and I believe that they still are, they were in a relationship Mr. Worthington had met Miss Smith at the Mrs. Winters, where she was working at the time. And he picked her up by walking. They walked back to the hotel room. At the time when they walked back to the hotel room, they did engage in taking cocaine as well as possibly drinking. At that point in time, an argument did begin. According to Miss Smith, she advised that the defendant did hit her at some point earlier in their altercation. Later on, she tried to leave the location. When she began packing her bags to leave the location, Mr. Worthington tried to grab her cell phone in an effort to keep her cell phone. But once he grabbed the cell phone, she turned around and picked up a machete and cut him on the side of his neck. There was a break between the first incident and then this subsequent incident with grabbing the cell phone, with him attempting to take the cell phone and her subsequently cutting him with a machete. Mr. Worthington left the hotel room, went to a gas station where 911 was called. Police arrived on the scene. He was transported to Grady Memorial Hospital, in which he did receive stitches and had to have surgery to have that cut, to have surgery on the cut, Your Honor. In this case, it appears that this is more of a toxic relationship between both Miss Smith and Mr. Worthington. We've had some conversations with Mr. Worthington about the resolution of this case, and we gave him what the offer was going to be. He advised that they were still in a relationship and still deal with each other. And so based upon kind of the history, based upon the facts of this case, Your Honor, the state thought it was appropriate to reduce this to a misdemeanor, battery, family violence, with the special conditions as enumerated earlier in the plea colloquy, Your Honor. As far as Ms. Smith's criminal history, she does not have any felony convictions, Your Honor. Her history is primarily theft, and she does have a hit and run and a driving while license suspended, Your Honor.
Okay. Thank you for sharing that. Ms. Crawford, any adult felony criminal history for Ms. Smith?
No, Judge, she doesn't have any criminal history.
Thank you. So, Mr. Franklin, talk to me about how a machete attack is being reduced, other than your good negotiating skills, to misdemeanor.
So I will begin with my first real conversation or attempted conversation with Ms. Smith. If you recall, well, you probably don't recall, but I was on Zoom the day that she showed up for court, so we hadn't met in person. So she gave me her phone number, and I made a phone call to her. I had some indication in the notes in my file that Mr. Worthington may not want to prosecute. And I was calling to follow up with Ms. Smith about just kind of what went on that day, just a basic introductory conversation. It turns out that Mr. Worthington was in very close proximity.
When you were talking to Ms.
Smith.
Okay.
Such that I wanted to talk to him anyway. As I was preparing to ask to speak with him, he grabbed the phone, or she passed the phone to him. And what I learned today, so there was some aggression towards me for calling. He and I had some words with each other in terms of the tone that was being used.
Meaning, like, why was another man calling Ms. Smith?
Exactly.
Okay.
So I don't think he believed myself to be an attorney. He, I would call him saying that you just like a regular dude, essentially. And that a real attorney.
What are attorneys supposed to sound like?
I have no idea. But he may mention that.
Hold on one second. It's this device here. And we just don't know the name for it. It says witness on the back, but I assume witness is the D10. Okay. We don't need the camera. What really all we need is for Ms. Rivers, when she's sitting here, to be able to see what's going on. So if that's an easy fix, great. If it's complicated, we can do it another time. Okay. Would I not see it on the control panel then? Because it's not a... Got it. Okay. Sorry.
So to kind of get through that part quickly.
That's kind of interesting though.
Based on what I interpreted as a kind of unexpected level of aggression for a conversation where I understood he didn't want to prosecute and that kind of stuff, I made mention to the first DA who had the case, Ms. Besa. She subsequently went out on leave. I made mention of it to Ms. Sims. She subsequently left the office. And then I spoke to Ms. Hilton about it yesterday and was like, I think there may be something else going on with him. From my perspective, I expected that there was potentially some violence on his end of things as well. I spoke to Ms. Smith today in person because I didn't want to call her anymore because I didn't want to agitate anything.
Right.
And she communicated to me kind of what Ms. Hilton picked up on. This is a toxic relationship. She spoke about the fact that there was some more regular abuse early on. Not so much of that now, she said they had been doing good. I think that this drug usage that was spoken about certainly contributed to what went on this particular date. And more importantly, the reason why we get to a negotiated misdemeanor. There are certain facts that exist that this would not have been an impossible case if we had thought we could get an immunity motion on it. I'm not sure how strong that is. She suffered some injuries to her eye as she was pushed into a bed or a corner of a bed during the physical nature of what was going on. I don't think he was wailing on her at that point in time, but there was certainly kind of this physical thing going on. And she picks it up in self-defense. And I think in the haste of things, she cuts it. Him getting cut happens more so than this being an actual machete attack, as we would kind of assume when we first, read the indictment. So in light of the fact that it's not the type of assertive attack that we may think it was once we kind of dive into the facts, the fact that Mr. Worthington didn't want to have a full-out prosecution or felony convictions. And the fact that, from what I gather, despite it being machete cuts to the neck, I think he was out within a couple of days. A day or so. It was
Any reason why there was a machete floating around in the hotel room?
That was the protection they had. They just didn't have
Okay.
gun.
In lieu of a gun, they had a machete.
Correct.
Okay.
It's just what was there. And so we think that this is just it's a heck of a happening. There was a happening more so than an attack. And so we appreciate the communication that I was able to kind of have with Ms. Hilton yesterday, and we were able to talk through things fairly quickly. It just needed me to speak to Ms. Smith again, and I spoke to her this morning, and this aligns with her goals for the case. She has employment pending that she could not get with the felony. She feels that she will still be able to get that job with a misdemeanor of this type. And we think it's a couple that's going to be together regardless. But we at least feel that getting
They both need to do FFIP. Okay. All right, that's helpful. I appreciate that. Let me pause one more time. Mr. Anjuran, going forward, how do we add this one? Do we have to plug a keyboard in every time, or because it's more helpful for the court reporter to be?
Oh, permanently, so then you can just log in and join. Thank you. That'll work for today. I appreciate it. Thanks so much. Okay, thank you for providing that background. Is there more you want to share?
No, that's essentially all, Your Honor.
You want to ask?
No, sir.
All right, so you and Mr. Worthington are still in item.
Yes, we are.
Do you live together?
We get motels together right now. We can't be in the same, like in the same apartment right now.
Because of this case?
This case.
Okay, so when this case is resolved, then you won't have to stay away from Mr. Worthington,
Yes.
so you'll be able to be in the same spot.
Yes, ma'am.
Do you
Yes,
two
sir.
have kids together?
No, but we call each other all our kids, our kids.
Okay, so you have kids from another relationship. He does as well. Did any of the kids stay with the two of you? Or are they grown, or?
We don't want them in this situation.
So they have safer places to be, both yours and his.
My children are with my mom right now, and my sister, and his children is with his baby mama at this moment.
And how many total kids are we talking about?
4 children,
All told.
all 4.
Okay. All right. And what's this work you're going to be able to do?
I'll be working at the Hilton Motel, making $14 an hour.
Did you say you will or we?
I'm gonna be doing.
Okay.
He's gonna be doing some construction or chopping off chicken heads.
With a machete?
I don't know. I'm just saying, that's what he want to do.
Okay,
I don't
I
want
think
to
you've
stop.
got the better job.
Yes, I do.
You do. Okay. All right, Ms. Smith. I find there's a factual basis for your plea. It sounds like you and Mr. Worthington have had a history of you care a lot about each other, but maybe because someone's drinking or doing something else, it gets messy pretty quickly. You're getting a family violence battery, which is a misdemeanor. Next time, even if it's just a family violence battery, that's a felony. And that starts making it real hard for you to work and things like that, because employers will say, well, I'll hire this person who doesn't have a felony.
Right.
So just keep in mind as you're working through your relationship with Mr. Worthington, none of us can keep you away from him. I could say that's a condition, but if that's who you want to be with, that's who you're going to be with.
I love him.
Okay, I hope he loves you, but sometimes it sounds like you guys express your love in ways that maybe not everyone would appreciate. I also find that your plea is knowing and voluntary. And I watched you ask Mr. Franklin lots of questions, and that's great. It's good to ask questions when you're not sure what's going on. Do you have any other questions, or do you feel like you understand what's going on?
I feel like I understand what you mean.
All right. Then I find that your plea is knowing. I think it's voluntary. Voluntary means that you're going forward with this because you think it's the right thing for you. Is that correct?
I think it's the right thing. So, yes.
No one's forcing you to enter this plea. Okay, then I'm going to accept your plea. It's an offered plea. And what that means is that you're not agreeing with everything the state said that happened, but you don't want to go to trial. You don't want the jurors to see a picture of Mr. Worthington's neck and the machete and blood everywhere.
I'll be honest, he's not going to come to court.
Well, the state has ways of getting him to come to court.
Subpoena.
He might come through that door instead.
Yeah, I don't know him to do that.
Well, then that's another reason to work the case out. But what I need you to help me understand is you are entering this plea because you think it's in your best interest to do so.
Yes.
Okay, then I'll accept it as an offered plea. It's to count 2, which has been reduced to family violence battery. I will follow the recommendation and sentence you to 12 months of probation. It will be a special condition of your probation that you complete a family violence intervention program. That's not just one class, it's a series of classes over time. No violent contact with Mr. Worthington. That's a condition, but it's also the law. If you hit him with a machete again, you're gonna get in trouble. You hit him with a baseball bat, hit him with your fist, you're gonna get in trouble. The same for him. He needs to keep his hands off you if it's not a lovey-dovey kind of thing. All right? You'll need to submit to a drug and alcohol evaluation. So you'll meet with a professional who's able to ask you questions and talk to you about what you do. And if that professional recommends treatment, that treatment will be part of your probation. So if they say you need to go to AA meetings or NA meetings, that's what you'll need to do. Any questions about any of that? This is your indictment. Normally we pass it around and you'd sign it and Mr. Franklin would sign it, etc. But what I'd like to do is sign it on your behalf, if that's okay. Can I sign for you? Mr. Franklin?
Yes, sir.
And Ms. Hilton?
Yes, Your Honor, thank you.
Great. So I will sign the indictment. It will indicate a plea to count 2, reduced to family violence battery. And we will go from there. I don't know how it works with misdemeanor probation as to how you report. What do we do? Okay, someone's going to come here. Okay, so you'll need to sit tight. Someone's going to come here to let you know where you report and how you report to misdemeanor probation. Okay? All right. Thank you, Ms. Hilton.
Thank you, Your Honor. That concludes my business for today. May I be excused?
Yes, ma'am.
Thank you.
Ms. Crawford, I have a quick question for you, and then we will turn to Harris and Hubbard. I forgot to get information from Mr. Griffin and Mr. Williams so that you could give them reporting instructions. What do we need to do about that?
I had emailed, text one of the attorneys and asked him for the his offender's information, but he did not respond back to me. So I just need to get their contact information, and then I'll reach out to them and give them the reporting instructions.
Okay, meaning the contact information for the lawyers?
For either lawyer, yes, I can get the lawyer's contact information, and then we'll go from there.
Okay, well, Ms. Nelson can help you with that. All right,
Let's turn to Ms. Hubbard and Mr. Harris. They have been patiently, some of them have been patiently connected here. Before we get on the record with that, Ms. Patel, what's the answer with Mr. Nesbitt? Is he becoming a client?
Yes, Your Honor, he does qualify for our services, and I let Ms. Shubo know that.
Great. Okay, good luck with that. All right, you represent Ms. Hubbard, and Mr. Wright represents Mr. Harris. Mr. Wright, in the past, I think he's there. Mr. Harris has been with you, and I see someone
Yes.
sitting in the background. There he is. Great. So we're on for final plea. I'm going to start with Ms. Patel, and we don't need to get on the record yet. Let's just figure out what's happening. What is happening with Ms. Hubbard's two cases, Ms. Patel?
Your Honor, believe position 5 is the null cross.
Okay, so we'll be hearing something from the state. And let's make sure Ms. Hubbard, can you hear us, Ms. Hubbard? Or can you wave? All we've got is a camera icon for you.
She was there a minute ago. I will text her.
It's a door. It shows a lock or a doorknob or something.
I think it's the ceiling.
Oh,
And that's a light.
the sprinkler?
That's a light.
It's a light. Okay. Why don't you see if you can get Ms. Hubbard to, I fully understand if she took a few steps away. It's been 3 hours. Yikes. When does the next thing start? At 12:30? Fun.
There she is, Miss Hubbard.
I see a hand. There's a face. Okay. Ms. Hubbard, can you hear me?
Oh.
Whoops.
Probably.
Well, how about this? We've got Mr. Wright and Mr. Harris. What's happening with position 4?
Your Honor, we have received some additional stuff from the state. If you recall, that was one of the issues, was getting clarity on what exists and doesn't exist.
Sure.
I think that has now occurred based on the offer which has been given by the state, which, if I'm stating it correctly, is 20 to serve 12. My client will respectfully decline that offer.
Well, let's get that on the record, and then we can get you and Mr. Harris on his way, or on your ways. So this is, we'll get on the record. This is position 4, 19 SC 170770. And we're dealing just with defendant Harris right now. He's represented by Mr. Wright. They are together in Mr. Wright's office. And we've got Ms. Hall here in court. Ms. Hall, if Mr. Harris wanted to enter a plea to aggravated assault, aggravated battery, etc., the charges he faces in this indictment, what would the state be recommending today?
Your Honor, for the aggravated assault with a deadly weapon, 20 years to serve 12, balance on probation, and all the other charges that fall in suit.
Okay, so the overall recommendation would be 12 years to serve, followed by 8 years on probation.
Yes, Your Honor.
Okay. So, Mr. Harris, it sounds like there's no surprise there. It's exactly what Mr. Wright said. If you were to enter a guilty plea today, the state would recommend that you serve 12 years in custody, followed by 8 years on probation. Do you understand that?
Yes.
Okay. If you were to enter a plea today, Mr. Wright would not be required to make that same recommendation. He could recommend whatever he thinks is a more reasonable sentence. If I were to sentence you to more than what Mr. Wright asked for, you would have the ability to withdraw your plea, say no thank you. So if I agreed with Ms. Hall and sentenced you to 12 years, or I thought her sentence was too low and I sentenced you to more, you could withdraw your plea. Do you understand that?
Yeah.
After today, you have the absolute right to enter a plea at any point, but two things may change. One thing that will definitely change is your right to withdraw your plea if you don't like the sentence I give you. So let's fast forward 2 months. This is on a trial calendar, and the state says, you know what, rather than go to trial, we offer you 10 years. And you say, great, I'll take it. If I decide that you really should serve 12 years, that's what your sentence is going to be. You don't get to withdraw it saying, wait a minute, I like the 10, I don't like your 12. You understand that?
Yeah.
The other thing that may change, I don't control this, is that the state may not keep this offer open. So it may be that it's trial time and you realize, boy, I do not want a jury to hear this case. I'd like to take that 12 years you offered me back on May 11th. Ms. Hall may say, you know what? Now it's 15 years. You understand that you cannot keep this offer open just because you want it to be open.
Yeah.
Yeah, speak up.
Yeah.
Okay. So understanding all those things, Mr. Harris, is it your decision to say no thank you to this offer and have me move your case to a trial calendar?
Yeah.
That's exactly what we'll do. You will remain on bond. It's important that you comply with all those conditions of bond. Mr. Wright, do we still have a good address for Mr. Harris?
I do, Your Honor.
Okay,
I've been in constant contact with him.
great. Then we will move your case to a trial calendar, Mr. Harris. We aren't trying a whole lot of bond cases right now, but I hope that changes soon. This is old, and we ought to get it into a courtroom as soon as we can. If you move, you need to let Mr. Wright know what your new address is so he can update the court, okay?
Yeah, you have the same address?
Same address.
Good, all right. Ms. Hall, anything else in Mr. Harris's case?
Nothing further from the state, Your Honor.
All right, Mr. Wright, Mr. Harris, you're free to go. Appreciate it.
Thank you. Good to see you, Judge.
Good to see you. Thanks for your time. All right, Ms. Hubbard, can you hear us now? So I can see you, Ms. Hubbard, but we can't hear you. Are you able to? Ms. Patel, I'm sure you've been working with her. Any idea what the audio?
I will text her and see if she.
Okay.
Miss Hubbard, is your microphone on?
Oh, this
here we
looks
go.
positive. There we go. Hey, Ms. Hubbard, can you hear me?
Good morning. Good
Good
afternoon.
morning. Yeah, it's afternoon now. You've been very patient. We're going to
Yes.
talk a little bit about your two cases, okay?
Okay.
Ms. Hall, tell me what's happening with position 5 first, which is where Ms. Hubbard is a co-defendant with Mr. Harris.
The state would be no crossing the charges against Miss Hubbard in that case, Your Honor.
All right,
I'll send the paperwork to the court later on this afternoon.
sounds good. Ms. Hubbard, one of your cases is being dismissed, the one that you used to have with Mr. Harris, okay?
Yes, sir.
But you've got another one with a whole bunch of counts of cruelty to children and obstruction. That's position 3. Ms. Patel, what's happening with position 3?
Your Honor, on position 3, I would ask for more time. The issue was that Ms. Hubbard was in BHTC on that case. When she picked up the new case, the charges were very serious. She was kicked out. I couldn't work with BHTC or look into anything until I could be assured that the other case would resolve itself in one way or the other. So now that I am in a position to move forward on the other case, I'd ask for more time to see if I can either find an outpatient program or see if BHTC will take her back now that the other case has been resolved. I spoke to Ms. Hubbard about this as soon as Ms. Hall let me know that she was not crossing it, and explained to her that that's the approach that we would try. The other case, we have zero intentions of taking to a trial calendar. It's a bidding on an officer case. It's just that we were kind of shut down at the initial phase when I asked the HTC if they would take her back because the other case, the charge was so severe.
Is Mr. Harris wrapped up at all in any of these charges? There's some family violence allegations.
No, Your Honor. It's essentially my client was having a mental breakdown. Her mother called the police. My client spit on the officers, which is where the felony counts came from. And the cruelty was that she allegedly hit her mother, shoved her mother in their house.
Got it. So mom is the victim of the family violence,
Correct.
and then there were kids around when that happened.
Correct.
Okay. Ms. Hall, my thought is that we move this case to a trial calendar, but we preserve Ms. Hubbard's final plea rights. And if there is a negotiated resolution between now and then, you guys can always pop it onto a calendar by working with Ms. Nelson. Does that work for the state?
Yes, Your Honor.
Okay, Ms. Patel, does that work for you?
Yes, Your Honor.
So Ms. Hubbard, Ms. Patel is going to be working with you on your other case to see if we can sort that out, okay?
Yes, sir. Thank you.
All right, thanks for dialing in. You're free to go.
Thank you.
All right, that leaves last but not least, Kayla Johnson, who is on the call. There she is. And Mr. Ensline, both of you have been very patient. We've been dealing with all the press of business today, but it is now Ms. Johnson's turn. Let me call this case up and we'll figure out what's going on. 024. Mr. Lee. Okay. All right. Ms. Convery, this is why you're still here. Okay. What is the state think is happening with Ms. Johnson's case?
So, Mr. Entwine and I have been in close contact about the case file complete, all of that. Probably this case needs to just track with Mr. Lee if possible. I know we announced, or the court announced at the last calendar for Mr. Lee, he would be on that June trial calendar, where we're like on a list for early June. And so I kept an offer open until like a week or so from now.
Who represents Mr. Lee?
It's Florio, Thomas.
Okay.
Florio. Yeah. And
Is Mr. Lee only in this case, or does he have multiple cases? Just this one. Would you be seeking to sever?
hopefully Ms. Johnson's position is a resolution.
Okay.
But yes, it should be against the trial. She would be a testifying.
So we could seek to put Mr. Lee's case on one of these up. He's in custody.
He is in custody, and Your Honor, I think announced that he would be on the June 7th, maybe, trial calendar.
Okay. Did I already submit that one? I think I did. I'll look.
I only remember because I expired my offer like a week or so before then, so I couldn't
Okay.
get ready.
Okay. Yes, he was added on May 4th. I sent that to the gatekeepers. So Lee only, not co-defendant, is what the email said. Okay. So what you're suggesting is we preserve Ms. Johnson's final plea rights. The incentive to resolve it is there's a trial date coming and you may want Ms. Johnson's testimony. Don't know what the state's going to want, but that may require you to negotiate more with Mr. Ensline. Ms. Johnson appears is on bond, so she has a little more liberty than Mr. Lee does. Mr. Ensline, does that work for you if we maintain Ms. Johnson's final plea rights, meaning if this results in a plea, she has the right to withdraw her plea if I sentence her to more than what you're asking for on her behalf, but we just let this case track with the co-defendant's case?
Yes, Your Honor, that works for us.
Okay. Anything else you want to say? You had to wait so long to talk. If you want to say more than yes, this works for us, that's okay.
Yes, Your Honor. Actually, there was talk of a June 7th trial date. I would just like the court to know that I have filed with the court a leave through June 7th, but Ms. Convery has noted that if Ms. Johnson's testimony is required, that it is highly unlikely that that would be needed prior to June 7th. Or sorry,
Correct.
prior to June.
Right. So the way we have to work it, because of the space restrictions we've got, is that June 7th, if this is the case that goes, and it's not going to be the oldest one on our calendar, is that all we do that day is jury selection. So the earliest Ms. Johnson would need to testify would be the 8th, or it's a 2-week calendar, the 15th. So I appreciate you flagging that, and it gave you more to say, but I think we're going to be okay.
Perfect, Judge. Thank you.
Ms. Convery, anything else in Ms. Johnson's case?
No, Your Honor.
Ms. Johnson, you remain on bond. I'm confident that there are conditions on your bond. Make sure you continue to comply with all those conditions, and you just keep your lawyer posted as to what's going on with the case, okay? All right. Thank you, Mr. Ensline, for your patience. Thank you, Ms. Convery.
Thank you, Judge. And just for one last thing for clarification, we do not currently have a date to come back, but with that eyeballing that June 7th date, is that correct?
Correct. What's going to drive this now would be Ms. Convery and her team getting ready for the Lee trial. And if she needs to try to work something out with you and your client before then, we'll get you in front of me so we can take care of that. But you're right. You do not have another court date at this point.
Perfect, Judge. Thank you so much.
See you guys.
Thank you.
Bye-bye.
You do? Voluntary. So, but that's not gonna be a motion.
I don't think that emotion. Because I probably can. Are you still?
I can sign the sentence however you want. I can't e-sign it here. I have to be back there to e-sign it. Just because I have to figure out how to get that file out here, but I'm happy to manually sign it. Whatever's easier for you.
I printed it out there. All the others I'll just send like.
Okay.
They gotta be together first.
It was nice that we closed out that Canon case.
Thanks, colleagues.
I also felt bad for poor Ms. Hilton. Like you got bounced from person to person to person. I really felt bad for your client actually, that because there's been that transition.
Thank you.
I mean, it all worked out. Like, once she was able to get on, I think they would have my things being still to anyway.
Yeah.
So
Yeah. That was the right place for it to end. Please do. Yeah, we're going to take a quick break and we'll figure out what's happening. Yes, ma'am. He did, and I'm going to send an email back to everyone on there so you get it. He's going to have to file a motion, but it's consistent with the email you would have received last night from me. There's no lawyer we're going to force to go to an in-person jury trial, but you don't just get to flap your hands. He'll need to file something, and then I'll move it onto the judicial hold. And then the burden is on Mr. Melnick to let us know when he and Mr. Carter are comfortable trying the case. And then you don't need to worry about it anymore. And it's not showing up saying, McBurney, you got this open case. Why aren't you moving it? Well, I'm not in a position to do so. So it will come off the calendar. Pardon me?
No conference tomorrow. Or wait until the
It may just be easier for us to talk about it then, because I'm not going to be able to do it today. We've got Ms. Love, and then we've got, are you the one who is here with Mr. Shepherd? How many motions is it really?
one.
Okay, good.
And I doubt that we're moving forward.
Okay, great. So we'll let you know. If you don't hear from us, please dial into the pretrial conference. But if you get an email saying it's off because, great, but this has been a zany week. It's too loud, or she just doesn't.
All right, I'm gonna leave the bench for a few minutes. There's that, and this is the indictment. Oh. Ms. Love.
Hi, Judge.
How are you?
Well, how are you?
I'm also well. So do we have an Illinois detective walking around in Georgia soil?
We do, in fact, and we also had to take a simmer.
Cast the superstars. More importantly, I guess, do we have Mr. Hodge? Okay. Will you guys get a lunch break? And then we'll spell you out. I'm gonna take a quick break, but we have stuff sort of scheduled back to back. Welcome to presiding. Will someone relieve? Okay. You're not shaking your head at all. Yes, you will. Okay, good. I gotta give the court reporter time to refresh, because she's gotta be here for all of it. So we'll take a few minutes, but then we will start with the Hodges matter as soon as we get the court reporter out, and then if Mr. Franklin's ready to go and you're ready to go on this level, we'll do that. So don't stray too far.
Thank you, Judge.
You're welcome.
Judge McBurney, I have a question. This is
Yes,
Ms.
ma'am.
Crawford. I wanted to know if I'm needed for the remainder of this.
Let's ask Ms. Hall. You're not needed for Hodges, so you can take a break. Is Miller gonna be a plea? And so should Ms. Crawford plug back in for Miller?
Mr. Shepherd insinuated one for on the non-negotiable plea, so I'll say yes at this moment. So
Okay.
we're still discussing it, so it may change.
Okay, so if you could be back around 1:30-ish, that would be great, Ms. Crawford.
Okay, thank you.
Thank you.
Okay, let me make a copy. I'm gonna make a copy right quick.
Here's this thing. You gonna bring it up?
Yeah.
Is that misdemeanor probation? It is, great, excellent.
I'm gonna sit over there and watch for a little bit. I'm gonna sit over there and watch for a little bit. Need any help with anything?
I think they misplaced my actual motion.
You want me to pull it up on Odyssey?
Yeah. I don't actually need it. It's kind of a bit.
Right. Long time no see in person.
I know. It's different. I have to think everything backwards now.
Really?
How do I do this? It's
Too much. You like it better.
emailing and e-filing and all that. So now I'm here and it's like, okay, give me the indictment. And I was like, okay, I got one here and then I got. It's probably less more time.
Right. But it was easier if you could just send a copy, send it, print it. Yeah.
Yeah, but I mean, I kind of like to be around people again. I mean, you know, haven't been that for quite a while.
Right.
And she said that too. I didn't like it.
Is it Cherry Hodges or did I get that wrong?
it's very hard.
Okay.
Scroll down, it's filed in January.
Okay. Let's see.
January
Getting
2021.
closer. Right here.
Yeah.
Oop. Mhm.
Do you need help with anything, Ms. Rivers? Did you need help with anything, moving anything? Did you need help moving anything? Yes, ma'am. I've done this with you before. The description is of a dark skin, has dreads, but of course the pictures don't have dreads. But the one description is of a dark skin person. Just tell me that's what we're in.
There's like a, oh God. Like how is this guy even in there?
How is he even in there?
And the quality of these photos is straight shit. When I had this issue where the woman described my client as medium to light. My client was very dark. And like the detective who was a Black man, I was like, is my client medium to light? I don't know what that means. I was like, Is he darker than you? Yes. Well, what would you consider yourself? Well, that's just based on anyone's interpretation.
But then you're using somebody's interpretation. You
Like,
understand what I mean?
what? It was so frustrating.
Oh, no. Oh. It's a yes. And I gotta go. And also, yeah. Oh, yeah, yeah. Yeah. And we got to who was, but it wasn't. Oh, because we had all these people. And all people giving them names up. I mean, what was it? People didn't like had for two before. No, ma'am. It was all of us. We had this. No, did not understand the kind of vision. I was wondering why she sent that. Like, she did, by the way, this is. I'm sorry. What's that? If she knows where it's yeah. Where's this in here? Here. Oh, hey. Not at all. He is uncharacteristically cool and smooth.
Hello.
Thank you again, Mr. Franklin, just for being this regular. I appreciate it.
Don't thank me, pay me in offers.
Do what?
I said, don't thank me, pay me in offers.
I can't do it. That's illegal. Are you all currently representing your mom?
I'm sorry,
Are you all currently representing your mom, the spa case?
not me.
Oh, no, I'm at the PD's office. So did he hire?
I have no idea.
I don't think we'll. I don't know if we'll keep it if they.
You have it now? Yeah.
I think that
You
Liz
know what?
Markowitz.
Liz did talk to me.
Yeah.
I know she did.
Liz Markowitz went there, but you know, if it becomes a death penalty case, we will not have it.
I see.
So,
We see.
yeah. But I heard that that's in grand jury today or something,
Yeah.
right?
Yeah. Here in Cherokee.
Is it grand jury in both counties today?
Mm-hmm.
He's physically still in Cherokee though, right?
Hmm?
He's physically still in Cherokee though, right?
I don't know. That's a good question, because I was under the impression that for whatever reason, he had been brought here and had like something, birth appearance or something.
I think he was brought here, but I don't know if they just loaned him out and took him back.
Because that was the time when I thought I saw Keith's name on it.
Right.
Yeah, I know Liz did have a conversation with him. She did talk to me about that.
Yeah.
She was gonna let me sit with him.
Oh. It seems like that won't be the case anymore this time.
Yeah, that seems that.
It's not care.
Oh, Devin, I'm just going. Officer or Sergeant Montiel has his interview that he recorded the interview. So rather than show him mine and have him, you know, he's gonna just give it to me. And I will label. And here, I'll give you the case law I intend to give to the court too, just for argument's sake. Wait, what's your motion? I gave you 3.
It was here, Newton, Roseboro.
Okay, here's Westbrook, and then there's Thomas. Here. And, I'm going to be showing, asking to admit. It's not it right there. Here it is. So this is the lineup that I'll be marking as this exhibit 1. And here is the ammunition that I will mark as.
Did you have not order on purpose? Like a judge, you
I
want
asked-
2, 4, 6, 5?
I asked APD, Cheryl Hampton Barber, their legal assistant, to scan it to me exactly as it was in the file. And I don't know if Zimbrick had taken it out of order. I intentionally just left it just like that.
I get why he would be in the back, but I don't know why it's the 4, 6, 5.
Right, right. And let's see. the admonition that I showed here. Here it is.
Did he send it back?
Yes.
This is the one he was sent back?
She had a FedEx, a folder.
I remember he said something about he was going to pre-stamp, pre-paid FedEx.
Right. And so, that's exactly as it was.
I totally forgot I'm duty. Good luck on please watching on YouTube if he decides to live stream it.
See you later. See you later.
Later.
And they're out there in the hallway. I don't know if you want to ask any questions beforehand, but they're sitting out there on the bench. Like, right, you know, where that's.
Make sure you don't have the stuff streaming all over.
So the admonition will be State's Exhibit 1. The photo array will be State's Exhibit 2. And the recorded interview that Montiel has right now will be State's Exhibit. And that's all that I intend to introduce. Hey, how are you? Good, I am good, thank you. Happy that I can fit a suit post-COVID, because I'm busting out of everything.
Right, me too.
I'm telling you, being at home was good and bad. Not bad, and so I started trying to get dressed for work. Terrible. Okay.
Just us?
This love step out in the hallway. She said the office outside. Not sure.
judge can, the court instructs, whether the court has a preference as far as masks are concerned for our witnesses.
Sure, my preference is that we all be heard. And so if you find that it is easier for your witness to be heard, to have his or her mask off while on stand, that doesn't bother me at all. I'll have mine on just to help out, but when you're questioning a witness, you don't need to have it on, and witness doesn't need to wear one. Assuming the witness is comfortable with that, I won't require it to come off unless it's really mumbling, and we may say, you gotta do it.
Thank you.
Unless it's a retired APB detective in this case, the mask has to stay on for an eye shield as well. I'm disappointed that Mr. Franklin didn't agree to remote testimony.
Oh, Lord.
So, are you ready to go, Ms. Love?
Yes, Your Honor.
Mr. Franklin, you good?
Yes, sir.
Okay, if we can bring Mr. Hodges out for the start.
Ready when the court is ready, Your Honor.
All right. 1 second. All right, Mr. Rivers, you ready? Okay, so we are going on the record. Day 2 of 19 SC 166924, State versus Jerry Hodges. Hello again, Mr. Hodges.
How you doing?
Good to see you. Mr. Hodges was here yesterday, as was Mr. Franklin's lawyer and Ms. Love, prosecutor. We were set or scheduled to go forward on Mr. Franklin's motion to suppress identification testimony. There was a Miss Canada who purportedly picked Mr. Hodges' photo out of a lineup or an array in 2019 in Illinois, where she lived at the time. But for that, we needed a detective, I think he's a sergeant now, from Buffalo Grove, Illinois, and he wasn't here, but he's here today. So we'll hear from him. I think this case is going to call witnesses the state wants to call. We may hear from the detective who was running the investigation, the whole case investigation from the Atlanta Police Department. However we hear it, I think that's what we're moving forward. Mr. Franklin had asked that I grant the motion because it was the second time that we had convened in an effort to move forward with the motion. The first time there was, I think, understandable confusion because the two sides had discussed about having, no, it wasn't that, it was that the detective had a family issue and couldn't be here because he had a family issue to work through. And Mr. Franklin very graciously said, I need him here. So that sounds important and we'll bump it in a few months. But then there was an oversight on the part of the state and this sergeant from Buffalo Grove was not here. They, state was given 24 hours to make it happen, and awesome hours at the state. I'm told that, we do have Sergeant Montiel, here, at the appropriate time. But as I understand it, the essence of the argument is about a pretrial identification made by Ms. Canada that was made through some form of photographic array or lineup. And unless there's anything else you want to get into the record before we start with this, I did not grant Mr. Franklin's request. He grants his motion because his state was unable to proceed yesterday. I felt it appropriate given the stakes and the fact that we had 1 day, not 3 more months, to Mr. Hodges' stay in custody to give the state that extra 24 hours. So your request is noted, and I am not granting the motion in essence by default because the state wasn't ready to proceed yesterday because they are ready to proceed. It's not quite been 24 hours. But anything else you want to get on the record?
The only other thing that I want to mention, Your Honor, in my written motion, I used a template and I didn't change the witness's name, so it says witness Dow, D-A-O, which should be witness Canada. But other than that, I just want to acknowledge that scrivener's error, and that I intended to put Miss Canada's name and not the other witness's name.
It's Miss Canada through and through. All right, Ms. Love, when you're ready.
Thank you. State Policy Detective.
Brett Zimbrick, Z-I-M-B-R-I-C-K.
Is the mic on?
It is on. Okay. You just got a little closer.
I got you.
Good morning, Detective Zimbrick. How are you?
Good. How are you?
I'm good, thank you. Detective, would you start off by telling the court where it is that you are currently employed?
I am unemployed. I retired.
And from where did you retire?
City of Atlanta Police.
When did you retire?
Retired in 2016. I went back under a contract to continue working in the homicide unit, and I left there in April of 2019.
How long did you work for the City of Atlanta Police Department?
In total, 33 years.
And what was your position there when you retired in 2016?
Homicide investigator.
How long did you work as a homicide investigator?
25 years.
And were you peace officer standards and training certified or certified as a law enforcement officer for the state of Georgia the entire time that you were at the Atlanta Police Department?
I was.
Did you serve as lead detective in a homicide of the victim, Malik Buchanan?
I was not originally assigned the case. I picked it up as a cold case.
Okay. And when did you pick it up as a cold case?
In November of 2018.
When you picked it up as a cold case, did you take any steps to further the investigation?
I did.
And did those steps include photograph arrays to show to witnesses?
Yes.
Which witnesses is it that you were trying to determine the need to show photo arrays to?
There were 2 actual eyewitnesses reported in the original file that had witnessed the shooting of the victim, Corey Goodwin and Canada, Kristen Canada. So those were the 2 that I focused on.
Okay. Now, were Corey Goodman and Christine Canada in the city of Atlanta at the time that you began working on the case?
No.
Where was Christine Canada?
She was in Buffalo Grove, Illinois, attending medical school.
And where was Mr. Goodman?
He was in Alabama.
How then did you go about attempting to ascertain whether they would be able to recognize anyone in a photo array?
I was able to make phone contact with both of the witnesses prior to any photo identifications being presented. Was able to re-interview both of the subjects over the phone to get their recollection of the event to see if it would be advantageous to continue the follow-up of the investigation, whether or not they got good looks at the victim or at the suspects, and whether or not they could recall the incident itself. Sometimes over lengths of time, people have a tendency to forget. Both of these witnesses appeared to recall the event with clarity, and I decided to proceed in following up with them at a later date.
I'm going to skip ahead to the outcome of the presentment of the photo arrays to ask you whether or not either of the witnesses made any sort of identification after reviewing the photo arrays.
Ms. Canada made an identification.
So let's talk about Ms. Canada. When you spoke with her prior to her viewing the photo array, can you tell the judge what information that you gave to her?
I had advised Ms. Canada that we were picking up the case file and reviewing it to see if there was anything that we could do to further the investigation. Asked her about her recollection of the case. She recalled the events as they happened, as she had dictated back at the original date of the homicide to the original detectives. She indicated that she was living out of state and attending school. I told her that there was some physical evidence that we would process and hopefully lead us to a possible suspect or suspects.
At the time that you gave her that information, did you give her specific details about the defendant or any other suspect that you believed involved in the homicide?
No.
And did you indicate to her that you had in custody someone that you wanted to see whether she could identify from a photo array?
There was nobody in custody on this case, but we had photos, a photo of a possible suspect, but we didn't indicate that we knew who was involved.
At the time that you spoke with Ms. Canada the first time prior to her looking at the photo array, had you already put together the array that you intended to allow her to see?
No.
And so following that, were you in any way able to hint to Ms. Canada or tell Ms. Canada or reveal to her which photo in the array that she would later see would be that of the defendant?
No.
Given that Ms. Canada was out of state, what did you do to further the identification process?
Once we had identified a possible suspect, I made contact with the jurisdiction where Ms. Canada was currently living, Buffalo Grove Police Department in Buffalo Grove, Illinois. I was directed to the detective division where I advised them of my situation and asked if they would present a photo lineup to a witness of a homicide, and they indicated that they would be receptive to doing that. Arrangements were then made to FedEx the 6 photographs and the admonition form to Buffalo Grove Police Department. I contacted Miss Canada and advised her that the Buffalo Grove Police Department would be contacting her, so she would answer the phone, obviously. And then the lineup was sent to Buffalo Grove. There was nothing in the FedEx file or package other than the admonition form, the 6 photographs. There was no indication of which photograph was the person of interest, and there was no identifiers on the photographs themselves.
Were there numbers on the photographs themselves?
I believe so, yes.
Okay. I'm going to show you what has already been marked as State's Exhibit 1 and ask you if this document is the sort of document that you sent to the Buffalo Grove Police Department as an admonition.
This is the City of Atlanta photo lineup admonition form that we used and used at that particular time with the City of Atlanta Police Department. And this is, in fact, the blank photo lineup that was sent to Buffalo Grove, Illinois.
After the photo array has been presented to the witness, Was the admission form and the photographs that were shown to the witness sent back to you?
They were returned via FedEx, yes.
And State Exhibit 1, the admission form that you received from Buffalo Road Police Department.
It is.
Your Honor, at this point, the state moves to admit State's Exhibit 1.
Mr. Franklin, any objection to State 1 for the purposes of this hearing?
No, sir.
It's admitted.
Would you read into the record what State's Exhibit 1 admonishes witnesses concerning?
The admonition lineup form, you are about to view a group of photographs to see if you can make an identification of the person who is involved in the crime now being investigated. This group of photographs may or may not include a photograph of the person involved in this crime. You should only make an identification if you can do so. You may not talk to anyone while viewing the photographs. Since hairstyles, beards, and mustaches are easily changed, the photographs you are viewing may or may not depict the hairstyle or the facial hair similar to that of the person who is involved in the crime being investigated. Also, note that photographs do not always depict the true complexion of a person. It may be lighter or darker than shown. Pay no attention to markings or numbers appearing in any particular photograph. Do you understand? And there's a place for a signature.
Thank you. I'm going to now show you what's already been marked as State's Exhibit 2 and what has previously been shown to the defense. And I'll ask you if you recognize this exhibit, which consists of 6 photographs.
I do.
How do you recognize it?
These are the 6 photographs that I presented to the Buffalo Grove Police Department.
Is there any substantial variation to those photographs today from the time that you sent the photographs over to the Buffalo Grove Police Department?
No.
Your Honor, at this time, the state tender State Exhibit 2, which consists of 6 photographs, as evidence.
Mr. Franklin, any objection to State 2 for this hearing?
No objection at this time. I do have some follow-up questions before admission, though.
Before it's admitted for purposes of this hearing?
Yeah.
Okay. What I'm going to do is I'll admit it subject to your cross-examination. I'm happy to. I won't look at it until you ask questions, and then if I need to reconsider that, I will.
Thank you, Judge.
You're welcome.
Detective, when you sent to Buffalo Grove Police Department the photographs that are depicted in State's Exhibit 2, did you send them to the police department in the way that they have been presented to you, and that is stapled at the bottom left-hand corner of the photographs and with an exhibit sticker on the front?
No.
Would you tell the court how it is that you sent those documents or those photographs to the Buffalo Grove Police Department?
Each photograph is on a single sheet of paper. Each sheet of paper was in an individual manila folder. So there was 6 folders. Each one contained one of those pictures and the admonition form.
Were the folders, the 6 folders containing the 6 individual pictures, identical to one another?
Yes.
Was there any writing on the exterior of the folders that would indicate to either the person administering the photo array or the person viewing the photo array that would indicate which of those photographs was a photograph of the defendant?
No.
Would you tell the court, and if you need to look at the exhibit again, which of these 6 photographs is the photograph of the defendant in this case?
It's numbered 3 and it's at the back.
How did you choose the photographs that are depicted in State Exhibit 2?
The photographs are picked by a computer from the desktop at the office. You enter parameters that you're looking for age, obviously race, sex, hairstyles, that kind of stuff. Gives you a group of photographs that you can then scan through manually until you find individuals that have similar characteristics. You wouldn't put a 50-year-old man in a photograph with a 20-year-old kid. I mean, it's just, you're looking for similarities on all 6 of the photographs so that none stand out.
And did you personally make an effort to put together a photo array in which the defendant's picture did not stand out as readily different from the rest?
I did.
At the time that you chose the photographs for the array, did you use or look for a picture of the defendant taken in the year that you were investigating the case yourself?
Right. The purpose was to locate a photograph of the individual closest to the time of the offense, which would be more representative of what the individual looked like at the time of the crime. So you wouldn't use a picture of an individual when he was 30 as opposed to when he was 17. You would try and use whatever picture is closest to the time of event.
In general, when you are looking for photographs to put in an array, is there a particular place that the computer pulls from to generate the selection of photographs that you then choose to place in the array?
Just the database that it has available to it.
And are mugshots or pictures taken when a person is arrested, are those type of photos generally a part of that database?
Yes.
What happens when you have a suspect who at the time a crime was committed had not been arrested or was not an adult?
We have access to the juvenile records. We were able to obtain a photograph of Mr. Hodges from YDC, I believe is where we got it.
Okay. Were you anywhere in the room at the time that the photographic array was shown to the witness, Christine Canada?
I wasn't in the state.
Were you on the telephone or on a Zoom or other virtual link with the officer at the time or with the witness at the time it was shown to her?
No. And can I go back to the picture of Mr. Hodges?
Yes, please.
He was arrested for a subsequent event after the homicide.
Objection relevance.
Or the picture was from 2007, but it wasn't from YDC. It was from the arrest records of the City of Atlanta Police. So the picture came from the city's database.
Okay.
So overruled, I wasn't sure. We've already done the 404B in this case. I didn't think you were getting into for 404B purposes. You're clarifying, your recollection is that it's in there. That it's not a YDC photo, but I'm aware that there were a couple other incidents litigated, whether those were coming.
There was, and the database turnover based on updates of equipment and assets over at the City of Atlanta, it came back from a different database that what we were using to fill our pictures. So,
what features did you look for in the photographs that you selected from to determine which photos you would place in the array?
we were looking for age range, sex, race, facial hair, head hair, just general appearance. No eyeglasses. None of them are wearing eyeglasses. All of them are clean shaven or fairly clean shaven. Hairstyles are similar. Age range is similar. So just the basics is what we were going for there.
Do you remember what age the defendant would have been in 2007 at the time that the crime was committed?
17, I believe, 16 or 17.
Okay. If you indicated in your reports that it was 15, would that be accurate?
Born in 91. 16, I guess, if he was born in 91.
And regarding your knowledge of the defendant's hairstyle at the time that the crime was committed, what did you understand the witnesses to have reported the defendant's hairstyle would have been, or the shooter's hairstyle would have been?
I don't recall off the top of my head. And I don't have the witness statements here in front of me, I'm sorry.
If you indicated in the documents that you turned over to the district attorney's office that the witnesses reported that the shooter had short dreadlocks, approximately 2.5 inches long, would that have, if you indicated, or if that was indicated in those documents, would that have been accurate?
That's what would have been told to me, yes.
And if that were the case, is there a reason that you have no pictures of persons with dreadlocks in this photo array?
Because the suspect in his photograph had no dreadlocks in his photograph. So the hairstyles are all consistent. And like we talk about in the admonition, you're looking at the face, not the hairstyle or that kind of stuff. So that's what we were going for there.
And do you recall a witness indicating that she may have seen flashes of what could have been gold teeth in the person that she saw shoot the victim?
Yes.
Is there any picture in this photo array displaying gold teeth on the person depicted in the picture?
No.
Would you tell the jury, the court, why that is?
That none of the photographs containing gold teeth is that the suspect or possible suspect at the time, his photograph didn't indicate gold teeth in his photograph.
And in fact, is the photograph containing a picture, is the photograph of the defendant in this array one where his mouth is open or closed?
I don't recall.
I'll show you State's Exhibit 2 and ask you to take a look at it and just state for the record.
All 6 have a mouth closed.
And you put in photographs of persons with their mouths closed because the picture of the defendant is one wherein his mouth is closed?
All remain consistent, yes.
Okay. Detective, that is all that I have for now.
Right.
And Your Honor, I will leave State's Exhibit 2 on the podium so that if Mr. Franklin wants to use it, he can.
Sure. I've got one question before Franklin goes. There was a Mr. Goodman that we got to in Alabama. Did he get a lineup and did he pick someone, or after your interview you thought, let's not send this guy a lineup?
No, we went out and physically sat and talked to him and showed him a lineup, and he was unable to identify.
He picked no one.
No one.
Okay. And would he have seen pretty similar pictures, the same 6 pictures?
Same.
Same 6.
I have copies of the same 6, but not these 6, but it's in a different order. I'm sorry.
Afternoon, Detective.
Mr. Franklin.
I'm gonna go over some of the questioning that Ms. Love initiated first before I kind of get into my own spiel, okay?
Yes, sir.
So, as I understand, you took over the case in November of 2018, correct?
Yes, sir.
And around that point in time, that's when you, I guess, you just got the old files from, I guess it was Detective Mathis and I think it was
Gentili.
Okay.
The file is kept in a room, and those were the detectives that had worked on it prior to me.
Okay. And so whatever was in those files is what essentially composed your understanding of the case at that moment in time, right?
Yes, sir.
Okay. Okay. Beginning, I guess, your initial exposure to the case, you understood that one of the witnesses that made an identification back in 2007, correct?
The incident with Detective Mathis going and interviewing somebody because one of the witnesses had picked somebody.
Correct.
Yes.
Okay. So the report wasn't entirely clear. It wasn't as thorough as the report that you prepared. What kind of lineup had been done in 2007?
None.
None.
This individual, my understanding, the witness,
And which witness are we referring to, Mr. Gooden, or that would have been Miss Canada, because that report wasn't clear as well.
and I don't think it was either one of those two that identified somebody back in 2007.
Okay. And what makes you believe that?
I believe the yeah. It's not identified in the supplemental report by Detective Mathis, so I guess I misspoke, but Gooden never identified, said he was a part of that. He didn't discuss previously identifying anybody, and I know it wasn't Miss Canada. She didn't previously identify anybody either.
Did you speak to her specifically about that?
Correct. Okay. Asked if what kind of follow-up had been done with Miss Canada by the previous detectives, and she said very little, if any. And to tell you the truth, I didn't know that the deceased was her child's father. It wasn't mentioned anywhere in the file until we spoke. So she obviously didn't relay that information to any detective either.
Understood. Okay, so as part of reviewing that portion of documents, you also, I guess, did a follow-up on the fingerprints or some to that effect, right?
The fingerprints that were never identified, yes.
Okay, and that is how you came to develop Mr. Hodges as a suspect, right?
Correct.
Okay. Now, when you develop Mr. Hodges as a suspect, you describe kind of using a computer system to find filler photos that would be similar to those of the one that you found from Mr. Hodges in that period of time.
Correct.
Okay, and I think you made mention that you could search for filler photos based on age and race and sex.
Yes.
And maybe like facial features like hair or something like that. Right?
Correct. It asks several different questions. You can actually put a height and a weight in there. Not that a photograph's going to get you a height, but it'll give you, taller fellas that have elongated faces, that kind of stuff. So you can put all of the parameters that you want to put in there.
Okay.
I basically go with age, sex, race, and facial hair and head hair. So you can put afro, or you can put dreads, or you can put bald, or you can put, wavy, whatever you want to put in there.
Okay. Once you identified Mr. Hodges as a suspect, you weren't able to identify any other photos where he ever had dreads at any point in time, right?
That I recall is correct.
Okay. You understood that Miss Canada mentioned that the suspect that she saw may have had gold teeth.
Correct.
Never found any photos of Mr. Hodges ever having gold teeth at any point in time, right?
Correct.
Okay. And you indicated that the parameters that you typically use would be age, race, sex, facial hair, and actual top of the head hair.
Correct.
Okay.
And then that gives you, 1,000 to pick from.
Gotcha.
And then you can manually roll through all of those and find the ones that, in your opinion, best fit the scenario.
Okay. So it's not as if you type these parameters in and it just gives you 5 photos and those are the other 5 that you have to stick in there.
That's correct. You can continue to roll through and get what you need.
Okay. And so in terms of filler photos, you pick those from a database of what matched the descriptors that you put in.
Correct.
Okay. Now, kind of an odd conversation to have, but I'm gonna go ahead and have it. You've been a police detective for over 30 years, or an officer in some capacity over 30 years.
Yes.
You are a little bit older than that in general and just have general life experiences, correct? Knowing that Mr. Hodges was a Black male, you're familiar with the understanding that Black people have a wide variety of complexions, right?
Yes, sir.
And complexion was important in this case because that was one of the descriptions that both witnesses gave of the person they saw, right?
Yes.
Ms. Canada described the suspect as someone who was very dark skinned.
Correct.
Mr. Gooden, though he wasn't able to identify Mr. Hodges in his lineup, he also said that the one thing he remembered was that the guy was dark skinned.
Correct.
Okay. So it would have been incumbent upon you at that point in time that upon these photos of persons that were presented in this database of filler people to use photographs of other dark-skinned people, correct? It wouldn't be fair to put someone of my complexion in a lineup for a dark-skinned Black person. Or would it?
I would not use you in a lineup based on your complexion if the description was dark-skinned male.
Okay.
So I guess.
And I know that talking about race can be awkward sometimes. I'm not trying to catch you up on it.
Yeah, that's not what I'm trying to say. I understand what you're trying to say about the perception of skin tones from a cross-racial identification type thing. And that's what I'm saying is my opinion. If, it was a Black male, dark-skinned Black male, I wouldn't have eliminated you based on what my perception of your skin tone is.
But taking Mr. Franklin out of it, are you driven more by what a witness says the person looked like, or the ultimate photo you're stuck with? If you're stuck with a photo of Mr. Hodges that because of the way the camera works, he's not so dark skinned, will you only get dark skinned folks who don't match that?
No. What we try and do is get the facial features, the hair, similar to that of the person that committed the particular crime, or if you suspect committing the crime. I wouldn't put a very light-skinned male in there, but medium to medium dark, and as you go down that spectrum, I guess I'm not opposed to that because the admonition form clearly states that the photograph may or may not depict the true complexion of the person because of the, like the judge said, the taking of the photographs. So I guess I'm complicating what's trying to be an uncomplicated event. Am I explaining it correctly?
I think I follow a little bit.
It's not like we go out of our way to get 3 very light-skinned males and then 3 very dark-skinned males. We try to be.
Let me ask this. Maybe this question will clarify the point you're trying to make. Because the example I gave you was just kind of this generic, hey, you got a dark skin complexion identification, that's all you got. You found a photo of Mr. Hodges. The objective would be to use filler photos
that are consistent,
that would be consistent with his complexion.
Correct.
As now would it go as far as to, is it still subjective in terms of, hey, in my opinion, this is still close enough to what I view as,
I understand what you're saying,
Mr. Hodges' picture, or would it still kind of go back to, in my opinion, this guy is dark skinned kind of deal? Does that make sense?
Right. My opinion, they're all fairly consistent in the spectrum of skin tone, and the facial features and the hair, that kind of weighs a little bit more in the presentation of the lineup. You have to take into consideration that it's 9:30 at night in March when the event takes place, and the witnesses are actually, one of them is outside an apartment, so lighting conditions at that point. So, you have your picture of who you believe to be your suspect or a possible suspect, and you work around that, and that's what we did here. So I guess my opinion goes a long way in presenting that lineup, I guess is what you're getting at, and that's what I'm saying. Yes.
Okay. You made mention of another fact that's kind of relevant to all of this. So, of course, the witness's ability to perceive a perpetrator is critical to their ability to identify someone in the lineup, right?
Correct.
And so, did Ms. Canada give you any indication that the person who she saw running from the apartment with the weapon, she give you any indication she had seen that person before?
She said she had not and had not seen him since.
Okay. So that would have mean she saw him for this moment in time in 2007. And at least until when you spoke to her and when she did the lineup, she had not seen this person since.
Correct.
Up until 2019, so about 12 years.
Correct.
Okay. And maybe it's just short of 12 years. I think the incident happened in March. Identification, March of 2007. The identification took place in January of 2019.
2019, yes.
Okay, so about 2 months. They're about short of a year.
Correct.
Okay.
And speaking of dates, when asked the age, Mr. Hodges was 16 years old and 6 days at the time of the homicide, based on his age and date of homicide.
Okay. Now you also mentioned that this happened at 9:30 at night, right?
Yes, sir.
Okay. And this is March, so it's tilting towards spring, but not quite spring. So it's still 9 o'clock. It's still dark outside, correct?
Correct.
Okay. And Miss Canada, at the time that she perceived the person running out the house, when she saw that person, she was sitting in her vehicle.
Correct.
Okay. So she wasn't like right at the apartment or walking into the apartment. She was
seated in her vehicle, driver's side, facing the door right outside of the victim's door.
Okay.
The apartment that she was intending to go to.
Okay. And I believe she said she's looking through the windshield, not the side window or anything, correct?
Correct.
Do you know what kind of car she was driving?
I do not.
Do you know if the car had any tint in its windows?
I do not.
Additionally, excuse me, Ms. Love asked you a question about the photos that you actually sent to the detectives in Buffalo Grove.
Yes, sir.
You stated that at the time you sent them, it certainly didn't have an evidence sticker on them.
That's correct.
You stated that you believe that they had a number on them, but that is kind of the source of my objection. You're not sure whether you had them pre-numbered or not?
I did.
You're not certain?
I am.
Okay. And what makes you certain at this point in time?
Wouldn't make sense to number it after the fact.
Okay. Would it make sense if the detective in Buffalo Grove did the numbering?
Probably not. I think the request was just to show the lineup. And the presentation was done on video. So I'm sure we could look and see, but I'm confident that the numbers were on there. They were in sequential order inside of the file folders when they were sent up there.
Okay. Moving back to the photos that were selected in and of themselves as well. You made mention of, we talked about trying to find pictures of people who are similarly complected, and making sure that no photo has a feature perhaps that sticks out more than another. Do you take into account the backgrounds of the photos?
We try our best. Some of them are dictated, like suspects' photos are dictated by what we have available to us. The filler photos, we can actually research the database.
Okay, and that would be the database that has the thousands of photos.
Correct.
Of persons who pulling from mugshots or driver's license photos or whatever.
Correct, and they're all similar backgrounds.
Okay. May I approach the witness, Sean?
You may.
Detective, I'm going to ask you to take a look at the line. I think it was, at this point in time, it's out of numerical order, but photo 1, if you could take a look at it.
Yes, sir.
That photo does not have a discernible background, correct?
Correct.
Photo 2. That's numerical number 2. That photo does have a grayish background that you could see, correct?
Slightly in the bottom left below his ear. I guess the first one's got a lighter background.
Okay. Photo 3, and this would be the photo of Mr. Hodges, numerical 3. Mr. Hodges' photo doesn't have any discernible background, correct?
Correct.
Numerical number 4.
Correct.
This photo does have a discernible light grayish or bluish kind of background, correct?
And actually, the originals have a more distinct background, but there is a background here.
I'm sorry.
I think these have a different tone than those do.
Okay, so the originals have even more so than the copies I have.
I believe so.
Show up. And I'm approaching what I have from myself. So even what you have would show a more discernible background, right?
Correct.
And that's, what you have is what the Miss Canada would have been shown in Illinois, correct?
I believe so, yes.
You believe so?
Yes, sir.
Okay. Numerical picture number 5. Discernible background as well, correct?
Yes, sir.
And numerical lineup picture number 6 also has a discernible visual background, correct?
Yes.
So is it fair to say from our discussion of these photos, Mr. Hodges' photo is the only photo that doesn't have a discernible visual background?
Correct.
Okay.
Number 2, well, 2's got a very slight one, but yes.
Okay. Slight, but it's present.
Somewhat, yes.
Okay. Now, looking at these 6 photos that you have in front of you, and I understand you have to flip through them. Mr. Hodges' complexion, as seen on the paper, is significantly darker than the other person's.
Somewhat, yes.
Okay. Moving on a bit, do you recall the number of times that you spoke with Miss Canada personally yourself before the lineup was done?
2 or 3, maybe.
Okay.
Well, the short conversation where I said Buffalo Grove's going to call you, probably that would add another one, so maybe 4.
Okay. And so I guess your initial conversation, as I understand from your direct testimony, is, hey, I'm Detective Zembrick, I work in cold cases. I'm looking into the murder case of Malik Barry Buchanan.
Do you remember it? Do you remember it? And then that's when she tells me that he is her child's father, and you know where she's living and that kind of stuff. And then we talk about her recollection of the case.
Okay. And would that have been something that was done when you first got the case, like around that November, the early November date that you first got it, or would that have been after you realized that, oh, we got a fingerprint match?
No, it would have been after getting the case, reviewing the case. I'd read through it, see what we had, and then I would call the witnesses to determine whether or not things have changed. Sometimes people say, oh yeah, I saw him at the mall, or, you know, I knew who it was back then, but I was afraid to tell, that kind of stuff. So just to kind of.
Okay. Do you recall, aside from the conversation of, hey, Buffalo Grove is going to contact you to do a lineup, do you recall any other conversations with Miss Canada after you had learned of Mr. Hodges as a suspect?
We had a conversation, and it was probably based on, you know, evidence had been developed and led us in this direction. So we're going to send some pictures up to you.
Okay. So understand that what you just said now is probably not the verbatim, and I'm not trying to play a word game with you right now. But you let her know that since I've gotten the case, we developed some things. We're gonna have these other people show you a lineup to see where things add up.
Right.
Okay. Now with Buffalo Grove Police Department, was Douglas Shipman the person who you primarily contacted in trying to get the lineup done?
Correct.
Okay. And who is he exactly?
I believe he just happened to be the guy that answered the phone that day.
All right, lucky him. Okay. So you explained to him kind of what you're calling for.
Correct, because you're cold calling another department. So you say, this is what we have. You know, we used to get calls in the homicide office from other agencies. So they would divert I didn't know if Buffalo Grove had a specific homicide unit or if they just had investigators. So it got directed to Montiel.
Okay. And you gave him some background on the substance of the case, right?
Yes, sir.
And you did that probably verbally, but also in email, right?
Yes, sir.
When you say you gave him, meaning Montiel or the guy who
Montiel, when we were
you
talking.
were ultimately referred to Montiel, and that's what you mean you gave a little more substantively by saying, here's what we got.
Correct.
Okay. And you, at least with Mr. Shipman, you informed him that you're about to say something.
Well, the emails are between Shipman and then he's CCing Montiel on the emails.
Okay.
So that's where it goes. That's how Montiel gets involved in it.
Okay. So you informed Shipman and Montiel is courtesy copy to these emails to your understanding.
Correct.
You informed them that you're using a photo from 2007, 2008, right?
Correct.
And as you should, you let them know you're sending this admonition and just to read the admonition, right?
Yes, sir.
Now, you also give them instructions about how to inform her to identify the persons in the lineup, to only identify one person and not three.
Correct. Well, correct. That's the standard that we use, is that if there's three suspects in the crime like this event, we wouldn't put all three suspects in the same photo lineup. We would have three separate photo lineups if we had identified all three suspects. We only had one suspect identified through the fingerprint, so that suspect was involved or was included in this photo lineup. And the instructions given were, if she were to make an identification, which person are we identifying? So is it the first guy out of the house, the second guy out of the house, or somebody else, or the shooter, or however it goes? So that was the intent of the instruction.
Okay. So let me clarify this. So you had the prior reports from Detective Mathis and Detective Gentili.
Correct.
You had 2 or 3 conversations with her yourself.
Yes.
Was it not clear already that she didn't have a description for the 2 people that had ran prior, and that she was talking about the one person she saw was the one who she described as the shooter?
Correct. But had she identified the individual and said, oh, by the way, that was the first guy, I was just snapping in my mind, I wanted to know that as well. So I wasn't saying we're looking for the shooter, we're looking for any of the identifications of the suspects if you know them. But yes, she indicated that she would probably be more likely to identify the shooter because he came out and, in her words, looked directly at her and then turned and shot Malik.
Okay. And the regular admonition that was sent with the photos, that wouldn't have been sufficient to instruct her to pick one person?
I would imagine it's just make an identification if you can do so.
Right.
I don't think it identifies a number of people, just we've had lineups before where somebody said, I went to high school with this guy, but this is the one that we're talking about here, that kind of stuff. So make an identification if you can do so is the instruction.
Okay. I think this will be my final question. You, or my final line of questioning. In your career, you've personally administered hundreds, if not thousands, of six-pack lineup procedures, correct?
Yes.
Once a person makes a lineup selection, in my experience, I often see they sign their name to a particular photo within the actual six-pack. Like, presumably, there would have been a signature on Mr. Hodges' photo.
Correct.
Okay. Is it fair to say that that would have been your practice, that if you were personally sitting down, you would have had the witness sign the photo itself?
In most cases, yes. In this case, if I had presented it, yes, the individual would have signed the actual photograph.
Okay. And you gave other instructions to the Buffalo Grove detectives, but you didn't give the instruction to have Ms. Canada sign Mr. Hodges' photo.
Correct. The admonition form that was presented has a place on it for them to physically put the photograph number in the space provided, if they make a selection. And that would also, be confirmation that the photographs were numbered prior to being sent.
I'm sorry, you tailed off.
It would also be confirmation that the photographs were numbered prior to being sent, because she wrote number 3 in the admonition as the photograph that she identified.
Nothing further. Thank you.
All right, before any redirects, because we've got a few indictments to present, we just get those, get these two folks on their way, and we'd love if you've got anything additional for So there was one earlier today. It is back in here.
It's not back.
But it's part of the 17. Which was the no bill, or it doesn't get handed to you. That's the no bill.
No bill doesn't get handed.
Okay, so it's secret. All right. Grand jury on the 8th today.
They did, they were the very first day.
Oh, well, welcome. Congratulations. Thank you, grand jury service. Okay, since I signed this, none of these cases get assigned to me.
Hopefully not.
Yeah.
Now, you gotta keep one of the files.
Oh, what do I keep? That's new. Okay. We practice. Thank you. All right.
Thank you, Your Honor.
Make sure it's I keep waiting. All right, Ms. Love, did you have any follow-up from the case? All done.
I have brief follow-up, Your Honor. Thank you. Detective Zembrick, you were asked on cross-examination about the photo array that has been admitted as State's Exhibit 2 when compared with a series of photographs that Mr. Franklin had in his possession and brought to you to review, correct?
Yes.
The photographs that are admitted as State's Exhibit 2 and the photographs in the array that Mr. Franklin showed to you, would you consider them substantially similar or substantially different than one another?
Of these and those?
Yes.
There's some difference based on the backgrounds that is not present in his.
And would the photographs or would the differences that you see would you attribute those differences to anything intentional that you did with the photographs?
No.
Then to what would you attribute the differences in the photographs Mr. Franklin showed you and the photographs that are State's Exhibit 2?
We don't take this speculation unless he has some expertise that we need to take. Well, I'm also not sure. Mr. Franklin's got copies of copies, so they look a little different. In fact, the backgrounds are more similar in his than they are in what hopefully will become State's Exhibit 2. We're able to get that.
We remove objection.
No more objection. Okay, so State's Exhibit 2 is now admitted officially and thoroughly. State's Exhibit 2, the backgrounds are a little more distinct. I'll be working through how distinct are they and how consequential is that. But I think if I was saying it correctly, things were a little more bleached, if you will, for the copies that Mr. Franklin had, just product of the copy.
Thank you, Your Honor. That's where I was did actually. Detective Zembrek, with the photographs that you have to choose from when picking for photos for a photo array, do you manipulate the photographs in any way in order to ensure that photographs that you deem are similar characteristic-wise are more or less similar to that of the defendant? In other words, would you manipulate the background of all of the photographs in order that they're exactly the same?
No.
Why not?
I don't manipulate any photographs.
Okay. And you also indicated that the photograph of the defendant appeared in the array that you're looking at darker than the other photographs.
He's darker than most, yes.
Okay. And was there an effort on your part to put lighter skinned subjects in with this photo array?
No.
Now, I'm going to show you, or ask you rather, when you presented or showed the photographic array to Corey Goodman, the other witness in Alabama, did you use the same photographs as you used for Miss Canada?
You mean these 6 right here?
No, I mean the same picture.
Same 6 individuals?
Yes.
Not the same actual pictures. Like we didn't hand them to him and then put them in the mail and send them to her. There's different sets of the same 6 individuals.
And did you in fact number those photographs that you sent to Mr. or that you showed to Mr. Goodman?
I believe so, yes.
And do you recall whether the numbering scheme of the photos of the photo array that you showed Mr. Goodman was the same as that you showed to Miss Canada?
Should be different.
Okay. I'm going to show you State's Exhibit 4. And as I'm coming to you, how many people in total did you, during your investigation, prepare photo arrays to be headed to?
I believe it was 2.
I'm going to show you what's been marked as State's Exhibit 4. Just take a look at State's Exhibit 4, which consists of 6 photographs.
Yes.
Now, do you recognize, are those 6 photographs in State's Exhibit 4 numbered?
Yes.
And are the 6 photographs in State's Exhibit 4 depicting the same people that are depicted in State's Exhibit 2, regardless of the order?
I believe so, yes.
And if you want, would you just take a minute and look through?
I believe there's one that's different. I believe there's one that's different. It's hard to look at these without laying them out. I'm sorry. There's one that's different.
Is the defendant's photograph reflected in State Exhibit 4?
Yes,
Now, do you recognize what the collection of photos that is labeled State Exhibit 4, what it is?
I'm sorry, what? Does it
What is State Exhibit 4?
say a photographic lineup of, that contains the suspect and 5 filler pictures?
And who prepared or who put together that array of photos?
I did.
And for what purpose did you put together the array of photos labeled State Exhibit 4?
For Mr. Goodwin, I believe.
Okay. And is State Exhibit 4 an accurate depiction of the photographs that you believe you put together for Mr. Goodwin?
Yes.
Do you see any material difference from the photographs that you prepared to show to Mr. Goodwin?
One of the filler pictures is different than the filler pictures in the original lineup.
But is that the photograph of the way you showed to Mr. Goodwin?
Yes.
Your Honor, the state tender State Exhibit 4 is that.
No objection to State 4 for this hearing?
No objection.
Submitted.
In State Exhibit 4, are all of the backgrounds of the photographs identical?
No.
And looking at complexions, are there slight variations in the complexions, or are there huge variations in the complexions?
Slight variation. Yes.
And in terms of a comparative analysis, is the defendant's picture in State Exhibit 4 substantially darker than anyone else's? Somewhat darker?
A little.
Not
maybe.
darker?
A little, maybe. In my opinion, not that much darker than a couple.
And would the difference in skin tone between the defendant's pictures in that array and the difference in skin tone between the defendant's pictures in State Exhibit 2 and the other filler photos, would that difference between States 2 and States 4 be similar or very different?
Similar.
Okay. And State Exhibit 4, when it was presented to Mr. Goodman, did he choose the defendant?
He didn't.
Okay. When Christine Canada, did you review the lead detective's file before you went out and prepared these photo arrays?
Yes.
And did part of the lead detective's file include a rough transcript, if you will, of the interviews of Christine Canada and Corey Gooden?
I believe so, yes.
Do you recall whether Christine Canada described the defendant as being, or the shooter as being dark-skinned or very dark-skinned?
I don't recall. I did not review the statements before today. I'm sorry.
Okay. Do you recall whether Corey Gooden described the defendant or the shooter as being dark-skinned?
I don't recall. I'm sorry.
Okay. Sir? I got it. If I were to show you a transcript of the interviews of both Mr. Gooden and Miss Canada, would that refresh your memory?
Yes.
Okay. I'm going to show you page 2 of 2 of Statement of Candidate Christine, and page 2 of 6 of Statement of Corey Gooden. Okay. And I believe that Mr. Franklin has been able to find those. First, showing you page 2 of 2. Would you please read over page 2 of 2 of the Statement of Candidate Christine? Is your memory refreshed as to how she described the skin tone of the person that she saw shooting?
Very, very dark skin.
And showing you page 2 of 6 of the statement of Corey Gooding, specifically in the first line labeled A. Would you please read that to yourself? And is your memory refreshed having read that as to how Corey Gooding described the complexion of the shooter?
Yes,
How did he describe it?
dark skin.
That's all that I have. Thank you, Your Honor. Yes.
Do you have any?
Yeah, 2 lines of questioning is very short. Next one. Okay, 2 quick questions, 2 lines of questions for you, Detective Zimbrick. From Mr. Gooden's transcribed interview, he was also asked about his confidence, his ability to identify the shooter, correct?
I didn't read that. I just read what was directed to me. I'm sorry.
Okay.
I didn't read that part. I read what was directed to me. I'm sorry.
Not a problem. 1 second. If you were able to review it, would you refresh recollection?
Yes, sir.
Okay. Yeah, first time.
You may.
I'm handing you page 4 of 6, and it's the 3rd question. Read it. Let me know if it refreshes your recollection as to Mr. Gooden's ability to identify anyone.
Okay. Yes, sir.
Okay. He wasn't confident he could identify a person, correct?
You said it's hard to say. It happened so quick.
Okay. Hard to say it happened so quick. Okay. Do you recall from your record, from your memory, what Mrs. Canada's belief was in her ability to find someone through identification?
I believe she said yes.
Okay. Nothing further at this time, Judge.
All right. Thank you, Detective Zimmer.
Sir.
Oh, wait, I have a couple. You were asked about an ID that someone made in 2007. That someone you believe was not Ms. Canada.
Correct.
And it did not involve a photo lineup.
Correct. According to
Hey, do you recognize this person in his pictures?
Detective Mathis was dispatched saying that an eyewitness to the crime had physically spotted somebody on the street and that person was taken into custody by uniform officers. And then Detective Mathis was dispatched saying that your eyewitness has picked who they believe to be a suspect. And the victim's mother was part of that as well, the identification thing. So Mathis went, recovered the suspect, brought him back to the office, took a statement from him, and I guess compared the fingerprints and released him.
Not Mr. Hodges.
Correct.
Did you, in your communications with Ms. Canada, ever send her electronically or through US Post any pictures?
No.
The only pictures you ever sent anyone were to Monty or Montiel?
Montiel.
Okay. And he took it from there?
Yes, sir.
All right. Thank you.
Yes, sir.
Okay, let's keep pressing. We actually are stepping on a motion that was supposed to start at 1:30.
State calls Sergeant Montiel.
Hello, Sergeant. Yes, sir. Thank you for traveling all the way to Atlanta. But on short notice. Yeah, let's say if you're here.
Raise your right hand, please. You swear affirm the person you give me for quote the truth or Please state your first and last name and what you do.
The first name is Tony, last name is Montiel, Montiel. I am a police officer with the village of Buffalo Grove in Illinois.
Good afternoon, Sergeant Montiel. Would you please tell the court how long you have worked at the Buffalo Grove Police Department in Illinois?
I have been there almost 24 years. I'm 6 weeks away from 24 years.
Okay, and if you feel more comfortable taking off your mask so we can hear you clearly.
Okay.
And are you certified as a law enforcement officer by the state of Illinois?
Yes, I am.
Have you remained so certified during the entirety of your time with the Buffalo Grove Police Department?
Yes.
On occasion, did you assist officers from other jurisdictions on their cases?
Yes.
Did you have an occasion to assist in a homicide investigation in the state of Georgia back in 2018?
Yes, I did.
Tell the court what your involvement in that investigation was.
I was contacted by a detective from Atlanta PD on, I think it was December 27th of 2018. He had asked if we could assist in doing a photo lineup with a witness who at that point lived in Buffalo Grove.
At the time that he spoke with you, and was that Detective Zimbrick?
Yes, it was.
At the time that he spoke with Detective Zimbrick, did he indicate to you which photograph of the photographs that he sent you contained a picture of the suspect in this homicide?
No.
What sort of information did Detective Zimbrick give to you about this case?
Detective Zimbrick was vague on purpose. He asked if we would, we could contact the witness directly, coordinate a date and time where she could come to the police station, Buffalo Grove Police Station, and administer a lineup per Atlanta's protocol.
And once you received those photographs, did you administer a lineup to a person by the name of Christine Canada?
Yes, I did.
Prior to beginning her review of the photographs, did you read her or tell her anything?
I did. Along with the photographs that Detective Zimbrick sent me, there was a Atlanta, Georgia admonition form, photo lineup admonition form, I believe is what it's called. So I did. I read it verbatim. I explained it to her. She signed it, provided her with the 6 photographs, and I exited the room.
I'll show you what's been marked as Stacy Exhibit 1 and has already been admitted as evidence, and ask if you recognize this document.
Yes, this is the document I read to her.
Do you recognize any signatures on the page?
I recognize Ms. Canada's signature, my signature, yes.
And are you and Ms. Canada the persons who filled out this form?
Yes.
And what did you do with it once you filled it out?
The form was sent back to Detective Zimbrick that day. It was January 3rd, 2019, I believe.
Thank you. I'm going to now show you what's been marked as Stacy Exhibit 2. And ask you if you recognize Stacy Exhibit 2.
I do.
And what do you recognize Stacy Exhibit 2 as?
These are the photographs that I showed to Miss Canada.
When you showed the photographs to Miss Canada, did they come assembled with a staple at the bottom left-hand corner?
No, they were individually placed in 6 separate manila folders, I believe.
And when you began showing the photographs to Miss Canada, did you indicate to her that a picture of the shooter is contained within those photographs?
No.
Did you give her any indication as to the identity or your belief of the identity of any persons depicted in those photographs?
No.
And I believe you stated earlier you did not know who was in those photographs. Is that correct?
Correct, I did not.
Was the interview of that you conducted with Ms. Canada, wherein she was showing the array video and audio recorded?
Yes.
I'm going to show you what's been marked as Stacy Exhibit 3, and ask you if you recognize Stacy Exhibit 3.
I do.
How do you recognize Stacy Exhibit 3?
This is a copy of the interview that I conducted with Miss Canada. This is my writing on the DVD.
And did you in fact bring that interview to Georgia with you when you came there?
Yeah, yes, I did.
And so did you review that interview before you brought it in to the courthouse this morning?
Yes.
Is it a fair and accurate copy of the entire interview that you conducted with Ms. Canada?
Yes.
Did you have any conversations outside of that interview room with Ms. Canada regarding her knowledge of this case before or after you conducted that interview?
No.
Your Honor, the state tender State Exhibit 3 as evidence.
Any objection to states 3, Mr. Franklin?
No objection. I believe this is the same video that started the skirmish. Just a copy that we broke here. No objection.
It's admitted.
Thank you. Sergeant Montiel, did Ms. Canada identify any persons in that photo array that's marked Stacy Exhibit 2 as the a person she recognized?
Yes, she did.
And which person did she identify? Do you recall?
Number 3.
And were those numbers on those photographs before you showed them to Ms. Canada, or did you put those numbers on the photographs?
They were on it before I showed.
Once Ms. Canada was given the photographs, did you stay in the room or re-enter the room at any time before she made an identification or selected photograph?
I left the room before she made the identification, and then I returned when she came outside the room to tell me she was finished.
Were you in any way communicating with her while she was inside the room reviewing the photographs?
No.
What happened once Ms. Canada came outside and indicated to you that she had chosen one of the photographs?
I confirmed that number 3 was the one she identified, which she said yes. And then I conducted a small interview with her to ask her some follow-up questions that Detective Zimbrick had asked me to follow up with.
Now, did you ask her or tell her or instruct her to indicate on the admonition form whether or which photograph she selected if she recognized anybody?
I believe I told her, I said, once we filled up the top portion of the form, and then I said, I'm going to leave. When you're done, you fill out the bottom portion of the form, we'll sign it. And then that's what she did. She filled out the bottom portion of the form while I was out of the room.
And I'm going to show you again, Stacy Exhibit 1. Would you please tell the court what the bottom portion of the form that you're referring to is on this form, starting with the first line of the bottom portion? And would you read it into the record?
The bottom portion of the form that I'm talking about is photographic lineup identification. I, Kristen Canada, have viewed a group of 6 photographs. She checked the box that says, I have identified photograph number 3 as being the person who committed the crime now being investigated. I make this identification freely and voluntarily without threats, coercion, or promise of reward. And then we, Ms. Canada and I both signed it and dated it and put our time.
Do you recall before she looked at the photographs, whether or not the admonition that you repeated to her as you saw it on the form included any admonition regarding skin tone or skin color or complexion?
Yes.
And what was that admonition?
Pardon me. Near the bottom of the paragraph that I read to her, it says, also note that photographs do not always depict the true complexion of a person. It may be lighter or darker than shown. Pay no attention to markings or numbers appearing in any particular photograph.
When you reviewed the audio and video recording of Ms. Canada inside the interview room, were you able to observe what she was doing as she was reviewing the photographs?
When I reviewed the video, yes, I'm sorry.
That's what I meant.
Yes. When I reviewed the video this morning, yes, I did.
And at any time did she appear to be comparing photographs?
Yes, she was.
Once she indicated to you that she had made an identification, did you interview her any further?
Yes, I did.
Why?
Detective Zimbrick had asked if we could obtain a few other pieces of information from Miss Canada. I really can't remember exactly what he had asked. I remember that I had asked the questions that he was looking for.
If you see a copy of the notes that you took during that interview, or rather I should ask you first, did you take notes during the interview?
I did.
And seeing a copy of the notes that you took during that interview, refresh your recollection as to what types of topics you all covered after she made an identification.
Yes.
Sergeant, would the conversation you had with Miss Canada be contained on the video that's now in evidence? Or
Yeah.
did the video stop once the identification?
The video continued the whole time.
So everything and anything you discussed with her is now in evidence that I can review?
Yes.
What did you do after you concluded your interview with Miss Canada?
I walked Miss Canada and her children out of the department. Took a matter of 2 minutes, maybe. I told her that Detective Zimbrick would probably be in touch with her. It's possible that I could be in touch with her if he had further things that he needed Buffalo Grove to do. After she had left, I then contacted Detective Zimbrick. I said, I'll be FedExing these documents and video out to you. I did show him a picture of picture number 3. I sent that in a text message to him. He called me, or I believe he called me on the phone shortly thereafter, and expressed his. He was very excited that number 3 was picked by Miss Canada.
At that time, did you learn why he was excited?
That was a suspect.
Okay. Did anybody ever enter the room while Miss Canada was there reviewing photos?
Just me.
And did you?
Not when she was reviewing photos, no. I was the only one.
During the course of your interview?
Just me.
And did you ever see her making phone calls, consulting with anybody while she was reviewing photographs?
No.
Thank you. That is all that I have. Your Honor, I don't need to publish to the court. I can leave to the court to review State's Exhibit 3 if there is no objection from the defense.
You keep looking under there like you're gonna be able to play it on the machine down there. That's not happening. So I will review it. I'm just letting everyone know now. If there's something that
is contested, people can draw my attention to it, but otherwise, it doesn't sound like it's a 9-hour interview. So it shouldn't be something that takes very long. But however long it is, I'll watch it. But that device below the podium will not play on any screen we can see.
Awesome. Thank you, Judge.
Sure.
That's all that I have right now.
All right, Mr. Franklin.
Is detective or investigator? What's your preference on that?
Sergeant.
Sergeant.
Well, I at the time I was an investigator and I recently been promoted. So
Right.
I'm good with Tony too.
I'll call you sergeant. I respect the officer. I know it took some time to earn it. I understand you have a flight to catch at some point, so I'm gonna be as quick and brief and direct as I can be. During your direct testimony, you made mention of the fact that the detective from Atlanta, Detective Zembrick, did not tell you exactly which picture was the suspect in question, right? But he did tell you that his suspect was in this lineup, right? Okay. So you didn't know which one, but you knew one of these 6 pictures was the guy that he was hoping to be picked.
Yes.
And that was confirmed after the identification process, when you sent him the text message, and I think you said he expressed happiness about that, right? Okay. You stated that before the lineup, your communications with Detective Zembrick were vague on purpose.
Yeah, I didn't have any information on what the case was about. I didn't have names of people. I didn't have any information on the case. There was nothing given to me through that. The only thing that was given to me by Detective Zembrick is that they had identified a suspect and now they needed assistance doing a photo lineup because the witness has now been living in Buffalo Grove.
Okay. Were you ever, or do you recall being a party to some emails between Detective Zembrick, yourself, and Doug Shipman?
Yes, I was.
Okay. And in those emails, it was made mention that the photo was one from 2007, 2008.
I don't recall.
Okay.
Shipman and Detective Zembrick started the whole process before I got involved. I don't think I got involved for a couple of days.
Would it be safe to say, and I guess it's my interpretation from reading it, would it be safe to say that you weren't an active participant in the conversation between Detective Shipman and Detective Zembrick?
Correct.
But at some point in time, the conversation may have been forwarded to you, or you were courtesy copied at the end of it to where.
Yes, we were trying to get this done as quickly as possible. Shipman had a forensic interview on a child that on the date that Miss Canada was available. We were trying to work at a point where she was going back to school at a certain day. And so we were trying to move quickly. And Shipman and I had been partners, were partners at that point for about 5 years.
I got you. You knew that there were 3 people that would have been involved in the incident here in Atlanta, correct? Or if you don't recall at the time, that's fine as well.
I know I learned that through the interview I had with Miss Canada. I don't recall if I knew that. I know the email says that. I don't think I saw that email that between Detective Zembrick and Shipman. I know it was mentioned in there because I did review that today, that there were 3 suspects total.
Okay. You reviewed the email between Shipman and Zembrick today?
Yes.
Okay. And you can't recall if you saw that email prior to or not? Prior to the identification procedure or not?
Back then, I don't recall.
Okay. But then, I guess there were some questions that Detective Zembrick wanted you to follow up on if an identification was made. And once it came to your knowledge that you made an identification, you asked those questions.
Yes.
Were these questions like written out for you, or did at some point, you've been doing this for 20 years, you could just kick in and you just ask the appropriate follow-up question?
If I recall, it was very, very, just only a couple questions and I did not write them down. I think I just went in there, did a quick interview, and I knew that Miss Canada had been interviewed prior, and I didn't want to, I didn't want to, my questioning was kind of vague on purpose because I don't know what she said back then. And her recollection was probably a little more.
Okay. I think at the beginning of your direct testimony, you informed us that you have been, at this point in time, a detective for a police officer in some capacity for 24 years.
Yes.
It's fair to assume that at some point in time, you actually have conducted one of these identification type procedures for your own cases, right?
Correct.
And certainly it would be pursuant to Illinois law and not Georgia law necessarily, but the interaction wasn't unfamiliar to you.
Correct.
In your cases, would it, when you have an identification being done, witness identifies a suspect, do you have them do anything with the actual photo they select, like such as sign it or make a marking on the actual photo?
In Illinois?
Yeah.
In Illinois, we do it digital. It's all on a computer, so it would be a keystroke.
Oh, okay.
And it is also audio and video recorded from the computer laptop that we used to
But
do
if
that.
I hit picture 5, I click something and that would create a digital mark that you were interviewing McBurney and McBurney.
Correct.
Okay.
So this is kind of Stone Age for you, going with paper.
Well, we did that for, I'd worked in investigations for 13 years total of my 24 years. And we did do the old school way years ago, but we've been doing this photo lineup way for over 7 years now.
Okay. During the ancient days when you would have used just paper and pen, what would have been the practice?
We called it a 6-pack. So we would actually put a photograph. It was a manila envelope with 6 square cutouts. We would compose our own photo lineup that way.
Okay, so would the 6 cutouts all be like on one page?
Yep.
That kind of 6-pack kind of thing?
So we would hand that to the person.
So probably what we more quickly assume when we like watch a TV show, they have a 6-pack lineup, that kind of thing, right?
Yeah, it's
okay.
exactly.
And on that kind of form, they would, back in the day, they would circle it or initial it or.
A little more relaxed. Some of us would have them signature right next to it.
Okay.
Circle it, signature. We did not video and audio record it at that time. So it was investigator or officer's discretion on how they wanted to have them show.
Okay. I believe that is all. Thank you.
Any redirect?
Just briefly, and if the court will permit, I'll just stay here because it's just one question.
Sure.
But if you want me to stand up, I will.
No. As long as observers can hear you and movies can hear you.
Sergeant Montiel, you indicated on cross-examination that previously when you all did use paper copies, I guess, of photographs, they were on one sheet and the witness would circle or initial, whatever
Yes.
officer desired. In this instance, when you presented the photos to the witness, did you take them out of the folders or leave them in and allow her to go through and open them up and pull them out?
I removed them from each individual 6 folders.
Did you pull them out in any particular order?
No.
That's all that I heard. Thank you.
Where in Illinois is Buffalo Grove?
I
mean, I know Chicago.
So Chicago is in Cook County.
Yeah.
I said Cook County, and and then Buffalo Grove's the south part is in Cook County, and then the north part is in Lake County, the neighboring county just north of Cook, which takes you up to Wisconsin. And
So
it's
if I were in Chicago and I hopped in the car, how long would it take to drive to get to your house?
if you're on the north side, it took me less than 30 minutes to get to O'Hare this morning, and O'Hare is in the city of Chicago. It's a close suburb.
We very much appreciate your scramble to get here. I know it was short notice, but this is an important matter, as I'm sure you understand. Trying is going to take a while to get closure on some of these things. So it gave an inconvenience, but appreciate the comity, the team between law enforcement agencies. Your cooperation.
You're welcome.
May Sergeant Montiel step down?
Yes, state has nothing further.
Okay, great. Thank you, sir.
Thank you.
Anything else, Ms. Love, in terms of evidence in the state?
No, Your Honor, that's all the state has.
Any evidence you want to present, Mr. Franklin? No. Okay. I'll have argument in just a moment. I need to get, is it, I want to make sure that I'm pronouncing it correctly. Monty? You go to the jury room, I'll meet you there.
Hey, how are you?
All right, we are back. Mr. Franklin, I'm happy to hear your argument as to why you think this identification ought to be suppressed.
Your Honor, I believe that the substance of my argument is best articulated by the examination of Detective Zembrick's testimony. Our biggest issue with the identification process coming into this was the photo lineup we felt suggested that a person select Mr. Hodges' photo over any of the others.
So not things that Montiel did. I watched the video, but it sounds like that was by the book. If the lineup is effectively pointing to someone.
Yeah, it's not so much the questions that Montiel asked, but if you put bad in, you get bad out. And Montiel was given bad, he administered what we would consider to be the bad lineup. Therefore, the procedure itself would have to be deemed bad as well. We believe that, of course, Neil B. Biggers factors should be at the forefront of this analysis. And we believe that at least 4 of those weigh heavily in the favor of defense counsel, of Mr. Hodges. Those things to be considered are the witness's certainty. There was no testimony as to whether she was 50% sure or 100% sure. We got into questioning about whether she felt she would be able to identify a suspect in either her 2018, 2019 conversation with Detective Zembrick. Her answer was yes. She felt that she would be able to identify someone.
But how
certain she was. She wasn't. That was not given. Also to be considered is the quality of view. We would think it's fair to characterize her perspective of view to be poor. It was 9:30 at night. She was some distance away, and it was of a person who she doesn't recall seeing before or having seen afterwards. At least until we get to this identification process where she then selects Mr. Hodges' photo. We would concede that on the amount of attention paid to the culprit of the crime, she at least was paying attention because she was outside. I'm not sure if we got into evidence on this, but I don't think it's an issue talking about it. She was outside waiting for the deceased to come outside, and then she just sees this commotion go on. And so, of course, something is going on, so she's gonna look and pay attention. We don't contest that she saw things going on. We are questioning her ability to see accurately what was going on and who was involved. The fourth factor is the agreement between the witness's description and the suspect. Mr. Hodges is very dark-skinned, in my opinion. I don't think there's anyone who would describe him as anything other than dark-skinned. But certainly conversations as to complexion are somewhat subjective. So we believe that she picked out a dark-skinned person in the lineup. We would contest certainly 4 of the photos are not people who we would consider to be dark-skinned in anybody's definition. There's a 5th person who's a bit darker than the other 4, but certainly no one who is as dark complected as Mr. Hodges is. To that extent, I will further point to the testimony offered by Detective Zembrick on cross-examination. He acknowledged that whether it was somewhat or substantial, that Mr. Hodges' photo itself of the body was darker than that of other people. He also acknowledged, and I didn't realize this until we actually got into the questioning, but the backgrounds on the original copy of the photo lineup were more substantial, were more prominent than on I think the court kind of referred to as the bleached version of what I had. So certainly if on my bleached copies, I was able to to see that, hey, I have an issue with these backgrounds, they would seem to be that my client is the only one who doesn't have a meaningful background behind him from these bleached copies. Then certainly on these better copies that were used in the original identification, Mr. Hodges stands out even more. So we have 2 reasons within this one lineup that he stands out more than the other 5 suspects. And his picture is the only one that's of a dark-skinned person without a background. So we believe that when the only information that the detective who composed the lineup had is that per the transcript, the description was of a very, very, 2 varies, very, very dark-skinned person, that this certainly was a suggestive lineup procedure. We would also point to the fact that it wasn't as if Detective Zembrick didn't have the opportunity to select other photos that would have alleviated some of these concerns that I'm articulating. Out of the hundreds, if not thousands of photos that would presumably be offered through this database where he types in age, sex, race, it's not clear what control he has over complexion in terms of what the database offers, but there gets to be a subjective point where, okay, I have this pool of people who are Black males who are 16, 17 years old. I now get to pick the ones that provide the fairest comparison. And we think that the officer did a poor job of doing that, again, for the reasons that I've articulated before. It is further compounded by the fact that I think it made total sense to not use a 2019 photo of Mr. Hodges or 2015 photo. It made sense to go back to 2007, 2008 and do so. And it being that the photo that he was able to find was of a person with a low haircut or a fade, so it made sense to use still photos of dark-skinned Black males with fades. However, as part of the investigation, if the person who at the point in time committed the crime had dreads, there should have been some investigation to make sure that the person who we are tagging this case to had dreads at some point in time or had gold teeth. We understand that hairstyles can change. My hairstyle has changed since the time that I came into your courtroom, right?
Ingrid have figured out if your client at some point had a different hairstyle than the one picture he was able to get.
You could check.
But I thought you just said, hey,
correct.
It's just a hairstyle and teeth and a picture you have of the person because of the fingerprint is that person. That's a different hairstyle and you can't tell if there's
yes. Subsequent photos, Facebook investigations, Instagram investigations. These are things that are common circa 2019.
Right.
Right.
But then they'd be looking at pictures of this.
Right.
It's a strange case because of the passage of time. Everything happened in 2019, but they had a picture that doesn't fit.
Yeah.
You can see, hey, let's get online, let's see if we got more images. Yeah, look, he's always got the braids and the dreads. This picture doesn't. They had one photo they were able to salvage from some other database that didn't have dreads. How, I'm curious how you expected them to do research as to what life was like, what he looked like 12 years earlier.
Yeah, so I think, again, I think the world is an oyster. It's a world of possibilities of what could have been done at that time. And maybe if he did every single thing I could possibly think of right now. I can think of when I go to conferences and they give you a rubber band and they say, hey, think of all the things you can do with this rubber band, right? And you think of millions of things you would never think of. I could probably always think of something that he didn't do. But the critical part of this part of the analysis, I think, is that he did not do anything. He didn't attempt to do anything to validate that this case from 12 years ago, that this is actually a guy who at some point in time would have done that. I understand, cold cases are inherently difficult for the obvious reasons, but I think some effort would have been given to, okay, I got this match. I got what I believe to be my guy. At some point in time, I can put somebody else on it. I can try to get old yearbook photos. I can see if he still has posts from 2007 on his Facebook or something. So that certainly isn't the crux of my argument. I'm not saying because he didn't do that, we should win. I'm saying that corroboration would be helpful at this point, being that, especially in my view, we arrived at this conclusion that at least after Mr. Hodges is indicted, that is largely based on this less than optimal identification. As it pertains to Detective Montiel, I think he testified to the best that he could, learning that he needs to come to Atlanta and remember this case from a few years back. He didn't recall being a part of these emails where Detective Zembrick made these offerings about the case that certainly would have been in Detective Zembrick's recollection and Detective Investigator Shipman's recollection. So I didn't want to beat him up on that because that wasn't the critical part. But we do know from Detective Zembrick that he said that Sergeant Montiel was in fact courtesy copied to these emails that would have been in the realm of what he should have known going into this process. So it wasn't as if Detective Montiel was sitting in his office working on another case, and somebody said, "Hey, come here, come do this for me right quick." There were conversations between Detective Zembrick and Montiel prior to. I don't want to be accusatory in terms of kind of what went on, but I think that Detective Montiel's assertion that Detective Zembrick was as vague as possible is not dishonest, but it's not as, it wasn't entirely vague, because we learned that there are follow-up questions that you have to ask. And, you know, you learned that there were 3 people involved. He told you that the person that he believed was in the lineup, which again is probably a common sense assumption at that point, that I'm not going to have you do a dummy lineup 12 years later. I certainly think that the officer who's been practicing as long as he has may just kind of arrive at that on his own. But nevertheless, I think that over assertion, if you will, certainly makes his credibility somewhat curious in terms of what the conversation would have been before. And part of that may be, it's not my case, it's 2 years ago, I can't tell you exactly what it was. But I think that as we move on to the other factors, we talked about the witness's certainty, the quality of view, the amount of attention paid to the perpetrator, the agreement between the description and the suspect. The last thing that we get to, and probably the largest thing, is this conversation about the tie between the crime and the identification. If I remember correctly, the incident date of the murder was March 16th, 2007. Her identification was January 3rd of 2019. So we are 2 months, 2 weeks short of 12 years. So well over 11 years between this 10 or 15, 20-second moment where she saw a guy at 9 o'clock at night in a commotion where a bunch of people are running, turn and shoot at her, the father of her children. She expresses a confidence that the other witness, Mr. Gooden, did not express. Mr. Gooden walked into he was closer to the ongoings of the robbery, murder, and he wasn't confident that he could say anything other than, yeah, the guy was dark. I think that it's fair to argue additionally that Miss Canada's clarity of, yes, I can identify this person 12 years later, would be affected by the fact that this wasn't just a random guy who got shot. It wasn't even quote unquote just her boyfriend. It was the father of her child. It's something that has been followed up on for some point in time. I believe that she would be the person who was the person who tried to make an identification in 2007, because there are only 2 witnesses to the case. The other being Mr. Gooden, who's, as we learned, his representation is, maybe I can't identify anybody else. So he certainly would give that testimony, that conversation later on, if he had the day of the event, tell the cops, hey, I just identified a guy. That leaves 1 person. And there are other circumstances around that, but we didn't get into that during the examination, so I won't go into it. But there's only 1 person who that 2007 identification could have been. And we would argue that either she was correct at that point in time, and therefore Mr. Hodges is certainly not the guy, or if she identified somebody in 2007 and it was the incorrect person, then that's even more reason to think that 11 plus years later that she's wrong again. So just there's certainly we will certainly be filing a motion in limine if we were not to be successful on this particular motion, based on just that set of facts. But I do believe that we have enough within the hearing of what we learned today to believe that the procedure of developing the lineup, using that lineup that suggests Mr. Hodges' photo, knowing that the only meaningful description that she had was very, very dark skin. I think under those circumstances, putting Mr. Hodges in that lineup was totally unfair to him and in violation of his constitutional rights.
All right. Thanks, sir. Ms. Love.
Thank you. Your Honor, the defendant argues that the photo arrays shown to Ms. Canada, and using Ms. Franklin's words, suggested that the defendant was the person. What the state argues now is that the defendant has failed to show that or point to anything that indicates that the lineup led the witness to a virtually inevitable identification of the defendant as the perpetrator and was the equivalent of the authorities telling the witness, this is our suspect. And that is what the Georgia Supreme Court has stated that the lineup has to do in order for it to be deemed impermissibly suggestive. And the court's review, the trial court's finding for an abuse of discretion. Here we have heard testimony that the lineup shown to witness Christine Canada, or at least the version of it that is admitted as State's Exhibit 2, was slightly different in shading from the one that even Mr. Franklin had. And the court is well aware that copies of copies tend to produce variations in shading. What Mr. Franklin attempted to elicit from the witness, but I contend he was not successful, is that the difference in the complexions of the filler photos and that of the defendant was so stark that it pointed to the inevitable conclusion that this is our guy. And in fact, most telling that that is not the case is the fact that Mr. Gooden was shown a photo array that contained 4 of the same fillers that the array shown to Miss Canada contained, along with the defendant's photograph, and he made no identification of anyone in those photographs as the person that he remembers seeing on the night that Mr. Buchanan was killed. The court in Thomas versus State 310, Georgia 579 at 584, and I will give to the court the case law that I cite. I printed copies and gave to Mr. Franklin, hard copies of them, and I will provide them to the court as well. The court permits me to approach. And I think that Thomas versus State, don't recall if it's on the top of that heap, but it's the one that I'm referring to. In Thomas versus State, the appellant contended that the officer told each eyewitness that the appearance of the people in the photographs might now be different if their weight, hairstyle, or facial hair had changed, and asked the witness to pay attention to facial features. He, as Sergeant Montiel indicated they now do, used a computer program to show the lineup of the suspects to the witness in that case. Here, the 6 photographs contained in each of the 2 lineups that were shown to the witness were substantially similar, even though the appellant complained that his photograph had different lighting than others. In Thomas, the records show that at least one of the other photographs in the array had lighting similar to the appellant's photograph. In our case, we heard testimony from former Detective Zembrick that while from the pictures that he looked at in State's Exhibit 2, it appeared that the defendant's photograph had no background. He also indicated that photograph number 2 was also appearing to be lacking in background, if you will. And I'll leave the photographs for the court to review. But I argue that the photographs, the differences in the background shading are not so stark as to point to the subject, that is the defendant, as being the suspect. It is not in any way the equivalent, even when coupled with the slight differences in complexion that the defendant may have from 3 or 4 others of the pictures indicated in the array. Even when coupled with that, none of that has been shown to be the equivalent of the authority saying this is our suspect. And therefore, the defendant has not shown that the array was so impermissibly suggestive as to lead the witness to the inevitable identification of the defendant as a perpetrator. Your Honor, the courts have consistently stated that if the photo array shown to the witness is not impermissibly suggestive as to lead to the conclusion that this is our suspect, then the court does not even reach the second part of the analysis, wherein you determine whether or not, considering a totality of the circumstance, there was a substantial likelihood of irreparable misidentification, which is what I believe Mr. Franklin's second half of his argument spoke to regarding the time of day, the amount of time that Ms. Canada had to look at the witness, and so forth. So we would ask that the court make its determination based on the lineup that has been presented and the testimony that has been presented. And the fact that even in asking Mr. former Detective Zembrick about his choices of photographs, what we get is Detective Zembrick saying he made an effort to find people of similar complexions. And it's worth noting that while Mr. Franklin, based on his questioning, would not have considered himself to be suitable to place in a lineup of dark-skinned males, Detective Zembrick, on the other hand, said, I would not put you in there. And so these slight shade variations don't rise to the level of inevitably pointing to the defendant as our guy or the person who committed this crime. Also in Newton versus State, NEWTON versus the State, 308 Georgia 863 at 866. It's a June 1st, 2020 Georgia Supreme Court case. In Newton, the defendant challenged the determination that a photo array was not impermissibly suggestive when, as he argued, his photograph differed significantly from the other photographs in the array. He stated that his photograph showed a more magnified close-up view of his face, bringing inordinate attention to his facial tattoos, that his skin tone was light in comparison with the other subjects, and that his clothing could not be seen at all, while the others were dressed differently. The Georgia Supreme Court noted that it was true that the photograph of the defendant looked different than the others, noting that it was a close-up shot, omitting the chin and the top of the head. However, the court did not find that even that aspect of the photograph invites the witnesses to pick out the defendant from the lineup. They noted that the cropped picture of the defendant's face appeared to be of poorer quality than most of the other photographs, which displayed all of the facial features, but found that another picture in the array also differed significantly from the other, showing a shirtless man from the waist up. The court also noted one could discern facial tattoos on the defendant's face in the photograph, but that they were not particularly clear. They ultimately concluded that looking at the array as a whole, that defendant's photograph did not jump out as that of the obvious suspect, and found that the trial court therefore did not abuse its discretion when it found that the array was not impermissibly suggestive. In our case, Your Honor, the defendant's face is situated virtually the same as the other filler photos. The complexions are very much alike, notwithstanding any shade variations that Mr. Franklin or myself or even Detective Zembrick is able to discern. There are no people in the photographs that have substantially different hairstyles. The defendant just doesn't jump out as being the one. He was asked, Detective Zimbrick, that is, was asked by Mr. Franklin why he didn't get, or if he remembered that the witnesses stated that the perpetrator may have had gold teeth or dreads. And Detective Zimbrick testified, well, this is the photograph I had, so I'm not going to put somebody with characteristics described of the shooter in an array with a defendant who has none of these photographs. That certainly would make him stand out. In Roseboro versus the state, 308 Georgia, 428 at 433, which is an April 6, 2020 case. In that particular instance, the defendant argued that the trial court erred by not suppressing a pretrial identification from a photo lineup. And in that, the defendant argued that the prosecutor had not read an admonition from the police prior to the witness reviewing photographs that were shown on a telephone. The defendant argued there were an insufficient amount of fillers in the phone's pictures, and that in the identification photograph, the defendant was the only individual fully framed in the center of the photo and making an obscene gesture. The court found that none of those circumstances amounted to an unduly suggestive lineup procedure in which the prosecutor led the witness to a virtually inevitable identification of that defendant as the perpetrator. The court found that they have even held that the failure to read an admonition form, or the fact that a defendant may appear in multiple photos or be in a different position than other individuals in a photo, does not constitute an impermissibly suggestive lineup. In our case, the witnesses both testified that the photo lineup admonition contained instructions to the witness to not pay any attention to things like complexion, and noted that skin tones and hairstyles and things of that may be different. Don't pay any attention to those things. And in this case, our admonition was read to the defendant, to the witness. So therefore, that further lends support to the state's position that the witness was instructed to not pay any attention to skin tones, as they could be depicted differently than what she recalls seeing. Finally, in Westbrook versus the state, 308 Georgia 92 at 98. There, the appellate contended that the trial court erred in failing to suppress a pretrial identification on him because he had a tattoo on his forehead, a teardrop tattoo under his eye, and small piercings. The court noted that in order to make the photographs alike, the detective placed a dot over where the tattoos would appear, but did not cover up the two small piercings by each eye of the defendant, where no other filler photo had that feature. In this case, the court found that viewed as a whole, especially considering that the 6 lineup photographs were substantially similar, they could not say that the lineup led the witness to a virtually inevitable identification of that defendant as a perpetrator. And it was not the equivalent of the authorities telling the witness, this is our suspect. We have heard no testimony that Miss Canada was at any time advised that it would be the shooter in the photographs. What we have heard no testimony, in fact, testimony to the contrary was elicited, that the officer who was administering the lineup didn't even know who that defendant was, or who the person inside those photographs it was that the state of Georgia was looking at as a suspect, and therefore could not convey that information to the witness. Detective Zimbrick stated that he spoke with Miss Canada before he even put together the array, so there is no testimony. And in fact, the defendant has failed to show that anyone stated something to the witness that would give her the impression that this is our guy. So given that the shade variations of the background and the shade variations in complexion are so slight, we would ask that the court deny the defendant's motion to suppress, stopping at the analysis of whether or not the photo array was so impermissibly suggestive as to lead to the inevitable conclusion that this is our suspect. and not even reach whether or not the identification of the witness led to an irreparable misidentification, if you will, the second part of the analysis. Thank you, Your Honor.
Thank you. Mr. Franklin, anything you want to say about or?
Very brief. So Ms. Love made the, and can you hear me fine, Ms. Rivers? Ms. Love made the point as if it were to support the validity of the lineup that Mr. Gooding was shown basically the same lineup, right? The problem is that at no point in time did Mr. Gooding ever give any indication that he will ever be able to identify anybody else. He said before Detective Zimbrick and whoever accompanied him to Alabama, I'm probably not going to be able to identify him. He never gave a description other than it was dark skin, because he was the closest person to the place and he was running for his life as soon as he realized what was going on. So he paid no attention to anything. So therefore, there's no reason to think that the person who said, I'm not going to be able to make an identification is going to be able to make an identification. Compared with Miss Canada, who, as I stated earlier, is motivated to find someone and who internally believes that she can identify someone. I don't think she's out to get Mr. Hodges per se. She doesn't know him. But she received a phone call 12 years later from an officer who said, and he had compiled at this point in time, this was late December when he compiled the lineup, I have developed information. Based on that information, I need for you to do a lineup. That doesn't say that it's going to be this particular guy, certainly, but it does tell her that the person who this officer, Detective Zimmer, believe I have developed as a suspect in your case is one among these 6 people that I'm sending for you to evaluate. Which then brings us, which is why the importance of her description being very, very dark is so critical. Because if you give her these photos and the only meaningful thing that she had, because again, hair can change, depending on what kind of gold teeth you got, you can pull them out. Theoretically, that could happen, right? Although most golds don't pull out, those have to be platinum most oftentimes, but that's a different thing for the court. Right. However, if I tell you that I developed a suspect and your recollection from 12 years ago, and I know it because he said her testimony her interview stuff was consistent with what she had said before. If I know that the person you believe did it is very, very dark skinned, that makes his composition of this lineup irresponsible. If I didn't use the magic words earlier, it was inevitable that the only very, very dark skinned person in that lineup was Mr. Hodges. If you sat me next to Ms. Love, someone may say, you're darker than Ms. Love. I do think that the potential for cross-racial identification type things played some of a role in this. Certainly a white person may, you have a really light black person, or other than that, you're a black person, you're dark. And I think that the fact that the description is being given by a black woman of a dark, very, very dark person, again, is something that can't be removed from this case. There was no other choice for a black person to say very, very dark. There's always no choice. However, again, she's coming into it knowing that the person who has been developed, whether he said got fingerprints or whether he just really said they've been developed, is in this lineup. And I want you to see if the person that I've developed is in this lineup, who will be the suspect. I don't want us to be too cute for our ability to kind of finesse things legally, to forget that it's not legal minds who are assessing these things, it's common people. You're giving this to a common person under these circumstances, it's inevitable that Mr. Hodges would have been the person. So we'll leave it at that.
Thank you. Mr. Hodges, I will enter an order after I
review the evidence to include watching the session that Montiel has with Ms. Canada. That order will get to Mr. Franklin, Sheriff Duke, and then we'll be ready to go with the trial or whatever based on how I rule. My ruling won't mean no trial or yes trial. Well, Mr. Franklin now here's what's coming in. Well, Ms. Bug now here's what's coming in, not coming in. And then when you and Mr. Franklin are ready to get added to cases for trial, we will add to cases ready for trial. Is love anything else?
No, that's it.
All right, thank you for everyone here. Mr. Franklin, thank you for your patience. Thank you for your patience.
And thank you for.
I need to make sure it's either 1 through 4 are right there in this river so I can get them all. Everything's there?
Yes, Your Honor.
Great. Thanks. All right, we'll go off the record for a minute. Thank you, Mr. Shepherd, for being patient for your 1:30 hearing. I'm going to give Ms. Rivers a break, but why don't you tell me what you understand is happening now? I think Ms. Hall's in the jury room, but you give me a preview. Are we going forward with a motion?
But off the record, I don't think this is a who done it, it's a why done it. And my client's law minister who knows exactly everything that's led up to, that. So we're gonna try.
Here's this all.
We're gonna try and non-negotiate. Figure that out.
Okay.
I think those successful, my understanding is there's only one motion that's going to require testimony. The other motion is there is no statement, there was no evidence recovered, but we do have a photo ID.
So it's a motion to suppress identification. That's what we're going with that. Have you had an officer sort of looking around? Okay. Do you want to see if the plea goes forward or if the plea doesn't have a different day?
Probably keep out here, I don't think this is.
Okay.
The test was to be like 10 minutes.
Okay. Yeah, so why don't we're gonna let Ms. Rivers decompress a bit and then we'll see if the non-negotiated plea works. If that doesn't work, then we'll do the hearing.
Thank you.
All right.
Really?
Yeah, even Cassie's like, what's going on? But my understanding is an older murder case.
It was supposed to be yesterday, but the state managed to get someone in from Illinois, so we had to wedge it in between this morning stuff and this afternoon.
I got to talk to him for a while. He's been very nice.
All right.
And he was desperate to make his 4:30 flight. Yeah, the young lady showed up and he was on his way to the airport. He had a 4:30 flight, so.
I would hope that the agency would help him.
Oh, no.
Sure.
I do that. It's on us.
Point being is we didn't mind letting him go first because he obviously needed to get his flight. Yeah, my understanding, this is like an old case. Yeah. Oh, is that?
Thank you, Judge, for your
I just got a
indulgence and thank you, Mr. Franklin.
An 07 murder. No problem. Is there something I'm supposed to be looking at now, or do we go back to Ms. Niles? I'll go back there now.
I think it was back.
Okay, I'll go get it.
Okay. My brother,
No, I can take a break from that here.
okay. He's actually gonna look at something for it.
Because I was trying to pop, because I'm trying to come up. I guess I'm like, have to maybe see.
Just based on the rating. He would be brown.
So I mean, it's 2 questions, right? But I kind of beat up on that, like, picking out some nonsense, but like, I mean, he's a person, they may not have something. There's so much color in the black community. It's to who's a bad shit, right? Like,
Right, and that's why I prefer food, milk chocolate, dark chocolate, but I mean, yeah, I would do him, and him. He would be more brown. He'd be brown bordering on dark.
Because the other half of it is that I can be like, I can look at a picture, even if the shade is red. I can look at a picture and be like,
but this
so it's like if the picture is dark, you can tell that he's more chocolate. I'm trying to black.
No, he's not. Literally, he's not. Did y'all see his client? Y'all saw his client. This dude was not. This dude was not.
Yeah, because of black.
He's like milk chocolate. Do y'all agree? He was what?
He's a little tall. He's a little tall.
He was a little dusty.
He's darker than, my client is darker than him.
He didn't appear darker than you to me. He appeared dusty. Like you had some red undertones. He just appeared.
So like if someone comes in and says, hey,
huh?
If the only thing the person remember, like 12 years ago, is what you remember is the person is very, very dark. What's it going to And see, and my conviction about it is based on the thing I asked other folks in my office. I didn't say nothing but like, okay, I got a line up. The description is very, very dark, dread to gold teeth. Right? So who would you pick if you quote unquote had to pick? Now I know the have to pick is not the absolute standard, of course. Every little five people pick.
But if they did it like she did it, and we were watching them,
Then you going brown.
No, I mean, she stopped at another before she told you not, and then she actually put them together.
You put whatever order.
Yeah, but no, if I was that, like, he's dark, he's dark, but he's probably green. I like, he might be dark. That's how I would go. Hi.
Good.
And then I see where you put, but he just.
I mean, so the argument I think you have making this, he's as dark as the other one, but the photo is dark, right? Like he's dark, but it's also appears dark because it's a dark photo, a dark person, versus the argument being this is a fair photo. That's the argument. Right?
Yeah, it's like the shade. Like,
I think my whole life, I always consider myself like definition on the darker side. But again, it's shade. I've never been thought about it. You know what I'm saying? Like, so somebody was to say the person who did it was 6 foot, 300 pounds, dark skin. I would be like, 6 foot, 300. Don't call me brown.
I've been considered brown. I've had some people inexplicably to me say, "Oh no, you're like," and I'm like, I'm just not. You just see.
I said peanut butter.
Peanut butter is not right. Peanut butter is not right. Peanut lemon is like, I go with the caramel.
Look, so when we talking about you have red bones, you have light skin, you have brown, you have dark,
I don't know.
Yeah, like I mean, again, because it's different for everybody.
It is.
But when you get to the point of her saying very, very dark, he's very, very dark. He's very, very dark. Nobody would.
And he could be considered. That could be a light kid.
Look, that dude said that so people put me in mind. You just trying to get somebody arrested.
No, damn it, it's serious. People would. I mean, people don't. Everyone doesn't even consider like.
It's a question Michael didn't have to consider unless you're doing this kind of thing. Right?
I heard somebody say, she ain't like it's a thing, like it's a thing, like I want to be. That's what they were saying.
Just like the way you said that thing.
Yeah, and it's like should be lighter. Yeah, like you gotta be even lighter to be cute or whatever it is that she's trying to say. So like basically she's saying, no, it's a lot, it can be a lot lighter than that. She's in there there. So, I've actually walked into like Publix, so they've got the surveillance camera, you can see yourself walking in. I walked in and on the camera didn't recognize it was me walking in because it looked like a big old, just a light, just a little, you know.
I mean, let me ask you this, right? I get what you're saying, that you say follow someone.
No, yeah, or that's too washed out, that's not. Like, or that picture's much slighter than that.
If you're building a line off of very, very dark, you.
I would put him in.
Knowing that this is what you have to do this.
Oh, not
You have to do this.
I'll put him in.
But again,
I'll put him in.
You have thousands of people.
Very, very dark.
You have thousands of people you can use, right? To make sure you're, again, because you gotta deal with people like me.
Right.
You know, you want like,
But I would.
a 12-year-old identification, you know it's gonna be emotionally suppressed when you put this in the game. You got thousands of photos of Facebook. Them shit got no business being no one. I could almost be your passport. You straight different. He got someone on his cheeks.
Literally like, literally, you can tell it's like all like the cocky. And this, it just, yeah.
One for the fact that like I will make motion anyway, because the number of convictions I have on it, that is 5 people. And we did it on our computers, they actually were scrolling one by one through.
Yeah.
And that's what it was like, they came back. All I said was.
You loaded the question.
No, I'm like, if you pick one, who would you pick? Because I mean, at that point, it was, identification was done, you know what I'm saying?
Yes.
So that's why I had the case. So I'm trying to see how other people may approach it from this over analytical way we approach it.
You're still online.
And these were admins.
Hello.
That's your own.
It's definitely your.
Hey, Alana.
If it makes, you guys are still online.
We can hear everything she's saying.
Oh yeah, it's cool. Oh, well, for y'all, got you. They were saying that they could hear everything you say. She ain't saying nothing.
I didn't see anything inappropriate. It's still live on YouTube.
It's cool.
Thank you for letting me know that.
It's still live on YouTube.
Thank you all.
Question is anybody actually watching on YouTube? Because it was a room full of people today.
Watching, yeah. Right. Okay.
Okay, I'm coming out.
All right, thank you all. Thank you.
Is that yours?
I think that's yes. Forget
Oh, yeah. Hey, would you guys? You do? Okay, sorry. No.
Got a card for me or not? No more cards? You are.
You're welcome.
Sorry, that was my fault. Hey. Doing well. Okay. Okay. What we know today is real late. I'm gonna give you the first one here. I can get y'all a table with the here. So when the judge asks you to wait, you can move short. What I say? We're not gonna show them stuff. It's gonna make it out. It's going on. In short answers, I'm trying to stay on the top of the questions. Try to stay all of the questions. And the areas in the syndrome, it's almost 4 points. 3, 4, so. Okay. And if we don't get successful, then we got emotions here after that. So just really short answer, okay? Okay. No, one more thing. No, that's not it.
You know what? This is my first time being recorded. I talked for 3 years. Oh my God. Single service? He brought it up. Oh, yeah, you guys are gonna be for this. Oh, okay. Now? Now. That's your, oh, that's mine. Oh,
So are y'all really starting a trial tomorrow? Karen, are y'all really starting a trial tomorrow? Oh, tomorrow. Okay. Yes.
I do want to be clear because the judge has no evidence. You know, there's evidence, but there's no evidence. Physical, other than the shell casing, eyewitnesses, that kind of evidence.
But no evidence recovered from my defendant.
No, right. I just wanted to be, I thought when you said no.
No,
evidence, I
there's
was like,
plenty of
what?
evidence. What I meant is that there's no evidence to be suppressed. Because all we had was a search incident to arrest.
Yeah.
And they didn't find a gun.
Right.
Sometimes they do.
Yeah, and drugs.
Yeah, the guy just killed somebody and 2 weeks later, he's still carrying the gun.
Yeah. Crazy.
Throw it in a river, bro. I mean, seriously. Yeah. No, if there was no evidence, we wouldn't be fleeing.
Listen, when you said that, I was like, no evidence to be suppressed. If you gonna pull fast, you start talking. I got you. On Saturday, that's what we got.
No, hey, I'm all for that. I just wanted to make sure you had a chance to, if you do one thing, I'll be right back.
Just outside of cool.
Detective McKesey? Yes, sir. So, you came with lots of stuff. I can do one of the things now. You can wait till after we do this next thing. If you want to come back and get everything tomorrow, package, you tell me what works. You want to stick around? Okay, then why don't I just hold on to everything? Because if you're gonna stick around, I'll do it all at once. But if you want to take this and go and come back tomorrow, this will take a little while. This I'm done.
What do you prefer, sir? I don't want to hold you up neither, with your time and pressure.
It's up, I'm here. So I will turn to yours. I can't turn to these right now. I need to handle the matter that the lawyers are here. So if you want to take this one and go, we can do that. Or if you want to sit tight, when they're done, I will turn to this.
I have to get started tomorrow.
Okay, so you need to take it today.
Yes, sir.
All right, not a problem. Okay, so Mr. Shepherd, you would like me to bring Mr. Miller out here and we're gonna do a non-negotiated plea. Is that still the plan?
Yeah, we're gonna try.
Okay.
So. we'll see what the
Are
court is.
we apart by decades or?
We're apart by 8 years.
Okay, well, I'm here to try it. We'll see what happens.
So I guess the decade would be 10 years.
Yeah, close to a decade, but that's singular.
Yes. Yes, it is single.
Already in the news that the spot shooter was indicted. Left it this morning.
Oh, it was, that's right, you're presiding.
Yeah, it's not my case.
So who gets him first? You or Cherokee?
Pardon me?
Who gets him first? Us or Cherokee?
You've been indicted.
Oh, you hope we get. We have enough drama in this building.
All right, so you ready? This is our afternoon motions calendar. State versus Mr. Miller. Ms. Hall represents the state. Mr. Shepherd represents Mr. Miller. Good afternoon, Mr. Miller.
Good afternoon, sir. How you doing?
I'm okay. How are you doing?
Not so well.
I'm sorry to hear that. I know you're in a complicated situation. Mr. Shepherd tells me that you would like to attempt what we call a non-negotiated plea, where you're going to enter tentatively a guilty plea. Mr. Shepherd's going to tell me why he thinks I should sentence you one way. State doesn't agree with that. They're going to recommend something different. And I'm going to let you know, based on what I've learned from everyone here, about you and your case, which is limited. It will be just what the lawyers and you can tell me what I think an appropriate sentence is. If the sentence that I think is appropriate is more than what Mr. Shepherd asked for, you and Mr. Shepherd can talk. And if you want to withdraw your plea, you're able to do that. No questions asked, don't hurt my feelings. So I'm making the numbers up, but if Mr. Shepherd recommends 2 years to serve or 4, and Ms. Hall recommends 10 years to serve, and I say something that's more than 4, whether it's 10 or more, or if it's more than 4, you and Mr. Shepherd can talk about whether you want to take that because it's certain. No question marks, it's not a jury, it's not going to learn more, and maybe it could be 25 years. But you also can say, no, I don't want to do that, in which case I think we'll pop right into a hearing on a motion to suppress identification. You were kicked out of the lineup or some way or another. You were identified through a photo, and the Shepherd filed a motion to suppress that. You've got the witness we need to do that, and we'll have that hearing. And I'll let you know what I'm going to do with that. Okay? Okay. Does that work for you? Yes, sir. Okay. Then what's going to happen is Ms. Hall's going to put you under oath in just a minute. And you're going to need to answer a bunch of questions from her, from me, and we'll take it from there. When you're ready, Ms. Hall. You're welcome.
Mr. Miller, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before the court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
DeMoco Device Miller.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
On medicine.
You
High
taking
blood
medicine?
pressure. Trying to think of the name of the medicine they've been giving me.
So you take the names don't matter so much as what they're for and how they make you feel. So you take some medicine for high blood pressure.
Yes.
And what else do you take medicine for?
Really deal with my anxiety.
Anxiety medicine. Okay.
And depression.
Pardon me?
And my depression.
Depression. So something to help with anxiety, something to help with depression. And The blood pressure.
high blood pressure, and high cholesterol.
And high cholesterol.
Yes, sir.
Okay. Do you take that in the morning or at night, or both?
Both.
Did you get it this morning?
Yes, sir.
When you get the medication, does it help you stay calm and think straight, or does it make you jumpy and hard?
Made me stay calm, be straight, and stay focused.
Well, if at any time while we're talking this afternoon, you're not feeling focused, let us know, so we can slow things down, or maybe bring it back on another day. But it sounds like the medication helps you stay focused and think straight. Is that fair?
Yes, sir.
Okay.
Also, I need to point out that my client informed me that he does have mental health diagnosis, and there's a medicine that they're not giving him at the jail for post something, what, you have post-stress disorder?
Post-stress, they're probably giving me gossiping, and I forgot the name of the other. I can't think of the name of it. They're not giving it.
Okay.
So he does have mental health issues, but he told me that the absence of those medicines does not impact his ability to understand the proceedings, but he does have mental health diagnosis for post-stress disorder and depression, and what was the other one? Anxiety?
It sounds like you give medication for anxiety and depression, but maybe the third thing.
I'm not
getting
getting
medicine for.
Cause they say it costs too much.
Okay. But the fact that you're not getting it is not a good thing, but it doesn't make you unable to understand what's going on.
No, it just like balance the other two out. It make me like mellow. Like I don't get angry quick or get upset. Or I think about stuff and I might start crying. It just like keep me mellow.
Yeah. And that, so that medicine that keeps him from getting angry quick is gonna come into play later.
Okay. So we're gonna go forward with Mr. Miller. If at any time you're not following what's going on, or you feel like you're losing focus, let me know and we'll see what we can do.
Yes, sir.
Ms. Miller, how old are you?
45.
And how far have you gone in school?
I completed 12th grade year. I completed my 12th grade year.
Did you complete it with a high school diploma?
Yes, ma'am. Special education and learning disability education.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 1 count of aggravated assault with a deadly weapon, 1 count of possession of a firearm during the commission of a felony, and 1 count of possession of firearm by a convicted felon?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Some of it, not all of it.
Do you need more time to discuss this case with your attorney?
Really, I do it. I discuss it. I tried to discuss it with him earlier. We didn't have enough time, but he gave me basically what's going on. But I move forward.
You're comfortable moving forward right now. We could always use more time to talk about things, but you feel like you've spoken with Mr. Shepherd enough that you're okay going forward.
Yes. Okay, go on.
Yes, okay, if you change your mind, let me know, but for now, we're going forward.
Counsel, do you waive formal reading of the indictment?
We so waive.
Do you waive any defects in the indictment, including with respect to the defendant's name?
Also waive for the purpose of this attempted plea.
And do you waive moving forward on a copy of the indictment?
So waived.
One moment, Your Honor. Mr. Miller, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
He said that the maximum I can get is 30 years.
I'm gonna go down each one. The minimum and maximum for the aggravated assault with a deadly weapon is 1 to 20 years to serve. The minimum and maximum for the possession of firearm by a convicted felon is 1 to 10 years to serve. And the max
Ms. Hall. Hello? Hello, Ms. Hall? Can you hear me?